This trial is in the matter of case number CFI 056-2022 and is being held by way of video conference before His Excellency Deputy Chief Justice Ali Al-Madhani. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by JMR Solicitors and the lead counsel is Ms. Mariam Razak. The defendant is represented by MB Kemp, Middle East LLP, and the lead counsel is Mr. Salah Mato. Will the judge and the party's representative please confirm that the situation is as I have stated?
Confirm that's right.
We confirm what you said is correct.
Thank you.
Thank you very much, Said. Welcome you again. Good morning to you.
Good morning, Your Excellency.
And to everyone who's listening to us at this public hearing. Yeah, if there is any matter of housekeeping, and if you would like to raise, or we just need to discuss maybe the schedule of this hearing, and then we kick off.
Not as far as I'm aware, Your Excellency. I don't know whether my learned friend has any housekeeping issues.
Nothing from our end, Your Excellency. I think we can commence the trial based on the not in a normal course of action. So yeah.
So you stick to our agreement during the pre-trial review.
That's right.
So Mr. Razak would go with opening submission, followed by you, Mr. Mato. Then we take the witnesses in the new order, which is we take the second witness first. Is that right?
That's
yes,
right,
Your Excellency. I think the second witness is in Canada, and it's 3 in the morning there, if I'm not wrong.
Oh, okay. So he will be deferred to be the last one, isn't it?
I don't think it matters either way, Your Excellency. The second witness is present, and I don't think he has any preference as to whether he goes first or second.
Maybe he want to go to bed after he want to grapple with this, and he want to go to bed instead of keep waiting. Well, and would hear from Mr. Mato how he would like to deal with the witnesses. Like, would you be comfortable, like all the witnesses, I mean, appearing the cross-examination, or one in turn, or while the others is away from, and then they don't get into this call unless they are called? We have different way of dealing with the witnesses, of course. Would you be cross-examining Mr. Ajay as well, Mr. Razak?
Yes, that's right, Your Excellency.
Yeah. So, Mr. Mato, any insight?
I have no preferences, Your Excellency. I think I'd prepared that I would be cross-examining Mr. Farouk first and then Mr. Khan, but I'm either way. I'm agnostic about the order in which they will be cross-examined. So unless my learned friend has any preferences, we are fine with going with what they had suggested previously.
I have no preferences.
So in that case, we will go first with Mr. Farouk and then Mr. Khan.
Absolutely.
Okay, I don't mind. So we take Mr. Farouk first. Mr. Khan, we finish with Mr. Sethi toward the end.
That's fine, Your Excellency. Thank you.
That's fine. Mr. Razak, the mic is yours.
Thank you. Thank you, Your Excellency. Good morning again. The matter before the court today, as my respected registrar has pointed out, I represent the claimant, Fursa Consulting. My learned friend, Mr. Salah Matu of MB Kemp Law, represents the defendant in this matter, namely Mr. Ajay Sethi. Your Excellency, today we come before you to address a very simple issue, which is of utmost importance in this case. The simple issue is whether under the engagement letter, which constituted an agreement between the parties dated 7th of January, which was constituted between the claimant and the defendant, whether the defendant is obliged to pay a success fee of 966 UAE dirhams to the claimant upon the signing of the facility offer letter dated the 22nd of March between Emirates MBD and the defendant. As you are aware, Your Excellency, at the heart of any legal system, and particularly in accordance with common law principles, lies the fundamental principle that a contract is a sacred agreement between parties that must be upheld. Our client, the claimant, entered into a contract with the defendant, placing its trust into a contract with the defendant, placing its trust in the defendant's promise to fulfill its obligations. Regrettably, the defendant has failed to honour its commitment, and it is our duty to seek justice on behalf of our client. Furthermore, Your Excellency, contracts are the backbone of commerce, providing the foundation for business transactions and fostering trust amongst parties. They create a sense of security and certainty, enabling businesses and individuals to plan and engage in economic activities with confidence. In the matter before us, Your Excellency, our client entered into a valid and enforceable contract by way of an engagement letter dated 7th of January 2022 with the defendant. The document embodies mutual promises and responsibilities on the part of the claimant, namely in clause 2.2. The claimant's position is that a successful transaction occurred as the defendant accepted and signed the facility offer letter. A 2% success fee was therefore payable to the claimant within 30 days of the signing of the facility letter or drawdown, whichever came earlier. It is the defendant's position that the offer letter was a prerequisite and subject to further conditions precedent, and the contract would only be complete once the requisite conditions had been met. It is our case, Your Excellency, that our client fulfilled their obligations in good faith, yet the defendant has brazenly breached its contractual duties. The evidence you will hear and see today, Your Excellency, will clearly demonstrate that the defendant's actions represent a clear violation of the contract. Through the oral witness evidence of the claimant's documentation and expert analysis, we will unveil a trail of breach promises and broken obligations that have resulted in significant harm and financial loss for our client. We will establish that the defendant failed to fulfill their end of the agreement, neglecting their responsibilities and causing irreparable damage to our client's business operations and reputation. Moreover, we will present witnesses who will attest to the validity and enforceability of the contract, leaving no doubt that the terms were explicit, fair, and agreed upon, but willingly by both parties. We will also demonstrate that our client performed their obligations diligently, meeting all requirements set forth in the contract, while the defendant callously disregarded their commitments, showing a blatant disregard for the legal and ethical obligations of contractual agreements. Your Excellency, as you are aware, the law is unequivocal when it comes to breaches of contract. The law and the leading authorities are contained within the claimant's and the defendant's skeleton arguments. If it is helpful to the court, I'm happy to make legal submissions at this stage. However, for the assistance of the court and Your Excellency, perhaps I can suggest that if Your Excellency is minded to gear yourself that way, to hear legal submissions, given the fact that written closing statements have been agreed to be submitted, you do so once evidence has been heard from the parties. We trust that the evidence we present will leave no doubt in your mind that the defendant has unequivocally breached its contractual obligations, causing our client undue hardship and financial loss. Throughout this trial, we will present compelling evidence and an analysis of the facts, all of which support our assertion that the defendant is liable for the damages suffered by our client. We urge you today, Your Excellency, to carefully consider the evidence presented, applying your sense of fairness and justice to render a judgment that upholds the sanctity of contracts and ensures accountability for the defendant's breach. Thank you for your time, Your Excellency. Unless you have any further questions, that concludes the claimant's opening statement and an introduction to the matter before us today.
Thank you, Mr. Razak. I'm sure I would hear from you more after the dealing with the evidence.
Thank you.
Or
Thank you,
at
Your
least in a
Excellency.
written submission.
Thank you.
Mr. Mato?
Your Excellency, on behalf of the defendant, I would like to first give a brief introduction of the defendant. Defendant is a businessman based in Dubai for over 30 years and is the chairman of Channel 2 Group Corporation MFZ LLE, which is based in UAE. The defendant entered into an engagement letter with the claimant on 7th of January 2022. It was a series of engagement letters they had entered into for the sake of restructuring of the debt that he had at that time, post-COVID, and for acquiring 49 apartments in Fursa Heights in Dubai. So essentially, the purpose of the engagement letter was to restructure the debt, provide financing for the sake of acquisition, and to get working capital for the Channel 2 Group Corporation. That is the commercial context in which this engagement letter was entered into, which is very important. The purpose of this engagement letter, the agreement, was for the claimant to help the defendant get this financing. It is important for the court to be minded that this was the purpose, the commercial purpose. And the debt facility that is explained in this is the debt facility that is the crux of the engagement. Further, the engagement letter provides that the scope of works of the claimant is very broad. It goes beyond what my learned friend said in her opening statement. It includes assistance by the claimant in negotiating and concluding the mandate with the banks. In this particular engagement letter, the claimant was exclusively given mandate to seek financing from Emirates Islamic Bank, and at a later date, when they were unable to seek financing from the Emirates Islamic Bank, then they sought approval to seek financing from Emirates NBD, another bank in UAE. And the structure of the fees was as follows. Once the bank would provide a debt facility, which will enable the claimant, sorry, the defendant, I beg your pardon, the defendant to restructure their debt, buy, acquire real estate, 49 apartments in Fursa Heights, and if possible, provide working capital facility to the group Channel 2 Group Corporation, which will result in an approved and sanctioned debt facility by a bank. So an approved and sanctioned debt facility by a bank, which will allow the defendant to draw down and fulfill the purpose of the engagement. At that point, they will be entitled to 2% success fees. So success fees are to be provided once the debt facility is sanctioned and approved and sanctioned by the bank, which means they are capable of being drawn down by the claimant, by the defendant. The defendant, Your Excellency, I must point out, was in considerable financial difficulty before entering into this engagement letter. It was known to the claimant, and that's why he was seeking a facility. If he had 1 million dirhams to give for the sake of just basic assistance, a offer letter which is not a binding contract, surely he would have not needed any facility. I'm not going to repeat what my learned friend has suggested is the case of the claimant. Your Excellency by now would have seen what the case of the claimant is. But essentially, Your Excellency, the court has to determine two following issues in this matter. This is a simple and straightforward matter. I do agree with my learned friend on that point. The first point is whether the project facility, i.e. the debt facility, was approved and sanctioned by ENBD under the facility letter issued by ENBD on 12th of March 2022. And in light of the facility letter issued by ENBD, whether a success fee of 2% is payable under clause 2, subsection 2 of the engagement letter. The defendant's position is that the issues before the court require interpretation of clause 2.2 of the engagement letter and view it in the context of agreement as a whole and the nature of the facility letter that was offered to the defendant. We say that success fee under the agreement, i.e. the engagement letter, would only be payable to the claimant once the funds were approved, sanctioned, and capable of being drawn down by the defendant. Otherwise, the commercial purpose of the debt facility would not be met. There would be no reason for any success fees to be paid. Further, the facility agreement referred to, facility letter referred to in clause 2.2 was a debt facility, which was envisaged by the parties to allow defendant to immediately draw down the funds. So there was no ambiguity in it. It was straightforward. Further, the facility letter that was issued by ENBD was subject to a number of conditions precedent, which was set out in the Schedule 1 of the facility letter. So essentially, at the time when the facility letter was issued, the bank was still trying to ascertain the creditworthiness of the defendant, whether it should offer it a approved and sanctioned facility. So there was something further to be done, investigated, and then they would basically offer a facility which would be capable of being drawn down. As a result, we say that the amount of success fee payable at the time of signing of the facility letter was zero, because no debt facility had been sanctioned by the bank at that point. So 2% of zero, we say, equals to zero based on that fact. Defendant's position is further bolstered, Your Excellency, by the fact that the facility letter was signed, and after that point, the claimant could have said, that is all we had to do, and here's our invoice, and you pay us in 30 days. But they did not stop there. They continued to liaise between the bank, i.e. ENBD, and the defendant, and the claimant continued to be the primary channel by way of which the conditions precedent were being fulfilled. So claimant's overarching task was to get ENB to sanction and release the debt facility, i.e. approve it, so that they would, our client would fulfill the commercial purpose of the debt facility and they would be entitled to a success fee. Defendant, we say, fulfilled, Your Excellency, all the conditions precedent in the facility letter. But the way the facility letter, you will see, Your Excellency, was designed, it was not an exhaustive list of condition precedent. They could ask for any amount of conditions precedent until they were satisfied of the creditworthiness of the defendant, which was a necessary condition for them to issue a facility which would be capable of being drawn down. And until the very end, ENBD continued to ask for documents which were beyond what were set out in the facility letter. So in view of the above, Your Excellency, by way of conclusion, the defendant's opening submissions by way of summary as follows. The claimant was expressly and exclusively given a mandate to get an approved and sanctioned debt facility, which would be capable of drawdown, and which will enable the defendant to fulfill its commercial purpose of the engagement. The facility letter issued by ENBD contained a long list of conditions precedent, and which were necessary conditions for there to be an approved facility. So in essence, it was a conditional contract which was not yet binding. It will become binding once the bank would be satisfied of the fact that yes, the defendant was creditworthy enough to get 46 million dirham as a loan. So in view of the foregoing, a successful transaction had not happened because ENBD did not actually sanction or make available the debt facility that could be capable of being drawn down. And essentially, Your Excellency, successful transaction would mean that the defendant would be able to restructure the debt, acquire properties as suggested, and potentially, if possible, which was not the case in the facility letter, they also wanted to seek working capital facility. However, as per the terms of the engagement letter, no success fee was therefore payable to the claimant at the time of signing of the facility letter. Furthermore, we also submit that the agreement was automatically terminated, agreement being the engagement letter, 7th January 2022, was automatically terminated as the claimant was unable to achieve financial close of the transaction in question within a period of 90 days from the signing of the agreement. Accordingly, Your Excellency, we will invite the court, after reviewing all the evidence, hearing all the evidence, and hearing, and if so needed, legal submissions, that the court orders dismissal of the claimant's claims in its entirety, and so on, as we have requested. With that, Your Excellency, I complete my opening submissions, and unless you have any further questions, that's all I have to say at this point.
Well, thank you very much, Mr. Mato. Thank you also for the, the short submission. That's given the fact that when you trust, I have read your case and I understand your case. And to pay you back, that I would tell you what is in my mind now. What I think this is case, the matter of this case is interpretation of the clauses in the agreement. And then the question whether we rely on clause 2 enough, or there are more clauses need to be taken into account in reaching such interpretation. And it's you going further, the court should look at the surrounding and in order to reach a conclusion about the intention of the party at the deal time. So the claimant wants to draw the court attention that the deal, the intention of the party is that the fees is payable and due by the signing of the agreement between defendant and NBD, Emirates NBD, while the defendant going in the other side of extreme, the job has to be done. So this facility itself approved and sanctioned. So Mr. Mato wants the money in hand in order to pay the fees, while you, on the other hand, Mr. Razak, says, well, the signing, which is little bit more than introduction to the bank, is sufficient that for the fees to be paid. And now we're gonna we're gonna hear three witnesses to put us in the clear picture of the intention of the party during the deal time. What was the intention of the parties? Is that right? Am I summarizing your case in a right way?
Your Excellency, you've done a fantastic job, I must say. I'm thoroughly, in awe of what you've said, and I think it pretty much summarizes, in a nutshell, the both sides positions as far as we see it.
100%, Your Excellency.
So it's done. Then I think it's we as I said before, the question is it payable by the paperwork or by the job to be done? So and then we would need to hear, but we both agreed. No, we would need to get this interpretation from a businessman interpretation. So they are not laymen; they are both professional, commercial, sophisticated parties. Is that right, Mr. Razak?
That's right, Your Excellency. Both are very diligent.
So the interpretation would take that kind of a drift.
Yes, I agree.
Okay.
So, Your Excellency, as the law suggests, the interpretation would require a reasonable commercial man as such.
Yes,
How
commercial.
would a
man,
reasonable
yeah.
commercial man, having seen all the evidence, reach a conclusion here? That will be that's the if I'm summarizing it correct, if my learned friend agrees, that's what I think is the status of the law as such on this.
Yes, Your Excellency, I agree. It's viewing the scenario through the reasonable, commercially astute-minded man and how he would have behaved, he or she would have behaved in that situation.
That's fine. Then let's ask Mr. Farouk what he's going to tell us about this. Would you call your witness and introduce him, Mr. Razak?
Yes.
Are you
Mr.
okay? Or unless you want to take a break, I'm fine. I can continue.
I'm fine, Your Excellency. Mr. Farouk, would you like to take a brief break or are you okay to continue?
No, I'm good. Assalamu alaikum, everybody. Morning.
Alaikum salam wa rahmatullahi wa barakatuh. Thanks for being with us. It must be very early morning or after midnight for you, Ms. Farouk.
Not at all, sir. I actually follow Dubai hours. So I kind of work all night through in Canada just to follow Dubai working hours.
Wow.
Well, you're Canadian Batman. Okay, they're good. That's good. You may introduce your witness, Mr. Razak.
Yes. Mr. Farouk, could you please turn to section F, page 309?
Sorry, Your Excellency, should the witness swear before?
Yes. Yes, Your
Yes.
Excellency.
We do it
Apologies.
both. I mean, sometimes it happens. I mean, Mr. Razak is not completely wrong, but if you prefer,
Yes,
like even you want him to swear about even the number, the file location, that would be fine, Mr. Mato. Okay.
I was just preparing
Yeah,
the
okay.
witness.
Okay, then no worries. Saeed, would you please
Yes, please.
do the okay.
Mr. Farouk, please state your name and your occupation for the record, please.
My name is Adnan Farouk. I am the co-founder and managing partner of Fursa Consulting.
Perfect. So will you be affirming or swearing today?
I will be swearing.
Can I please see the copy of the Holy Book?
I don't have it ready right now. You'll have to bear with me for a minute so that I can grab it. Is that
Please.
okay? Okay,
Please.
just bear with me for 1 minute.
Please.
Your Excellency, I just wanted to check. You have a trial bundle electronically available to you.
Yes, it's open before me in another screen. Yes.
That's very helpful. Thank you.
Yeah.
Because I'll be taking the witness through the trial bundle.
Yes, Mr. Said. So this is the Quran.
Thank you. Keep your
Yeah,
right
you got
hand
it
on
in
the
50.
Quran, please.
You got it in 50 seconds.
It was not very far. Thank you very much.
Can you please keep it? Yes, thank you.
Yeah.
So please repeat after me. I swear by the Almighty God
I swear by the Almighty God
to tell the truth,
tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you, Mr. Farouk. Ms. Mariam, you may proceed.
Thank you. Mr. Farouk, could you confirm your full name and place of work for me, please?
My name is Adnan Farooq, and like I said, I am the co-founder and managing partner for Fursa Consulting, Business by Dubai.
Thank you, Mr. Farouk. Can I just take you to section F, page 309 of the bundle?
Section F.
I think my learned friend means section E.
Apologies, just bear with me.
It's a section 1A.
Section E.
Section
Apologies.
E1.
Apologies. E-1.
Yes, that is my witness statement.
Thank you, Mr. Farouk. Could you just turn to the last page of your statement, please?
Yes,
Can you confirm for the court that this is your signature?
it is.
Can you also confirm that the contents of this witness statement are true to the best of your knowledge and belief?
They are.
Thank you very much.
Mr. Farouk, I'm very, very grateful for your attendance today. It's even though you do Dubai hours, but I know nature wants us to sleep at night, so I'm very, very grateful.
Pleasure.
I will just to give you some idea, because I don't know if you've done this before. I'll be asking you a series of questions, and if you can answer them, that would be very helpful and will allow us to understand. At any point, if you do not understand what I've said, you can ask me to repeat. You can ask me to slow down if I'm being very, very quick. And if you need any refreshing, please do let me know. This is not supposed to be a interrogation, it's supposed to be a question answer session. So just so that the court can understand respective parties' intention, as His Excellency correctly said. So I'll begin cross-examination now. You are currently a managing partner of the claimant, correct?
That's correct.
The claimant provides debt advisory services to corporate clients since 2013, correct?
We got our license in February 2014, and since that, then we've been providing corporate advisory, more to do with debt advisory services to our institutional clients.
By training and background, you're a chartered accountant, correct?
That is correct. I'm a chartered accountant from England and from Pakistan, and prior in setting up Fursa, I was the group CFO for one of the subsidiaries of Dubai Investments.
Very impressive indeed. So given your background, you would understand commerciality behind corporate transactions, correct?
That's correct.
So essentially, corporate transaction, when you work on a corporate transaction, you will not see it in a vacuum as such, correct?
Yes.
You will see it holistically. That'll be fair to say that, right?
Yes.
So commercial parties seeking facility agreements to do business, make acquisitions and restructure debt, would anticipate to have access to debt to do those sort of transactions, correct?
That's correct. Depending on what is our negotiated scope with the counterparty.
The engagement letter dated 7th of January 2022, which is, if I can take you to section A, if you can see number 8.
Yeah.
Bear with me, I've got a bit of a lag here. Oh, it's not come. And page 152. So you'll see on your right hand side in red, page 52.
So page 152. Which section would that be?
Section A. Section A. There's number of these number of copies of this. So I'm just taking you to the one that I have used for my signposting. So it'll be section A, number 8, and page 152 in the number 8.
Okay, just bear with me.
It's just good for everyone to have it in front of us.
Okay, it's opening.
Yes, I know there's a bit of lag, especially when so many of us are accessing it at the same time.
Yeah. So I have the exhibits.
So if you go to page 152.
Okay, 1 second.
If you type the page number,
Okay,
that would
that
assist
is
you. Okay.
Okay, so
that
this
is the engagement letter we signed for the Islamic Bank.
yeah. So this is the 7th of January 2022.
That's correct.
You would agree that this engagement letter had 3 parties: the claimant, the defendant, and Channel 2 Group Corporation MFZ LLE, correct?
Well, not exactly, because the agreement was between 2 parties. It was Fursa Consulting, and if you notice, it was Mr. Ajay Sethi / Channel 2, and which were collectively referred as the client. So the client was Mr. Ajay and his company Channel 2 collectively.
But it would mean both Mr. Sethi as person, and because as you would appreciate, the defendant in this present dispute is Mr. Sethi, isn't that correct?
That's correct, because if you go through the debt facility that was requested, it had 3 elements. One, and this is not the particular engagement letter that is in dispute, but I can still explain. One was a liability buyout from another bank,
DIB, yeah.
Islamic Bank. That particular liability is in the personal name of Mr. Ajay. Secondly, the request was that he wanted to acquire 49 apartments in Varsha Heights. The MOU for this particular investment was also in the personal name of Mr. Ajay. However, the engagement letter that is in dispute also refers to a working capital facility for Channel 2. Hence, the engagement letter was with Mr. Ajay and Channel 2 Collective.
So that's what that you're confirming what I'm saying, that there were essentially 3 parties to it.
No, what I'm saying is Mr. Ajay and Channel 2, which is a wholly owned company of him, is collectively 1 party.
Okay, but you would agree that Mr. Sethi and Channel 2 are 2 different entities.
That's correct.
Okay. So you it's an uncontroversial point. Mr. Sethi signed the engagement letter as a chairman of Channel 2 Group Corporation, correct?
No, he signed it in his personal capacity because he's one of the parties, and because his other company is also 100% owned by him, he signed that as the chairman in his capacity as chairman and owner.
So you would agree that Mr. Sethi signed this as Mr. Sethi and as chairman Mr. Sethi, correct?
Yes.
The engagement letter that we are looking at, dated 7th of January 2021. Sorry, I'm calling it 2022. I beg your pardon. It's 2021.
No, actually, it's
2022. Sorry, I'm fiddling. January 2022. I'm fiddling with my. You're much more at ease than me. Was drafted. This engagement letter, 7th January 2022, was drafted by the claimant. Correct?
That's correct.
You will agree that the main purpose of the engagement letter is set out at clause 1 of the engagement letter, correct?
Yes.
Which provides the whole purpose of seeking the debt facility.
Yes. Which is a buyout of facilities from.
I was going to bring you to that. I was going to bring you to that, if you bear with me.
Sure.
So clause 1 provides that that the client, i.e., Mr. Sethi, is looking for. I'm just looking at the engagement letter that I have. Yeah. So essentially, they're looking at restructuring of debt. Secondly, they're looking at purchase of 49 apartments.
Yeah.
And then they're further looking for financing for the for Channel 2 Group Corporation. Have I gotten that right?
That is not correct, Mr. Martin. Because
Okay.
if you're referring to the engagement letter, that is on page 152.
Sorry, 157 I meant, not 152, 157. So that's the engagement letter in question.
Okay.
Sorry, I beg your pardon. I think I've misled you when I said 152 because the,
Okay.
the date is the same.
Yes, you're correct.
Yeah. Because this is the engagement letter that at 157 that is in question before us.
That's correct.
So it had three elements to it, correct?
That's correct.
As you explained to us. So specifically, the main purpose, commercial purpose of this agreement, of this engagement letter, was to seek liability buyout from EIB of DIB financing up to 45 million, along with new financing AED 28 million for acquisition of 49 apartments in Berkshire Heights, with down payment of AED 12 million and up to AED 15 million of working capital facilities for Channel 2 Group Corporation. So in total amounting to 88 million, correct?
Yes.
That was the commercial context of what we were doing.
I would like to clarify something here. The commercial context was under this mandate letter was essentially, and I would like the court and His Excellency to also refer the other engagement letter that we signed on the same date, which earlier we were just looking at on page 152. So the commercial.
Can I stop you there? Mr. Farouk, it's.
Would you allow him, Mr. Matthew, please?
Sure, Your Excellency, please go ahead.
Yes.
Yeah.
So the commercial element or the commercial purpose of both these engagement letters was eventually to allow Mr. Ajay Sethi to acquire these 49 apartments for which he already had signed an MOU. That is why, if you look at the Dubai Islamic Bank facility, it only talks about these 49 apartments. It does not talk about restructuring. The only matter which, when we discussed and agreed with him, and this was only because Dubai Islamic Bank already holds 3 properties which are currently owned by Mr. Ajay as a mortgage. So it was easier for them to kind of give additional facilities against the existing collaterals that they hold. The reason why we entered into a second engagement letter on the same day for Emirates Islamic Bank, in that, because Emirates Islamic Bank was a new bank for the group, they had no prior mortgages. That is why we agreed with him that part of this liability that Dubai Islamic Bank holds will be transferred to the new bank, and vis-a-vis, the mortgage of that property will also be more. But the main purpose of this facility, of both these engagement letters, was to arrange 28 million dirhams for him to acquire these 49 apartments. So that was essentially the crux of both these engagement letters.
And to
So
restructure
to arrange
the
the
debt.
money, and then to acquire the apartment.
That's correct.
And you'd agree, the claimant's claim is entirely based on the engagement letter, which is at 157.
No, it is based on the amount of facilities that we've arranged. So if you look at the
let's look at your particulars of, let's look at your claim form and what basically exhibits you have relied on. If I can take you to section A, number 3, please.
Okay. Yes.
So that's your particulars of claim, which is called summary of facts there. It says that subject to clause 2.2 of the agreement, a successful transaction had occurred. As
Where
the
are
defendant
you reading? Where are you
sorry,
reading?
it's
Which paragraph?
paragraph 3, sorry, Your
3,
Excellency, paragraph 3.
Right.
This is the basis of your of the claimant's claim. Subject to clause 2.2 of the agreement EX-1, which is the exhibit 1, a successful transaction occurred as the defendant accepted and signed the facility offer letter. So success fee of 2% of 46 million was to be paid. Now, let me take you to your exhibit 1, okay?
Yeah.
Sorry,
Which
it's
is
taking me a while to come there myself. I don't know if it's my system that's slow. Essentially, what you will see is the engagement letter.
Where it can be found? What's the reference?
Sorry,
where
it's,
the...
Your Excellency, it's in section A, number 6, exhibit 1.
Page 43.
Page 43. That's right. You would agree that the claimant has relied on specifically on only one engagement letter dated 7th of January 2022, correct?
That's right.
So it is not the other other engagement letter that you discussed shortly before, correct?
That's correct. The only reason I mentioned the other engagement letter was just to explain to the court and everybody else attended is the purpose of the transaction and why we entered into this arrangement was to arrange funding for the new acquisitions. Hence, you would see both these engagement letters signed on the same day.
Okay. After signing this engagement letter, the claimant approached EIB, but was unsuccessful in getting any positive response from them.
That's correct.
Correct.
And the reasons we've mentioned in our witness statement.
Yes, I will ask you the questions that I should ask you, if you can bear with me, please.
Sure.
So, clause 1 of the engagement letter also provides for the scope of work. It's in front of you, this on page 43, right?
Yeah.
And the scope of work includes obtaining business and financial information from the client, i.e. Mr. Sethi, preparing info memorandum if it's required, or something close to info memorandum for the sake of sending it to the bank to get a facility offer letter.
Yeah.
Identifying suitable counterparties, but here it was already specified as EIB.
Yeah.
And essentially, in the end, you will coordinate with various parties involved in the transaction, and subsection G of clause 1 says you will assist the defendant in negotiating and concluding the mandate with counterparties, i.e. with EIB. So concluding the mandate, ensuring that the facility is sanctioned and approved, correct?
That's correct.
Now, if I take you further to the next page, page 44 of this, number 6. Clause 2 then provides for the fees that you as the financial advisor would be entitled to for getting a sanctioned and approved facility, correct?
Yeah.
The success fee is payable under clause 2.2. Success fee is payable of 2% for the total project facility approved by the lender, correct? That's what it says.
Yeah.
And following, the project facility approved by the lender meant the amount of credit facilities sanctioned by either Emirates Islamic Bank as per the agreement, but as we know, then you went to Emirates NBD, so it was the project facility that was to be sanctioned by EIB, correct?
Yeah.
Therefore, isn't it correct that the defendant under the engagement letter agreed to pay the success fee to the claimant only when funds under the debt facility were approved, sanctioned, which means capable of being drawn down, so that the commercial purpose of the agreement would be met, correct?
Well, I would respectfully disagree on that front. And if you don't mind, I like to point something to the court because we're on the same page. I think the next line is extremely important.
I was going to come to that, but if you want to talk about it, please go ahead.
Please.
Yeah.
So if I can just bear and kind of digress, because we're talking about a related clause here. So in addition to what you've read, which is the definition of success fee, we've understood that it was 2% of the project facility approved, and we've defined the project facility as well. Now, if you look at the next paragraph, it also says that the client agrees to pay for such success fee in the case of a successful transaction, maximum within 30 days from the date of signing the facility offer letter or facility drawdown, whichever is earlier, which I think is very, very clear that the defendant at the time of signing this agreement was very clear that he has to pay the facility before the drawdown. It was the event of payment, the amount was payable of either 30 days from signing the facility offer letter or the drawdown date, whichever is earlier. And you had mentioned about a scope of work, and you kind of specified.
Sorry, Mr. Farouk, Your Excellency, it's important for us to have a cross-examination which is more pointed than to have a longer speech.
No, it's interesting. I would like to ask him why this two things are brought together, like the date of the signing the facility or the drawdown, whichever comes earlier. I mean, isn't it weird like to put it, I mean, in such clause? When you say, first of all, the first question, when you mean the signing of the facility offer, what does that mean? The signing of the offer only, the paperwork between the bank and Mr. Sethi. That's what you mean, yeah?
Yes, but more specifically, sir, how the process works, and I'm sure His Excellency knows about this, that before a bank approves a facility, there is a chain of emails and information that gets exchanged. There are credit concerns raised by the bank, which we were able to answer successfully. Eventually, once the bank approves and gets internal approvals from all authorities, an official letter is issued, which is called a facility offer letter, which predominantly talks about, and it's a very detailed document which talks about the borrower, the terms of drawdown, the information that the borrower has to submit. And if I may point out, the information that Mr. Matu talks about in Schedule 1, these are not approving conditions. These are dispersal conditions. And why we did and negotiated a time frame for our payment was that if you go through the approving, rather the dispersal conditions in Schedule 1, these are basically mortgage of assets which are being financed. These are submission of proprietary constitutional documents like Mr. Ajay's personal Emirates IDs and passport copies and so on and so forth. Similarly, there are a few other documents from his other banks. Now, because we had timelined and kind of fixed our payment structure was to protect our interest, where we have done all the work and provided him an approval. And because of his delay, let's suppose he does not get the mortgage arranged for the bank, or he doesn't supply any constitutional document to the bank, or any other information that the bank requires, which is already there in the schedule, in conditions 1, Schedule 1, he delays. Why should we get penalized? That is why there was an agreement.
I see. Mr. Matu, one more question. I'm sorry.
Your Excellency, you have the floor. So I'm at your service, Your Excellency. Please.
Ms. Farouk, I mean, are you treating like or are you saying that you're entitled to the same fees in both scenario, whether only paperwork or introduction and the drawdown? So your fees exactly the same in both scenario, whether he got the money cash draw down to his account or just introduction and paperwork, the fees exactly the same?
So the fees, Your Excellency, the fees is exactly the same when he gets the drawdown. However, if I may just kind of put this point to the attention of the court, that it was not merely an introduction. After the introduction, we have to go through a credit approving process with the bank. And that approving process takes months and weeks and months. That's what
I call it paperwork. That's what I call it paperwork, if you remember.
And after that, once you're successful, we're able to get a facility offer letter from the bank, which clearly demonstrates that his facilities are approved. Now, Mr. Matu also talked about the other engagement letters that we signed with him. We had multiple banks, including ENBD, in one particular mandate as well. Now, we did the paperwork. We did exchange all the information with all the other banks, but we were not able to get him the final approval. And that is where this particular case, where the approval is in hand, which is accepted and signed, is the basis of our claim.
I see. We'll leave that for Mr. Razak for next time. Okay, Mr. Matu, please. Beg your pardon.
No, I'm obliged, Your Excellency. Now, given the commercial purpose behind the debt facility, you would agree that the commercial common sense here is that 2% success fee will be payable only if debt facility was sanctioned by the bank, which means that facility would be available for the commercial purpose of the engagement letter, correct?
Yes, subject to certain conditions which Mr. Ajay and his team was supposed to complete and provide.
Again, the whole purpose of the facility being that it will be capable of meeting the commercial purpose of the agreement between the claimant and the defendant, correct?
Yes.
Yes. So if I can take you now to A8, section A, number 8, and page 162, please. Page 162.
Just bear with me for a minute, it's opening up.
No, take your time, please.
162, yes.
So this is the facility letter that was issued by Emirates NBD, correct?
That's correct.
Dated 22nd of March, 2022, correct?
That's correct.
And the facility letter came in two parts as such, if I can call it two parts. The first facility term loan, there were two term loans in it. You agree with me on that?
Yes.
We agree on that? The first term loan was for 18 million dirhams, which was for restructuring purposes, to buy out the existing liabilities from Dubai Islamic Bank, correct?
Up to 18 million, yes, that's correct.
Yeah, up to 18 million. And the availability was 90 days from the date of acceptance of the facility letter, right? So within 90 days, when they receive the conditions precedent, they would decide whether to approve and sanction this, correct?
Now, let me correct this. This is an approval. The precedent, the conditions precedent in Schedule 1 are dispersal conditions. So once he submits all those documentation, the bank will disperse. The bank has already approved, and as you can see, this facility letter is a very, very exhaustive document, typical to a facility letter that every bank issues.
So let's test that for a second.
Yeah.
The letter starts saying, further to our recent discussions, we're pleased to advise that Emirates NBD has agreed to make available the facilities listed in the clause facilities below. I'm just going to go down a little bit because it doesn't really help us further. And it says, and subject to the terms, the facility is subject to the terms and conditions stated in this letter, including condition precedent attached as Schedule 1. We agree with that, right? So the facility agreement or facility letter was subject to these conditions precedent.
Yeah.
So essentially, it was an agreement that will be formed once the condition precedent would be met.
Yes.
And essentially, for the first term loan, there were 90 days within which this offer would be open for it to be fulfilled. And that's my first point. And I hope you think it's uncontroversial because I'm just reading clause 3.1.6. That's what it says. 90 days from the date of acceptance.
Yeah.
And then the second term loan is 28 million, which is on next page on 164. And it's for 28 million. And this is for the, I assume it says towards part financing and real estate investment. It's the 49 Barsha Heights apartments that was supposed to be purchased with, right?
That's correct. Yeah.
And this had a slightly longer availability period, that is 6 months from the date of acceptance of the facility letter.
Yeah.
So essentially, so there was a two-tier acceptance period in this facility letter, correct?
Not really. It was not a two-tiered acceptance. It was a two term loans, and both these term loans have different collateral requirements.
Fine. I mean, essentially, within 3 months for 90 days for the first term loan and 6 months for the second term loan, correct?
Yeah.
Okay. Then we come to Schedule 1. Schedule 1, if I take you there, which is page 173.
Yeah.
Okay. These are documents and information which will enable the bank to assess the creditworthiness of the defendant, correct?
Not really, Mr. Matu. I keep correcting you. It is not for the assessment of the creditworthiness. These documents are required to disperse the loan. And if I may just ask you to read these documents, the first one is an original copy of this letter. The second is a copy of the general terms and conditions, which was actually signed by Mr. Ajay along with this letter. The third one is actually the mortgage of these 49 apartments and the villa against which these two loans were given. Now, you can understand that if a bank is giving you a real estate backed loan, you need to, the dispersal happens simultaneously. To
So
simplify it, if I may complete, Mr. Matu, if you don't mind, and with the permission
Please.
of His Excellency, if let's suppose, and just to make it very, very simple, if let's assume I go to Dubai Islamic Bank, that I have an apartment somewhere in Dubai that I need to acquire. The bank will give me an approval letter, but the disbursement will happen once I mortgage this apartment in favor of the bank. That is why the money, that is when the money will get exchanged. Similarly, the condition as per this approval letter is that he has to sign the facility documents. He has to mortgage these facilities, these properties. And in addition to that, he has to assign the rental and the insurance per se for the bank to disperse the loan. So
can I?
Why I gave all this background was just to correct that these were not conditions to approve or to check the credit worthiness of the borrower. These were conditions that needs to be met before the dispersal happens.
So if I take you to number 5 on 174, valuation report from an approved valuer in respect of each mortgage of real estate.
Yeah.
And what it was essentially, I mean, you're a chartered accountant, so, you know, bear with the lawyer and correct me if I'm wrong. So when a bank gives you a loan or an offer of a loan, it has to look at the collateral, whether basically you are credit worthy to be given that loan, correct? So essentially, this exercise is not that far from it, because what the bank is doing is, if we give you 46 million, what security do we get for giving you 46 million?
That's correct.
So they have to do a valuation of this security within the credit committee of the bank, has to look at all this and say, okay, does this meet our criteria, correct?
Yes, but if you can complete your question, I can then kind of address this.
So essentially, when they look at all this package of security that you give, the valuation of your mortgage, valuation of your rental income, and other insurance policies that you might have that further collateralize the loan. So in essence, that altogether gives them a criteria under which to give a loan, correct?
That's correct. However,
so an exercise has to be done after the signing of the facility letter, that with all this information, can we give a drawdown of this facility to this person?
Okay. So just to answer your question, the bank definitely needs to look at the valuation report before assessing whether and how much loan will they approve, which they've already done as part of the information that we've exchanged. They gave us a list of valuers. Cavendish was the valuer that was part of their list. We approached Cavendish. There was a valuation report which was provided to the bank. The only problem with that, and that valuation report had a value to this property. The only problem was that this valuation report was not addressed to the bank. So if you go through this condition again, all it says is the valuation report from the approved valuer addressed to the bank. And the same problem, and rather the same kind of point, is substantiated in the email exchanges between the bank, us, and Mr. Ajay post the approval and acceptance of this facility letter, where the bank is clearly saying, we are saying that the report is available. The bank is saying, why don't you address it to us? We said, don't worry, we will handle that. All that information has already been provided.
And you mean, Ms. Farouk, this is just related to the assets itself, not to the worthiness of Mr. Ajay Sethi himself.
No, sir. No, sir. Because see, and I would want to explain this point of yours in detail. This is the final letter that any bank issues in the UAE once all approvals are received internally. After this, the bank does not issue any more letters. Now, as part of our exhibits and part of our submissions also, we've also drawn attention to Mr. Ajay's other facilities that he has with Dubai Islamic Bank and Bank of Baroda. Both these banks have also issued very similar letters. Both these letters also refer to certain terms and conditions that needs to be fulfilled, which once he's done, he's gotten that money. So our point is that, yes, we're talking about interpretation of this document. Quite clearly, Mr. Ajay has seen these documents from other banks. He's accepted them. He's been dealing with multiple banks in the country. He's a very successful businessman. So again, for the purpose of our argument today, we're talking about interpretation, but it's very, very clear that this is the final document that any bank issues after approval.
Thank you.
You would agree. I'm just responding to the statement that you just made, and Mr. Farouk, that every bank has got their own criteria. So you cannot just Emirates NBD has its own sensitivity for a loan amount that they would have to give a drawdown for or sanction it vis-a-vis Bank of Baroda or Mashreq or whatever it is. Every bank has a credit committee which has its own criteria. Isn't that correct?
Yes, the approving criteria is individual to every bank. The facility limits, the appetite is limited to every bank. The type of documentation, the manner they prepare that documentation can be different. However, there is no other document that is produced by the bank once a facility letter is issued.
I understand. Now, you would agree with me that this facility letter was signed by Mr. Sethi on 30th of March 2022, correct?
That's correct. Yes.
On 31st of March 2022, could Mr. Sethi get the facility of 46 million, buy 49 properties in Barsha and restructure his debt? Was he capable of doing that on 31st of March?
Well, I mean, when he signed this facility letter on 30th of March, he obviously understood the terms and conditions that he has to fulfill.
No, I'm asking a question, Mr. Farouk. I'm just asking a very direct question. On 31st of March, was drawdown available as a result of this facility?
Yes, the condition, if he meets on 31st of March, yes, the facility was available. Was
it available on 30th of March?
No, because if he does not submit those documents, which are dispersal documents, more so.
So essentially, you agree with me, it was subject to these condition precedents?
Subject to these dispersal conditions, absolutely.
Okay.
My only disagreement with you is that these are not approving conditions. These are dispersal conditions.
based on the offer set out in the facility letter, this was more like, at this stage, more like a ENBD's term sheet. It wasn't a binding contract. Just by Mr. Sethi signing this agreement, ENBD was not required to give Mr. Sethi any amount of loan amount that they had in a preliminary manner offered to him. Correct?
I mean, I'm sorry I'm repeating myself, but I would still have to very respectfully disagree with you. And with the permission of His Excellency, I'd like to explain this point a little more.
I think you've explained this, your position, if
No,
you don't
because
mind.
you mentioned the term sheet. I think it's very clear that I kind of.
I didn't say it was a term sheet. I'm saying it was like a term sheet. That just to.
So let me put across few evidences that we've submitted, which will prove to the court that this is not a term sheet. Now, first of all, any term sheet that the bank issued goes through a certain legal process, which clearly says that this term sheet that the bank is issuing is non-binding and is not, and anybody issuing it cannot be held responsible. You will not find this statement in this offer letter. Secondly, in addition to the engagement letter, which is under dispute at this point in time, we also signed another engagement letter for DIB on the same date. If you notice, clause 2, there is an assignment fee of 50,000 that we've negotiated and agreed with Mr. Ajay, and that 50,000 was to be paid on approval of a term sheet. Now, that is where we're actually talking about a non-binding term sheet. So if you look at these three things together, this 50,000 was to be paid once a non-binding term sheet will be issued. And once a final approval comes in and he approves it, we get paid either within 30 days of signing the facility letter or drawdown, whichever is earlier. So all I'm trying to explain is. Yeah,
sorry, Your Excellency, I just want to point to the court that the claimant's claim is subject to this engagement letter, and it's subject to this facility letter. Any other discussion that Mr. Farouk is raising here is extraneous to what we are talking about today, what we have to decide today. It's your claim that you have advanced, Mr. Farouk. It's not what I'm saying. It's what you have stated in your statement of claim and in your claim form. So we have to be in the boundaries of that.
Yeah. So look at this agreement here.
All I'm talking about is basically in relation to another exhibit that we've already submitted. So we're not talking about.
That might be an exhibit, but your claim, as it's structured, is what it is. So yes, we have to.
If I may repeat myself, any non-binding document that the bank issues clearly says that this is non-binding, and you will not find the statement in this facility letter.
Mr. Mato, next question.
Yes, Your Excellency. If I take you back to 174, which is the condition precedent, and to the number 14.
Yeah.
Essentially, this condition precedent list that was provided by the bank was not exhaustive. They could ask even further, list of documents or information to their satisfaction. So this was not the only list of things that Mr. Sethi was required to fulfill. Isn't that correct?
That's correct. And again, I'd like to add something.
Sorry, I mean, this is a very simple question because.
No, it's not, because it's not a simple for everybody to understand. It might be simple for you, but quite honestly, if I have the permission of the court, I'd like to explain this.
In short.
Thank you, sir. Point number 14 comes after the first 13 points. If the borrower is not able to submit any particular document to the satisfaction of the bank, and I can give you an example. If let's suppose the bank says that I want an clean account conduct letter from a bank, and any bank is not issued, doesn't issue that letter. Yeah, and as part of the bank's policy, the bank says it is not part of my policy to issue good account conduct letters. So in that case, the bank might ask, okay, why don't you give us a copy of your bank statement? We'll see that there are no defaults and we'll satisfy us on this particular point. So again, this is an extremely common point that every bank issues and writes in every facility letter.
In fact, if I take you to E number 9, 443, can you go to bundle, sorry, section E?
Yeah.
Number 9.
Yeah.
And then page 443.
I have it in front of me, yes.
Yeah. So if you go down, there's an email from ENBD to Mr. Khan, okay, who is your co-founder.
Yes.
This is when they first inform you that they would like to offer this this facility letter, right?
Yeah.
So they provide a list of things subject to the following. It's approved subject to the following, okay?
Yes.
A to N, and then it says the above list is not exhaustive. So these are additional conditions precedent that were not included in the TNCs of the facility offer letter. They said, you know, this is not exhaustive. Further terms and conditions and condition precedent will be added. You agree with that?
Yes, but what is your exact question on this?
The question is, I'm just asking for your confirmation that there were further conditions that were not in the condition letter, but they were informed to you by way of an email. They kept on further informing you about further conditions that they required before they could talk about a drawdown, correct?
Not really, because if you compare this list with the with conditions precedent, the scheduled 1, this is practically the same list.
Well, whatever it is, but here they're specifically saying that this list is not exhaustive, would be sending you further. And as I would go with Mr. Khan, I'm not intending to go with you on this because it's primarily he was involved in this. I will show the court there were further things that they were continuously asking for, which were not in the original condition precedent. So that's my point I'm trying to make. But it's not something I intend to take you there. So I would like to put to you that the amount of success fee payable at the time of signing of the facility letter was 0 because no amount of debt facility was sanctioned and capable of being drawn down at that point. Isn't that correct?
Not really. Again, this is a matter of interpretation, and I would request our lawyers to kind of handle the situation.
Sorry, I mean, this is a cross-examination. You know, I'm just asking you a question. You're supposed to just answer yes or no. You can disagree with me, and I'm sure your lawyers will take up with this, you know, at some other point. No amount of debt facility was sanctioned by the bank when it issued the facility letter, because it had not yet all ascertained whether Mr. Sethi and Channel 2 were creditworthy for their loan term, correct?
I respectfully disagree, and I will keep saying that these were dispersal conditions. These were not approving conditions.
A credit committee of ENBD would review, in the end, all the documents requested by ENBD by way of condition precedents and decide whether to sanction the debt facility, which will allow the defendant to meet the commercial purpose of the engagement with you, correct?
Incorrect. And I don't know whether this is any comfort to the court, but we've been doing this for 10 years in Fursa alone. And even in our previous jobs, we've been doing this thing forever. The credit committee's role finishes once the facility is approved. Once the minutes of that credit committee goes to the documentation team of any bank would prepare this document. And all these conditions precedents that you see, once these are provided by the borrower, it will be reviewed by the documentation team. And if they match, they will give a clearance internally on the system saying all conditions have been met, please go ahead and disperse.
Without sanctioning of the debt facility by ENBD, defendant would not be able to fulfill the commercial purpose of the debt facility set out in clause 1 of the engagement letter with you, correct?
Can you repeat this question again, please?
Without sanctioning of the debt facility by ENBD, okay, the defendant would not be able to fulfill the commercial purpose of the debt facility, correct?
Yes. However, this facility clearly shows, this agreement clearly shows that the facility has been sanction.
I'm just asking a question. You
onus-
answered it. That's all I wanted to basically
I'm
ask.
sorry, just to complete, the onus is actually on the borrower to complete and submit these documents and take the money.
Therefore, you agree that in conclusion that no success fee was payable upon issuance of the facility letter by ENBD to the claimant, because no debt facility was ever approved or sanctioned by ENBD at any point.
Again, I would respectfully disagree. And if we agree to that, why would we enter into a claim dispute?
Well, people do strange things, Mr. Farouk. That's all I have to say. Those are all my questions for Mr. Farouk, Your Excellency. I have no further questions for him.
If I may just add before I close, Your
Oh,
Excellency.
no, Mr. Farouk, no.
No further questions.
No, Mr. Razak, unless you need to do any clarification, and we'll dismiss the witness.
There are a few points, Your Excellency, if I may.
Please.
Staying on the facility letter, Mr. Farouk, can I just take you again to clause 2.2?
Give him the full reference.
Can you direct him to the reference, please?
Yes. So the reference is, well, I have a different reference to my learned friend.
Please use yours.
Yes, it's section A, page 43.
Okay.
Now, if we scroll down, Mr. Farouk, page 44, clause 2.2, in relation to fees. Do you have that, Mr. Farouk?
I do. I have a printed copy in front of me.
Just to clarify, Mr. Farouk, the point that was made by His Excellency, can you clarify for the court why the same success fee is being charged upon drawdown and also the signing off facility? So essentially, what is involved when you are actually asking the client or the defendant in this matter to actually sign off the offer letter? So what preparation has been done prior to doing so, Mr. Farouk?
So not particularly to this case alone, but any transaction that we get mandated for, our role is to go through the client's information, discuss that information with him, understand the areas where any bank would have concerns, mitigate those concerns internally, structure the proper debt, and then prepare an information memorandum that we give and provide and circulate to all banks. Now, in certain cases, we're mandated for certain specific banks. In certain cases, we actually have a wide slate of banks to approach. Once the information memorandum is given to the bank obviously goes through it, asks for additional documents, and we're talking about documents with relates to passport copies and audited financials and property documents and rental agreements and so on and so forth. This is primarily done to prepare a credit proposal that the relationship team of any bank would prepare. That credit proposal goes to a credit committee or credit department first. The credit department will go through that proposal, give its comments to the credit committee. The credit committee would either reject or approve the facility. Once the facility is approved, the minutes of that meeting goes to the documentation team of a bank. That documentation team would prepare a very standard facility letter for all their approved clients, subject to certain terms and conditions and additional documents that the credit committee has approved for.
So essentially what I'm saying, Mr. Farouk, is that you make reference to a valuation report being addressed purely to the bank. Are you involved in preparation and liaising with the surveyors for the valuation report?
Well, as part of our kind of assistance to our clients, all we do is we kind of liaison with companies that we know or companies that we've worked earlier with, just to speed up the process. And however, the relationship between any third-party advisor and the borrower is direct. It is not with us that we kind of appoint these third parties.
Okay, so essentially what I'm asking you, Mr. Farouk, is that at the time of sign off of the offer letter and the drawdown facility, is the level of work that is involved by you the same level of work that's involved?
Absolutely the same. Absolutely the same. Once the facility letter is issued by the bank, there is hardly any more work that we can do before the client reaches to a drawdown level. Hence, that is where we've kind of frozen our fees.
Okay, thank you, Mr. Farouk. Thank you for clarifying. If I can now take you to the schedule again, just bear with me. It's taking a while. Just bear with me while I get to the relevant page number for you.
Sure.
My apologies, Your Excellency. It's lagging. The system is lagging slightly. So it's page number 66, Mr. Farouk.
Okay.
My learned friend refers to the number of conditions precedent that needed to be satisfied, Mr. Farouk, in his cross-examination. Can you explain the relevant due diligence that is carried out by the bank before the issuing of this facility letter?
Okay, so as part of the questions, or rather concerns, that any bank would issue and raise is whether the transaction which is under consideration, is that a genuine transaction or not? So what they would do and ask is provide us the MOU copy of this particular transaction. And we're talking about the acquisition of these 49 apartments in Fursa Heights. In addition to that, the bank would also see that if the repayment will come out of the rental assignments, they would also want to know how much rent are these apartments generating. Thirdly, they would also want to get evaluation done for these apartments just to see that in case of any volatility in market prices, is their debt covered or not? So all these documentation and everything was provided.
What I'm trying to get at, Mr. Farouk, is the defendant's, in this instance, creditworthiness established prior to the issuing of the facility offer letter?
Absolutely, because that is the only thing that any credit committee of any bank would check. And if they're satisfied, only then the documentation team will issue this letter.
Thank you. And finally, can you differentiate between a term sheet, an indicative term sheet, and a facility offer letter?
Okay. Since you're talking about term sheet, there are two term sheets that we've already submitted as part of our exhibits. One was issued from Commercial Bank of Dubai, and one was issued by First Abu Dhabi Bank.
I think that the court has had sight of that, but I want you to explain, Mr. Farouk, what is the difference?
Why I mentioned these two documents were, if you go through these term sheets, one, they clearly mention that these are non-binding term sheets. These are not final approvals, and this is subject to credit approvals. Secondly, the term sheet is basically a summary of a key loan. So it's merely 1.5 page long. It is not definitely 17 pages long.
Okay, thank you.
What do you mean by non-final approval? What do you mean by non-final approval?
So, sir, once you put up a proposal to a bank, the bank would review that proposal, send it to the credit team. The credit team would send their recommendation to a committee. The committee would have different department heads. That committee would decide whether they will go ahead, a bank will approve this loan or not. And if they would approve, what additional documents would they require? Once all that decision is minuted, those minutes are then sent to any bank's documentation team. And this is a very standard document that the bank issues for all their new loans. And the documentation team will then issue this.
That what is coming in schedule 1, and then what comes in with the email we have seen showed by Mr. Maro. So
yes, so email was just a very brief summary of the approving conditions, the documentation that would be required, and that email also mentions in the first line that 46 million dirhams has been approved by the bank.
Subject to conditions.
Yeah. So then So your role is basically just introduction the Mr. Ajay to the banks only, and then
Yes.
is that right? Only
Yes.
introduction.
What we've been doing this for 10 years now. So what we do is we would review the document, we will carry out our due diligence, we will iron out the risk areas, we will structure it, and that structure goes to banks.
Perhaps
So
you could explain to His Excellency, Mr. Farouk, what your due diligence involves.
So for Mr. Ajay's particular case, we went through his personal net worth statements, which was audited. We went through the MOUs and the other documents that he signed for this particular transaction to acquire 49 apartments. We found out and we checked a previously done valuations for these apartments, and then we agreed a price with him. And if you notice, the MOU is valued for 40 million dirhams. He mentions that he only requires 28 million dirham as loan, and 12 million dirham will be funded from his own sources as equity. So this percentage of loan and equity was also agreed with him. Then when we talked about and we told them that the collateral coverage that any bank is looking for is higher, we then discussed and agreed that part of this loan from Dubai Islamic Bank will be moved. So we obviously went through the loan documentation. Here we went through the property valuation. We went through the rental that he generated.
Other facility options.
Yes.
Looked at other facility options. But
So,
I mean, sorry to, I mean, I'm not supposed to ask so much questions. I just need to understand this case because, what is it? The due diligence, Mr. Razak, is just referred you to. It's exactly the similar things that comes in Schedule A and in the emails, which is you said, well, this transaction rejected because Mr. Ajay was not complying with that requirement. If you have done this due diligence, then that should not lead to the rejection of the transaction, maybe.
So that was actually the case with our previous mandates. Because we were relying on the information provided by Mr. Ajay, certain times, and you can understand any bank would have much broader kind of areas to review a particular case than us. For example, the bank has access to all, world Interpol or, their credit access global. They have access to central bank bureau reports, which we at our level, we don't. So the banks would figure out certain cases. One time, the bank rejected his proposal because his classification with the central bank was downgraded. One time, there was another case with DIFC, which was brought to our attention by the bank, and they said, we're not happy dealing further with this client. When we approach ENBD, we made sure that we have proper justification on all those previous problems before approaching ENBD, and that is the only reason we were able to convince the bank and got him the approval.
Thank you.
Thank you. I have no further questions, Mr. Farouk. Thank you, Your Excellency.
Thank you, Mr. Farouk. Thank you very much for coping with Mr. Mato and with the court question.
No further questions from me, Your Excellency. I'm ready to embark on the second half of the process. If anybody wants a break, I'm free. I'm open to that idea, but we can motor on, I think.
I think we can continue. We can take the second, Mr. Razak witness,
Yeah.
then we'll break.
Yeah.
Absolutely fine.
Thank you very much, Ms. Farouk.
Thank you, sir.
You may leave the bench here. Thanks.
Your Excellency, can I call Mr. Abdul Muiz Khan, Abdul Aziz Khan?
Yes, you may call Mr. Khan, yes. Yes, Ms. Khan.
Mr. Abdul Muiz, do you hear us?
I do. Assalamu alaikum, His Excellency, and good afternoon, the lawyers, both the lawyers.
Good afternoon.
Good afternoon, Mr. Abdul Muiz. Can you please state your name and your occupation for the record, please?
My name is Abdul Muiz Khan, and I'm the co-founder, CEO, and managing partner of Fursa Consulting.
Perfect. And will you be affirming or swearing for today?
Sure.
Excuse me?
Will you be affirming or swearing, Mr. Khan?
I do.
He
will
got
be
the holy
swearing.
book.
I think he'll be swearing. I
holy
think
book.
it looks like he's got the Quran in his hand.
Yeah. All right, Mr. Abdul Muiz, could you please repeat after me?
Yeah.
I swear by the Almighty God.
I swear to the Almighty God.
No, I swear by the Almighty God.
I swear by to the Almighty God
To tell the truth,
to tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. Thank you, Justice.
Thank you very much. Mr. Razak, you may introduce your witness.
Thank you. Mr. Khan, could you confirm your full name and place of work for me, please?
My name is Abdul Muiz Khan. And the second thing, the place of birth,
Yes, please, Mr. Khan.
I was born, I'm from India, a place called Aligarh.
Apologies, Mr. Khan. Your place of work and your position.
Work. Your
Okay.
business.
I am the founder, CEO, and managing partner of Fursa Consulting.
Thank you, Mr. Khan. Can I take you to your witness evidence, Mr. Khan, at section E, page number 312?
Sure. Just bear with me, Mariam. Is this, we are referring to the pre-trial bundle?
Yes, Mr. Khan.
Okay.
Not to pre-trial bundle, to the hearing bundle, I think.
To the hearing bundle. Are you on the
Okay.
system, Mr. Khan?
Yeah, I am in the system. Just let me pull that again. I think this, you sent it today.
It was sent by the representatives today. That's right, Mr. Khan.
Right. Let me pull that document. Just bear with me.
Just for the sake of completeness, Mr. Khan, it's section E, page number 312.
Yeah, please go ahead. I have the printout of my witness.
Okay. Can I take you to page number 317?
Okay.
Is that before you?
Let me get hold of the document. Is this
Oh,
the skeleton agreement we are talking to?
No, it's your witness statement, Mr. Khan.
No. Is this the bundle that we are referring to is called the skeleton agreement?
No, it's not. It's the actual trial bundle.
And when was it sent, please?
It was sent by the representatives late on yesterday and this morning again.
Mariam, please bear with me and take me to this document. His Excellency, just bear with me to get this hold of this document so that it's easier for me when Mr. Salah refers me to this document.
No worry. Mariam, you direct him. Let him
Yes.
tell you where he
Yes,
is
Your
now
Excellency.
exactly. What
Can
page
you
is open?
confirm where you are now, please, Mr. Khan?
Well, I am referring to so many emails that I have received today morning. So which email are you talking about?
Just bear with me a second, Mr. Khan. It was sent this morning. I'll get the actual timing for you now.
You may do something, Mr. Razak. You may share your screen and show him from where he can start.
Yes.
Yeah, I think that would be a good idea, man.
Your Excellency, if I may, Mr. Khan needs to have a trial bundle because it will not be possible to do cross-examination without it.
I'm just attempting to share my screen with Mr. Khan. Just bear with me. Apologies, Your Excellency. My bundle seems to now have disappeared, so just bear with me.
Oh,
No worries.
Apologies, Your Excellency. I won't be a second.
Mariam, is that a link? Okay.
Yes,
the trial
yes,
one.
it's a link. Do you have it?
Yes, I got it.
Do you have it, Mr.
Yeah,
Khan?
yeah. Yeah,
Can I
have.
take you? Can I take you to page number, section E, page number 312?
Just bear with me, I'm just downloading it. A minute.
Yes.
Yeah. Yeah. Which
Have you
page?
got 312, Mr. Khan?
Page 312.
312.
Yeah, this one.
you can print the page number in the search
Yeah,
box
that's
and
fine,
do
that's
it.
fine. I have it. I have it.
Can I now take you to page 317, please, Mr. Khan?
3117.
317. That's right.
Yes, I am there.
Can you confirm that that's your signature, please, Mr. Khan?
I confirm that's my signature.
And can you confirm that the facts stated in the witness statement are true to the correct to the best of your knowledge and belief?
I do.
Thank you, Mr. Khan.
Mr. Mato, the witness is yours.
Thank you, Your Excellency. Mr. Khan, thank you so much for making yourself available today. We are very, very grateful. Just to give you some structure, as you must have seen with because I'm seeing the cross-examination of Mr. Farouk, I'll be asking you a series of questions and taking you through the trial bundle to help us understand your position.
Sure.
If at any point you feel I should slow down or you don't understand what I'm asking, you can always clarify and seek a restatement of the question. So please feel free to ask me and stop me whenever you want to. Okay. Okay. With that, you are the CEO, founder, and managing partner of the claimant, correct?
That's correct.
The claimant provides debt advisory services to corporate clients since 2014, correct?
That's correct.
By training and background, you're a corporate banker, correct?
I have a corporate banking as well as risk management, including audit.
Thank you for correcting me. Very impressive, like your co-founder. In fact, you have been a corporate banker in Dubai for over 2 decades before you and Mr. Farouk set up Fursa Consulting, correct?
That's correct.
You worked for the Emirates Islamic Bank between 2006 and 2011, correct?
That's correct.
So given your background, you would have very good understanding of the commerciality behind corporate transactions, correct?
That's true.
And commercial parties normally seek facilities and debt facilities to do business and to make acquisitions and to restructure the debt, correct?
Correct.
Amongst other things. I don't want to say they just do it for these 3 things, amongst other things, correct?
True.
So it's correct that you know the defendant since November 2020, right?
Correct.
That's when you first tried to seek your assistance to get debt facility, correct?
Correct.
So I'll ask you a few questions about the previous engagement letters. Isn't it correct that the claimant entered into a number of engagement letters with Mr. Sethi / Channel 2 Group Corporation, right?
Okay.
So for example, if I take you to A, section A, number 8.
Which page number is that?
So page 142 in section 8. So section A, number 8, and page 142.
Yeah, okay.
So this is the first engagement letter between the claimant and the defendant. Even though this is not part of the dispute, I just want to highlight this. So this is dated 1st of November, correct?
Correct.
In this engagement letter, your mandate just was subject to seeking lending from DIB, ENBD, CBD, and Mashreq, correct?
Correct.
And if I ask you to turn over one page to page 143, the next page, here the fee structure was that they would be a $50,000, oh sorry, AED, immediately payable on indicative term sheet from the lender, and then there would be a success fee upon approval of the total project facility, which will be sanctioned by the banks, and there would be different success fee for different banks, correct?
Correct.
And then if I ask you to go further down to page 145, the termination is consistent with other engagement letters that you and the defendant signed. 90 days, either the financial close of the transaction or 90 days from the anniversary of the letter of mandate, which is the engagement letter. Okay, correct? Am I getting it right?
Yeah, okay.
Okay, then from there, if you go further down on page 147, you further entered into a second engagement letter, 23rd of June 2021. Again, debt facility, various banks, but this time there was also, I think, RAC Bank and FAB, including ENBD, CBD, and Mashreq. Yeah?
Right.
And this time the fees were on the next page on 148 were fairly different again, because there was an assignment fee of 75,000 dirhams payable upon term sheet, and then 2% upon success fee to be paid for the total project facility approved by the lender and which will be sanctioned by the banks, correct?
Correct.
Okay. And again, it's uncontroversial point. Page 150, termination is identical to the one that we just read. 90 days from the anniversary of the letter of mandate or the financial close of the transaction. Yeah.
Okay.
Then we then by this time you were not able to secure a debt facility for the defendant, correct?
Correct. The final approval, you mean?
Yes. So you were not able to get any credit facility or debt facility, any bank interested in it, correct?
Well, I wouldn't say that the banks were not interested. Is that the banks were initially interested, and that's why in agreement and in discussion with our client, Mr. Ajay Sethi, we proceeded with these banks, we approached these banks, we provided them with the initial set of information, which at their part, they did the due diligence, but somehow or the other, they found out some information which we were not aware of as consultants, as financial advisors, whereby the banks decided that they would not like to be proceeding forward.
So essentially, the fact was that that Mr. Sethi, the defendant, had various financial difficulties which were preventing the banks from giving him credit facilities, correct?
Well, yes. And these financial difficulties, I would say, can be considered in a banking language, can be considered as bad banks, okay, in terms of credit history.
So his credit, he was not credit worthy enough, correct? for them?
Well, for those banks,
Yes.
at that point of time.
So if I take you to your witness statement to paragraph 7, so which is at section E number 2.
Just tell me the page number, please.
Yeah, so section E number 2, page 314. Sorry, no, I beg your pardon, 313.
Okay. Yeah.
So by way of just confirmation, you say at paragraph 7 that the previous engagement letters that the defendant had with claimant have all failed because defendant or one of the group companies was downgraded by UAE Central Bank. During the market check, the bank was concerned with the negative feedback, and there were ongoing legal cases. Essentially, it was a client which was considered to be a difficult client for the banks to give credit to, correct? As you correctly said.
Right. At that point of time.
At that point of the time, which is September 2021, we are talking about. Yeah.
Right. Right.
Between September 2021 to January 2022, nothing as such changed in Mr. Sethi's corporate outlook. He was the same Mr. Sethi that you had not been able to secure a credit facility for, correct?
No, there have been subsequent changes, and these changes were when we approach. Now we come to the point of engagement and the assignment that we have, where this entire case originates.
So we will come to that, but in terms of his credit worthiness, the ongoing legal cases were still going on. The issue with central bank had not changed, had downgraded his company, and there was negative feedback. Nothing had improved on these 3 fronts, correct?
No, things have changed. Things were improved, and that's why, because we had those kind of justifications to our satisfaction provided by Mr. Ajay Sethi, we went ahead and we provided those justifications to ENBD, and they were convinced, and hence they approved this facility.
I understand that, but there were still ongoing legal cases, correct?
No, not those cases, because he has provided sufficient evidences whereby it was to the satisfaction and it was outside the purview of the credit application.
Essentially, what you're saying, Mr. Khan, that subsequently there were banks who had maybe a different risk appetite compared to the ones previously, correct?
Different risk appetite, and at the same time different structure. The kind of structure that we went to ENBD were purely a real estate transactions collateralized against real estate collateral and ring-fenced against the rental incomes.
Okay. Now, if I ask you to go to section A, please, and number 8.
Can you please tell me the page number?
Yes, I'll tell you the page number is 152. So 152, this is the, sorry, 157, I beg your pardon, because there are two, 157.
Okay.
So this is the engagement letter, which is the subject of dispute today, okay?
Correct.
This is an engagement letter that was signed by you with Mr. Sethi, correct?
Correct.
You agree that for just for clarification purposes, that Channel 2 Corporation is not a defendant in these proceedings, correct?
Is not a
Channel 2 Corporation, Group Corporation is not a defendant, correct?
Well, the way we see it is Mr. Ajay Sethi and Channel 2 Corporation, which is 100% owned by Mr. Ajay Sethi. And hence we have put Ajay Sethi / Channel 2 because there have been initially a discussion to get some working capital for Channel 2.
But Mr. Khan, your claim form suggests that there's only one claimant, is Mr. Sethi,
which is Ajay Sethi.
which you would agree is not Channel 2 Group Corporation.
That's true.
So you signed the engagement letter on behalf of the claimant on the 7th. And then Mr. Sethi signed the engagement letter as a chairman of Channel 2, correct?
Correct.
And you say that it was both on behalf of Mr. Sethi and on behalf of Channel 2, correct?
That's correct.
And the engagement letter was drafted by the claimant, correct?
Correct.
And you will agree that the main purpose of the engagement letter is set out at clause 1 of the engagement letter, right?
Right.
Restructuring of the existing debt, the purchase of 49 apartments in Barsha Heights, and seeking of working capital facilities for Channel 2 Group, correct?
Correct.
That was the overall commercial context for why you were basically taking this mandate, correct?
Correct.
And then the scope of works in clause 1 provides what were your responsibilities and obligations under this mandate or agreement or whatever we call it, engagement letter. It was to prepare to receive all the documentation which the banks would need to see before they would be interested in offering a loan to Mr. Sethi, correct?
Correct.
And then it will also assist Mr. Sethi in negotiating and concluding the mandate, which will achieve drawdown of a debt facility, correct?
Well, drawdowns are subject to fulfillment of certain conditions, which were laid out categorically in facility offer letter. And those fulfillment of conditions are the pure responsibility of our client, Mr. Ajay Sethi.
So the scope of work says at clause 1G that during the advisory period, the advisor shall advise the client, okay, and then advisor shall undertake to perform the following activities, which includes number G, assist the client in negotiating and concluding the mandate with counterparties. So conclusion of the mandate means a transaction would achieve its intended purpose, which is a restructuring of the existing debt, acquisition of 249 apartments. So there will be debt facility for that purpose, commercial purpose, correct?
Correct. But that means that we have to facilitate Mr. Ajay Sethi in a way that he gets approval. Now, fulfillment of the approval conditions, it's his pure responsibility.
But the documents essentially, as Mr. Farouk said in his witness evidence, essentially when His Excellency asked Mr. Farouk that essentially all the documentation in Schedule 1, you would have seen that in preparation for seeking an approval, correct?
Right.
And essentially, but it is up to the bank whether to give a mandate to the to allow for a drawdown to happen based on that information, because their purview is that it's just a suggested non-exhaustive list of conditions. They could ask for any condition precedents at any point before they decide to make a drawdown, correct?
No, I disagree. And the reason is, if I may.
Yes, please go ahead.
The reason is that bank has all the right, and it is clearly mentioned in the documentation that Mr. Ajay Sethi has signed, that bank wants to have information to their satisfaction. Now, if any client provides at any point of time information requested by the bank which is not up to their satisfaction, bank has all the right to ask for more information till the time they are satisfied with that information.
in terms of the engagement letter that we have, it was specifically to seek financing of debt facility from EIB, Emirates Islamic Bank, correct?
In writing, yes.
And then at some other point when you were unable to seek the debt facility from EIB, you went back to ENBD where you had previously gone, correct?
Correct.
So
After having a verbal agreement, and we have so many evidences which we have submitted to the Honorable Court that Mr. Ajay Sethi has given full consent for us approaching ENBD.
in fact, isn't it correct that Emirates Islamic Bank had raised credit and compliance concerns with respect to the defendant, correct?
There were certain concerns, yes.
So if I take you to your witness statement, which is at section E, okay? And section E, number 2, page number 314.
Yeah.
So which at paragraph 10, if I read that for you,
Yeah.
you say that we were appointed by defendant to arrange banking facilities from Emirates Islamic Bank based on the commercial criteria that we have talked about. The defendant highlighted to us the importance of acquiring the apartments. Unfortunately, it could not occur through Emirates Islamic Bank since the bank had raised credit and compliance concerns on the defendant. So there were concerns already even at that stage of this engagement letter that Mr. Sethi's credit position was to say in an English context was wobbly, was not very good, correct?
Correct. And if I may elaborate on this,
Yes,
the
please.
reason that they found out, because they have access to other banking partners, credit history, and through various system sharing that banks have, they found out that at that point of time, Ajay Sethi has defaulted on certain installments with DIB. Okay. Now, when this thing was brought to our notice and we went back to Mr. Ajay Sethi and we were approaching ENBD, Mr. Ajay Sethi assured us that he has cleared all the past dues and the matter has been resolved.
Okay, and that's very helpful. Thank you. Essentially, ENBD, based on your previous attempts to seek that facility from, was aware of Mr. Sethi's problems, let's say credit issues, and it was not something that they were seeing afresh. Isn't that right?
Well, this facility, considering this facility that we were approaching, the way it was presented to the bank was convinced in terms of the collateral coverage that they have and in terms of the repayment ability through rental assignments. So they were pretty much okay from a credit perspective, as long as they have been adhered to that this credit will be defined as a good credit.
But essentially the rental income that they were looking at was from the prospective purchase of the 49 apartments, correct?
Yeah, because Mr. Ajay Sethi has provided the historical rental, generation, and through the valuation report, it was categorically established the ability of these 49 apartments that the rental income would generate, which would be sufficient to repay the loan.
So at the time you entered into the agreement, you clearly understood the difficulty of seeking this debt facility for Mr. Sethi, and you understood that the debt facility was firmly linked to the commercial context that Mr. Sethi was going to use this debt facility for, correct?
Correct. with the assumption that Mr. Sethi would abide by all the conditions precedent stated in the offer letter, which he accepted that he would be able to furnish and fulfill in the utmost manner, that bank would be satisfied.
But based on the testimony that we have heard today of Mr. Farouk, it's the condition precedents, documents and information. This would be pretty much viewed by you before you seek approval from the bank for a loan, correct?
Yes, but let me elaborate, Mr. Salah. Because I, being a banker, perhaps I can explain it in the right manner and in the most practical manner banks generally look at, and the various functions that each within the bank, each unit is responsible. There are typically two main functions. The first one is the business, whereby the business is the interface and the point of contact where they interact with clients, gather information. They have been told to submit a credit proposal to credit committee in a prescribed format, which each bank has its own. Now, once that prescribed presentation or a credit application reaches a credit committee, the credit role is to ensure that all the risk elements are addressed. Now, based on that, the credit takes a decision to approve or to decline a transaction. Once the credit approves a credit application, they state categorically certain conditions subsequent to approval. Whereby, in this case, just to give you an example, a mortgage was an example, assignment of rental income was an example, providing insurance was an example, providing Ajay Sethi was supposed to provide a good conduct from other banks was a condition. Now, these are the conditions that the credit department instructs to the second department, which is post-credit. And this department is called credit administration, and they simply have to follow the instructions laid out in the approval conditions. If any of the approval conditions are not met, okay, they will not disperse the loan. So it's as simple as that. I have been hearing you, Mr. Salah, with all due respect, that you have been considering this facility as a term sheet, which is not the case. Because
no, we will come to that. So sorry, if you don't mind, we will come to that. It's more helpful if we do this in a more structured manner.
Please.
So now, because so where was I? So if I take you back now to section A, number 8, back to the engagement letter at 157.
Yeah.
Let me know when you're there.
Yeah, I'm here.
Okay. Now, if I take you to page 159, okay.
157 or 159?
Sorry, 158. I'm terribly sorry. 158.
Sorry?
158.
Okay.
It's the next page. Essentially, in this engagement letter, it appears that you were more interested in seeking payment by way of a success fee, and because that's what the assignment fee was 0, that means no fee would be payable upon entering into the engagement letter, and all fees you would get would be by way of success fee, correct?
Correct.
So success fee payable to the claimant was 2% of the total project facility approved by the lender, correct?
Correct.
That's what it says. And it further says that the project facility approved by the lender meant the amount of credit facilities sanctioned by let's say by the bank, correct?
Right.
So therefore, isn't it correct that the defendant under the engagement letter agreed to pay the success fee to the claimant only when the funds under the debt facility were approved, sanctioned, and capable of being drawn down by the defendant, correct?
I disagree.
Given the commercial purpose behind the debt facility, you would agree that the commercial common sense here is that 2% success fee would be payable only if the debt facility was sanctioned by the bank, which means that the facility was approved and available for drawdown for the commercial purpose, correct?
I disagree. Because my mandate categorically says that Mr. Ajay Sethi has to pay us either on the date of signing or 30 days from the drawdown, whichever is earlier.
That is the issue of timing. That is separate from when success fee becomes.
So I am, as I have mentioned to you, Mr. Sandar, that as financial advisors to Mr. Ajay Sethi, our role was very specific, very categorical to facilitate him in getting the approval. This is purely his responsibility to fulfill and furnish and satisfy the bank subsequent to credit approval. Now, if he is unable to provide, just for example, good conduct from other bank, it's not my responsibility. If he fails to furnish proper rental assignments, not my responsibility. If he fails to in mortgaging the property, it's not my problem. It's outside the scope of my mandate. My mandate categorically and specifically mentions for a specific facility, for a specific amount, for a specific time that I have to get him the credit approval, which we did it as mentioned in this.
Can I stop you there, please? I just need to ask you questions. It's helpful if you just answer the question.
Mr. Mato, if you allow me.
Yes, please.
I would like to clarify from the witness in regard if this is assignment fees, and because I can see for the previous 2 years, they used to charge the client, which is the defendant, an assignment fees. We understand the assignment fee is not just for the signing, but I'm sure there is a work and some due diligence to be carried out by maybe the firm. But for this last agreement, which is the subject of this dispute, you choose not to charge any assignment fees, but you just jump into the success fees directly. Can I ask you why this pattern changed this time? I mean, now the assignment became like without any fees, but then the success fees is the only rewarding or the consideration for you.
His Excellency, this is purely a commercial decision, and generally it happens because this was perhaps a couple of mandates that we have signed with Mr. Ajay Sethi. We have understood, we had that relationship. So considering that, we thought that, okay, when we were entering into this mandate, we believed that we had all the necessary information, and we were quite convinced that we should be able to get the approval that our client is looking for. So purely out of commercial consideration and on a relationship perspective, we agreed that, okay, we will not charge Mr. Ajay Sethi an assignment fee on this transaction.
Mr. Mato.
Thank you, Excellency. So now I would like to talk about the timing part of the success fee. Once the success fee becomes crystallizes, i.e. that banks have sanctioned the debt facility, and it means that the commercial purpose of the transaction would be met. We say that at that point, the client, i.e. the defendant, is to pay Fursa success fees within 30 days from the date of signing of the facility offer letter or facility drawdown, whichever is earlier. That's what it says, correct?
That's correct.
So essentially, drawdown, the successful transaction and the signing of the facility offer letter would mean payment of success fee only if the facility offer letter on the day it was signed is capable of drawdown, correct?
Correct.
So it's the drawdown which is the central part of the success fee, correct?
No, I disagree. Because I again reiterate and go back to my earlier statement. Our scope is specifically to facilitate client in getting the credit approval. Fulfillment of conditions stated in the facility offer letter, which will lead to drawdown, is purely the responsibility of the client. If the client fails to furnish and satisfy the bank to meet those conditions stated in the facility offer letter, this is outside our scope, and our fee becomes payable.
But Mr. Khan, the conditions which we will look at, I show you in a moment, that are set out in Schedule 1 as credit conditions precedent, they were not exhausted. At a later date in June 2022, they asked for further documents and information which went beyond that, correct?
Can we be specific, Mr. Salah, so
Well,
that
maybe perhaps it's better for us to come look at it later.
Sure.
But I'll pick up that point there. So
Sure.
Without the defendant being able to draw down from the debt facility, there would be no successful transaction, because commercially, for defendant, successful transaction means if he's able to do what he intended to do under this engagement, correct?
Sorry, I missed your question. If you can repeat that.
From the perspective of the defendant, a successful transaction means that he is able to draw down on the facility and fulfill the commercial purpose of the agreement, correct?
I disagree, because I will refrain myself within the scope of my mandate, and which the client has signed, and he exactly know what was the scope that I have to deliver.
Essentially, success fee would be payable if on the date of the signing of the facility offer letter, drawdown happens automatically. That's the scenario we're looking at, the timing of the payment of success fee. Either it happens upon signing, and simultaneously on the same day there will be drawdown, or a drawdown at a later date, whichever happens earlier, correct?
Yes, provided all the conditions stated in the facility offer letter, which has been accepted by the client, are fulfilled.
But the condition in the facility offer letter would be already seen by you, and you would have seen all the material documents based on which you would have provided information to the bank, to the credit committee, correct?
Mr. Salah, once again, with all due respect, I think we are just lingering on the same point, and we are mixing credit conditions and the post-credit conditions. What you are referring is always the post-credit conditions. Credit approval have been, once the credit approval is there, subsequent to that, a facility offer letter is issued. Now, in that facility offer letter, there are certain conditions to be fulfilled to get the drawdown. So and this is a normal banking practice across globe.
So you and I agree.
This, if I may, you cannot say that the credit conditions, it was not a fully approved facility. It was a fully approved facility subject to fulfillment of certain conditions based on which drawdown will happen.
You and I agree.
Mr. Khan, Mr. Matt, if you allow me,
please.
When you said there, open a successful transaction or draw down, which earlier or which come first, you mean? Can anyone imagine the drawdown would come first, the signing of the facility offer? Is that possible? Like, is that good writing? I mean,
It's not possible.
from your experience, can the drawdown happen before the signing of the facility offer?
No, sir. His Excellency, it's not possible.
And then what's the purpose of when you said it's which come first, or which happened earlier?
His Excellency, if I may be given a chance to elaborate.
That's why I asked you.
Yes. His Excellency, the scope and the framework based on which it was phrased like this, that getting a facility letter, signing the facility offer letter, or facility drawdown. There are two separate things. Facility approval letter means that the facility is approved by the bank. Now the drawdown is subject to fulfilling certain conditions. For example, a client has to provide his valid trade license. Now, in some scenario, due to whatever reason, the client fails to furnish a valid trade license.
No, I understand this. And my question is very simple. Can the drawdown happen before the signing of the facility?
It cannot.
It cannot. Thank you.
Your Excellency, you stole my thunder. Was my next question.
I'm sorry. I'm very sorry.
No. You were more eloquent than I was, so I thank you for that. Can we now turn to clause 6 of this agreement, which is on page 160?
Yeah.
So this is the termination provision, correct?
Right.
And termination provision, it says that when you look at this, the first paragraph only, you would agree that the engagement letter would automatically terminate upon financial close of the transaction or on the 90 days anniversary of the letter of mandate, which is the engagement letter. Whatever happens earlier, again, whether it's the 90 days anniversary or the financial close. So whatever happens earlier, it terminates at the earlier event, correct?
Okay.
So since there was no financial close of the transaction, no debt facility was approved or sanctioned or capable of drawdown by EIB or ENBD. So there was no financial close here, correct?
I disagree. There was a financial closure. Our scope was to get a facility offer letter, which we got and client accepted.
Mr. Khan, it talks about financial close of the transaction. It's
No,
not talking about financial close of the...
Financial closure always refers to the scope.
Well, I would beg to differ, because you would agree that this clause does not talk about financial close of the mandate letter or any other facility letter. It talks about the transaction, meaning the whole purpose of the transaction was to achieve a debt facility which would allow the defendant to do what he wanted to do by way of a debt facility, correct?
Mr. Salah, I disagree. Mr. Salah, with all due respect, I have stated multiple times, my partner has stated multiple times, fulfillment of drawdown conditions are beyond our scope.
And you would agree that the letter terminated on 7th of April 2022 on the basis of 90 days anniversary of the letter of mandate, correct?
Correct, because we fulfilled our scope and we delivered as per the scope, which client accepted.
But however, we disagree on that point, because
you said the scope is the signing this facility agreement. Mr. Khan?
Yes, His Excellency.
Your Excellency, do you have any further questions?
No, you go ahead, please.
So, sorry, I just want to pick up on that. If we go back to the scope, Mr. Khan, on clause 1, scope is wider than that, isn't it? It's to assist the client in negotiating and concluding the mandate with the counterparties. And concluding the mandate means meeting the whole purpose of the transaction. That's the whole purpose. The client didn't come to you so that they can just get a agreement which is not capable of getting them commercial purpose. People come to you for commercial purpose, not to basically collect pieces of paper, correct?
I disagree. Mr. Salah,
well, we have to agree to disagree then. We say that if the engagement letter automatically terminated on 7th of April 2022 because there was no successful financial transaction, i.e. there was no financial close of a transaction, the claimant has no claim for success fee under the agreement, correct?
No, I disagree, Mr. Salah. This is your interpretation of financial closure. Our interpretation of financial closure is that we facilitate the client in getting a credit facility approved, and the client accepts that, which he did.
Mr. Khan, I think Mr. Salah, if you allow me, I'm reframing. Mr. Salah, question. And he said, and I mean, in order to close the signing, you should have conclude the mandate with the counterparty, with the banks.
That's correct.
And the mandate, Mr. Salah would like to refer to, which comes in Schedule A, and then which comes later in an email to. He said, Mr. Salah said, these are mandates with the counterparty, which is the bank. And it's in the scope of work. So he said, you cannot say, I have concluded my work unless you have done this too. Is that right? That's what you want to deliver, Mr. Salah? So, am I right?
That's correct.
Your
Excellency, you've gotten it absolutely correct.
Yeah, you got it, Mr. Khan. You can answer now.
His Excellency, yes, I understand what from where Mr. Salah is coming, but our point of view is that we have a very defined scope, and our scope was to facilitate the client in getting a credit facility approved from a bank, and which we successfully did, which was accepted by the client. And, you know, in the approval conditions, there were certain conditions which were again accepted by the client to furnish that. Now, if, just to give you an example so that it becomes easier, now if one of the conditions states that the client has to provide a good conduct of account, and if a client fails to do that, this is beyond my scope. And because this condition is not met, bank is not going to do the drawdown. But it should not be, I should be qualified as if I have failed. This is something which is beyond my scope and beyond my means. The client has to furnish those conditions which he has to furnish post accepting the approval conditions offered by the bank, or post offering a facility which the client has accepted. Now, if he furnishes to furnish any of the conditions, certainly the drawdown will be halted. And this is the case.
And then what is the situation that you should have assist your client in complying with the bank later requirement? It's like, this is what Mr. Salah trying to say. It's your duty, it's your scope of work. You should assist him to do so. I mean, you just say, you just, as he said, you're blaming him for failure to deliver the requirement. But did you assist him in doing so?
His Excellency, if he has to get a good conduct of account, I cannot bring that. It's only him who has to get his conduct of account. And if, I'm just giving an example, and if his conduct of account is good, he will get a good conduct of account. It's nothing much I can do in that. Now, if he has to give a mortgage as a collateral, he has to give mortgage. I cannot provide that mortgage. He has to provide that mortgage. If he has to provide insurance, he has to provide that insurance. So those conditions he has to fulfill. Now, to get an approval to the stage to convince credit, to provide necessary information, to provide the information in the right manner that a bank would like. We have done that, and that was our scope. And hence, bank was convinced to approve and offer a facility letter, which he was willingly, he accepted that. There were certain conditions which again he accepted that he will fulfill that. Now he has to fulfill those. These are those conditions which are beyond my scope. I cannot get a good conduct of account on his behalf. So these are those conditions which is beyond the scope of my role.
Thank you, Mr.
Okay. Thank you, Your Excellency, for your intervention. I would like to go back to clause number 2, if I may, which is at page 158. Okay.
The next page, yes.
Yeah.
So you would agree, I mean, this should be a non-controversial point, but it has been pleaded by your lawyer, so I have to bring this to your attention. The last paragraph of clause 2 says, it is further agreed between parties that in the event...
Mr. Salah, are you referring page 158?
Yes, 158.
Okay.
It's the last paragraph of clause 2. It says, it is further agreed between parties.
There is no clause 2 on 158. That's on page 157, I guess.
No, clause 2 is on 158 of number section A, number 8, 158.
Okay, go ahead.
Anyway, wherever you can see clause 8, you can read it.
So it is further agreed between the parties that in the event the advisor shall have signed a facility offer letter for the project facilities from the bank, then there's a different kind of you would be entitled to damages as such, you know. So you would agree with me that the facility letter was not signed by the claimant, correct?
This is a typo. This has to be, instead of advisor, it has to be client.
Well, it is what it says. It says advisor twice in this.
You're right. You're right. You're right, but this is a typo.
But it's your document, Mr. Khan. I mean, you drafted it, correct?
That's fine. That's fine. That's fine. But in true spirit, it has to be client.
Well, it mentions client and advisor in different.
This is that's fine.
Yeah. So we agree that the facility letter was not signed by the claimant, correct?
It's not true. It was not signed by the claimant. It was signed by the client defendant.
Correct. And hence this scenario in the last paragraph of clause 2 is not triggered in the present dispute, correct?
That's true.
Okay. Now, if we go further down to the facility letter, which is at page 162.
Yeah.
So at 162, could I ask, since we can't keep this 2 pages simultaneously open, because I would like to basically, okay, first, I'm sorry I took you there, but I would like to first take you to, before we come back to this, to section E, number 9, page 443.
Yes.
Okay. This, if I take you to the bottom end of the email, it says this is the 11th of March 2022 email from ENBD, where they are informing you that they have approved 46 million term loans, 2 term loans, subject to the conditions A to N, and then it says the above list is not exhaustive. There will be further terms and conditions covered in facility offer letter, correct?
Correct.
And it's you agree with me that the offer that they have made of approved to 46 million AED of lending of loan was subject to specific conditions that they had set out, correct?
That's correct.
Now, if I ask you, if we go back to the facility letter now, which is at number 8, section A, number 8, 162. Let me know when you're there.
Yeah, I'm there.
Okay, great. So this is the facility letter that was issued by ENBD, correct? And then we look at these. I just want to show you, to begin with, in Schedule 1, which was a condition precedent. Okay. Now, if we go to number 9 of the condition precedent, okay, it talks about.
Refer to some other page.
Sorry, 174. It's the condition precedent.
Yeah.
It's a Schedule 1. So it says that, one of the condition precedent is copy of insurance policies towards properties with assignment of rentals.
Mr. Salah, I think you are referring to 173, not 174.
No, 174. It's paragraph number 9.
Okay. Copy of insurance policy.
For properties which were not yet purchased by the defendant.
Yeah.
So this was not capable of being fulfilled, correct?
Yeah, this was subject to doing the Mr. Salah, there is again a process here is that, and we all know that first the property has to be transferred in the name of Mr. Ajay Sethi, and then he has to get the insurance policy in his name.
But can I stop you there for a second? How can Mr. Sethi purchase an insurance policy for a property that he didn't own at that point, because he needed the money, the debt facility, to buy this property?
It doesn't say that he has to provide. It says that they have to provide a copy.
But
it doesn't say that he has to provide before.
Without the condition precedent, the debt facility would not be sanctioned by the bank.
Mr. Salah, again you are mixing. Approval conditions has nothing to do with the disbursement conditions.
Okay, let's we can talk a different language here.
Mr. Salah, you have to understand, because these are globally accepted mechanism in the banking industry.
Okay, can I stop you there?
Sure.
I've heard that. So without the condition precedent, there will be no drawdown, correct?
Absolutely, and this was accepted by Mr. Ajay Sethi.
So this number 9, copy of insurance policy for properties that Mr. Sethi was going to buy with the debt facility, he could not have gotten a copy of insurance policy for those properties, because he didn't own them. He didn't have title to them.
Mr. Salah, what's behind the question?
So the question, Your Excellency, is number 9, condition number 9 was.
This is the bank documents, yeah? It's a bank.
No. Was to procure insurance policy towards properties of assignment of rentals, and the problem is Mr. Sethi could not have procured this because he didn't own these properties. He would have been able to do so once he had gotten money from them.
Let's suppose you're right. What's next? What would happen?
So, I beg your pardon, Your Excellency, I couldn't hear that clearly.
I mean, let's suppose you're right. No way he can get that. And then what's next? I mean,
either it would have to be waived, or somebody would have had to basically, and I think Mr. Sethi did mention at some later point that this is not possible. So there were many issues with this mandate, because they were unable to close this transaction, because they kept on asking for things all the time. So this, as you will see in the cross-examination, I'll put that to Mr. Khan, that the way the ENBD was looking at this transaction was not from a point of view of drawdown. It was still evaluating this client, whether it's credit worthy or not.
His Excellency, if I may give my point of view.
Please, yes.
Okay. This is a very normal thing. Mr. Salah, I'll give you a brief example, okay, so that you can understand it. You approach a bank for a car finance. The bank gives you an approval that, okay, Mr. Salah, go ahead. We will simultaneously, you know, this is the provision. And the same thing goes for real estate transactions also. Globally, you have to mortgage the car in favor of the bank, and you have to provide insurance loss pay to the bank. You have to make loss pay the lender. This is now by your logic, then no car financing can happen in the entire world. The same logic goes here in the real estate. When you go to land department, simultaneously, when the title deeds are changed, the bank makes a payment. And subsequent to that, then the insurance comes into play. So in other words, if I understand from you, you mean to say that whatever form of asset financing is happening just simply cannot happen because nobody owns the asset and hence cannot provide the insurance policy. So the same logic goes for this transaction, that Mr. Ajay Sethi, who, as you have mentioned and we all know, is an astute businessman, he do understand that he has to go, and the process is go to the land department, get the title deed done, the banker will come there, will pay the manager's check, the property ownership will change, and simultaneously it will be mortgaged to the bank. Once the property is mortgaged to the bank, then comes the second step of insurance, and the insurance company will provide the insurance. So it's as simple as that.
No, I'm not disputing that, Mr. Khan.
Allow me to complete. There is no rocket science that we are doing, or this is the first transaction that's happening in the entire globe. These are all things that client knows, and everybody knows that these are the things that they have to do. And similarly, if you see the point number 5 is the point where bank is saying to get the property mortgaged, and then comes the insurance policy. So first, property has to be transferred in Mr. Ajay Sethi's name, and then he has to provide an insurance policy where the bank is a loss pay. As simple as that.
You're precisely making my point, Mr. Khan. You're precisely making my point. And thank you for that clarification.
And the bank has given a timeline within which he has to furnish these documents. Because the bank is not saying that he has to furnish everything upfront. The bank has given him time to provide.
No, but Mr. Khan, you know, the current facility, the debt facility will not be available until he meets the condition precedent. No. That's what it says.
So that is, Mr. Salah, how does real estate transactions are happening in the globe? So these are typical common things, you know, when a person goes to buy a house, he has to get the property mortgaged as well as get the insurance in favor of the bank.
But
Mr.
Khan, that's a condition subsequent. But this is a condition precedent.
Mr. Khan, you're repeating yourself. We understand you, sir. You said it's a market norm and it makes sense, commercial sense.
His Excellency, my last point, and then I will, Mr. Salah can make his point. You know, the bank no way is saying that they have to furnish everything upfront. The bank has given a time limit within which Mr. Ajay Sethi has to furnish this. So as simple as
with all due respect, Mr. Khan, these are condition. If there was a condition subsequent, that could be understood. But I've also done my share of transactional work in real estate.
And one more thing. This is very
Please go ahead. Please go ahead.
Mr. Salah, a very important point that I'm to make here is that the insurance policy that is being referred here are not the 49 apartments that Mr. Ajay Sethi is going to buy. The bank refers to the 4 apartments that Mr. Ajay Sethi already owns. So the bank is asking for those properties which is already in the name of Mr. Ajay Sethi to give insurance policy.
Well, we have to
No, it
for
is there.
example,
It is a fact. It is a fact, Mr. Salah, that the bank is asking the insurance policy of those properties which is already in the name of the client.
okay, so I will
Thank you.
explain to you further issue with this. Now, if we look at number 13 condition precedent, updated list of rentals, including rental agreements for 49 units located at Barsha Heights to be provided. Well, he didn't own them, so how can he have any rental agreements?
No, he has provided. He understands because, as you say, and we all know that he is an astute businessman. He has done a cash flow analysis. He has assessed that the rental income of this property now and the way forward, and he completely knows, and he has all the right.
Sorry, Mr. Khan, I have to stop you there, please.
Please.
Rental agreements for properties that he does not own, he's not capable of producing them as a condition precedent before he buys them.
No, but which clause are you referring to?
Number 13.
Okay. Fine. You know, there is no, there's absolutely no problem in getting a copy of the Ijaris because Mr. Ajay Sethi, as part of his due diligence, also wanted to ensure that whatever the seller is saying in terms of the rental cash flows is correct or not. And that can only be evidenced by having a copy of the rental agreement.
I mean, I
see
your point.
And there is no problem.
I see
and
your
there is
point,
no problem.
But this is not your document. You'd agree with that, right? So you don't necessarily control the language of this document.
But there is no harm in getting this, and there is no limitation in getting this rental agreement.
Well, he will not have access to it unless he basically, on what basis can he get it?
No, everybody does this due diligence. Otherwise, Mr. Salah, if I go and say that this is the X rental income, there has to be some supporting document to justify that. And that is in the form of the rental income or Ijaris, what we have here.
But in any event,
the very basic document. It's as simple as that.
This is not a material point for us.
When you say this is as simple as that, when you say that the company has having a turnover of X amount, that is substantiated and supported by the balance sheet.
Okay.
Next question, Mr.
After signing the facility agreement on 30th of March, without fulfilling the ever increasing lists of conditions and information requested, defendant could not restructure the debt, acquire 49 apartments, or draw down any of the facility, correct?
Sorry, come up again.
Without fulfilling the conditions precedent as Schedule 1, defendant could not restructure the debt, acquire 49 apartments, and draw down the facility, correct?
That's true. And Mr. Salah, I just recalled Mr. Ajay Sethi has submitted the rental agreements. So there is no problem. He has already submitted.
Fine. I mean, sorry, that was not the answer to my question.
No, I answered that first, and then I just justified that he has already provided the rental agreements.
Because technically, if I now that I think about this in terms of the structure of these Barsha apartments, it was capable of getting rental agreements technically because it was a hotel apartment. But anyway, it's not a material point. The point is that after signing the facility agreement, you agreed with me that defendant could not have restructured the debt without fulfilling the condition precedent or bought the 49 apartments in Barsha Heights, correct?
Mr. Salah, there was no restructuring. There was acquisition financing.
There was a restructuring also. He was trying to basically refinance his debt with DIB, correct?
That is for 80 million, but we are talking about 49 units.
No,
right?
we are talking about 46 million. That's what the whole purpose of the facility agreement is.
Right.
Correct?
You're right. If any of the conditions which was for the disbursement requirements were not fulfilled or client failed to furnish that, there could not have been any drawdown.
Yeah, okay. Now, if I take you to the facility agreement further up, if we first look at the loan facility, the first one, 18 million one, okay?
Which page is it, please?
It's 163.
Yeah.
Okay, so it talks about 18 million to buy out existing liabilities from Dubai Islamic Bank. We talked about this, right? And it will be available for 90 days, which means that this offer is capable of being formed as a binding contract if the condition precedents are met within 90 days, correct?
Correct.
And the 90 days will expire on 30th of June 2022, correct?
I think from the date of
So the 30th of March, Mr. Sethi signed it.
yeah, okay.
Yeah, I mean, it's not a, I'm not, I mean, it's fairly straightforward. And then if you go further down on page 164, the loan for purchasing the real estate, the 49 apartments, right? That had an availability period of 6 months for the facility agreement to become binding, for them to provide, all the conditions precedent that will fulfill this part, correct?
Right.
So if the facility agreement, this is not an agreement, this is a facility letter, offer letter, stated that the facility offer would only be approved, will only be, what we say approved, you say disbursed, okay, will only be capable of becoming a debt facility which the defendant can draw down on. It is only possible if they fulfilled every condition of the bank, whether in Schedule 1 or any other condition that they put on it, correct?
Yeah, correct in a way, but both the conditions have their own independent collaterals and conditions to fulfill, and the drawdown under each facility it was possible.
And the bank would look at all the information that Mr. Sethi would provide and see whether they will they're still comfortable to give him the loan that they had, as you say, approved subject to the conditions, correct?
As long as the disbursement conditions are met in each of the two facilities, the bank was ready to do the disbursement.
But my question, Mr. Khan, is this: if the bank had the capacity or the power to decline the drawdown based on the conditions precedent, if they saw by way of documents provided and information provided by way of condition precedent, and they didn't like what they see.
Yes, if the bank was not satisfied, then either the bank would have asked for more information or the bank would have taken their own decision to decline.
The bank, in fact, would have even asked to revalue something if they feel valuation, according to them, needs to be a second opinion on valuation, correct?
Absolutely, and absolutely, just to satisfy, if there are so many ways to satisfy a given situation. If one set of information is not coming to the satisfaction, the bank might ask other questions to satisfy.
So based on the offer set out in the facility letter, it was essential for a binding contract between the bank and the defendant that bank is satisfied of the collateral terms that the defendant provides. Otherwise, they would not want to basically have a binding contract with him, correct? That's why there's a provision to lapse the agreement, correct?
I disagree.
Okay. So the amount of success fee at the time of signing the facility agreements was 0 because no amount of debt facility was sanctioned and by the bank, and there was no drawdown capable at the time of signing of the facility letter. Correct?
Sorry, I didn't get your question.
I will repeat it. It's an important question. The amount of success fee payable at the time of signing of the facility letter was 0, because no amount of debt facility was sanctioned by the bank, which was capable of being drawn down. Correct?
Mr. Salah, I beg to differ. Their facility was approved. It was not dispersed because there were certain conditions to fulfill. And because there were certain conditions to fulfill, we agreed with the client that there has to be a limit, a time frame within which we have to be paid because we have fulfilled and we have delivered within the scope. So hence it was agreed that either at the time of signing of facility offer letter or drawdown, whichever happens within 30 days. Because if you see, this offer letter has got a validity. Now, Mr. Ajay Sethi has all the liberty to take it to the last day of the validity of and then sign it. So we wanted to limit, as we have delivered our scope and there was nothing else for us to deliver. So we agreed mutually that the time of 30 days to be put in place by which we will get a payment.
No amount of debt facility was sanctioned by the bank when it issued the facility letter because it had not yet. Sorry, can I please complete my question?
Sure.
No amount of debt facility was sanctioned by the bank when it issued the facility letter because the bank had not yet ascertained whether Mr. Sethi or i.e. the defendant should be provided this loan because they had not satisfied whether the collateral information and other information that he would provide would satisfy their creditworthiness criteria, correct?
I disagree, but I would like to ask from you, Mr. Salah,
it doesn't work like that.
Just for me to understand, Mr. Salah, I'm just...
Mr. Khan...
No, you didn't ask Mr. Khan. Mr. Razak here to assist you.
Sure.
Your counsel will ask you for redirection, and then
sure.
She will ask you for the questions. You know, it's my role is only to basically ask you questions, Mr. Khan. You know, I wish I'm not as knowledgeable as you, so I'm not sure if I can help you. You know.
Please go ahead. Sure.
So a credit committee of ENBD would normally review all the documents requested by ENBD by way of conditions precedent, and then confirm whether the terms of loan are met, correct?
No, not correct. Credit committee will never get into this state. This is the responsibility of the credit administration to ensure that they fulfill all the documents as stated in the credit approval.
So if between the time the credit committee has approved the loan and between the disbursement, if there's been some changes, would this committee not bring this to the attention of the credit committee?
It's the business unit who will then again take it back to the credit committee that there have been certain deviations or there have been certain limitations.
So there will be an interactive process between credit committee and administrative credit committee, correct?
If this the situation warrants that, but if a client is blatantly or just not able to furnish a given condition, then that means there is a breach of the offer letter, and the bank will not be able to entertain or give any relaxation. It depends what the situation is.
But you would agree for a client like Mr. Sethi, who is going through financial difficulties, which you had yourself witnessed from the feedback from other banks, including from ENBD, who had twice declined to provide him a facility offer letter in 2021. It would be expected from that fragile COVID period that we were in, banks to be a bit more careful who they give this kind of money to. And 46 million is a lot of money to be given to someone.
Well, as I mentioned earlier, this credit was approved purely based on the strength of the collateral provided and the cash flow provided. So it was ring fenced, and there was absolutely no issue on the credit approval or credit concerns.
But notwithstanding the decision of the credit committee, Ian, the bank was not willing to give a drawdown, correct?
Because the client didn't furnish the conditions stated.
Well, we say that they provided all the 14 conditions that they were capable of providing, but the bank still wanted further information, and they were insatiable amount of information. So
I disagree.
Well, you're not the bank, so I suppose you
No,
can't
because you're
really
questioning me.
speak on
So
their
if
behalf.
you are questioning me, I disagree to this statement.
Bear with me for a second, Your Excellency.
Sure.
Without sanctioning of the debt facility by ENBD, sanctioning meaning that debt facility being capable of being drawn down, the defendant would not be able to fulfill the commercial purpose of the debt facility set out in clause 1 of the engagement letter, correct?
I disagree.
So without being a drawdown, they would be able to purchase 49 apartments?
I disagree because acquisition of 49 apartments was subject to fulfillment of certain conditions post.
I understand that, but I'm saying without drawdown, there will be no fulfillment of commercial objective of Mr. Sethi, correct?
Absolutely, but drawdown would only have happened if the conditions were met to the satisfaction of the bank.
That's not my question. My question is specifically, if there was no drawdown, there would be no fulfillment of commercial purpose of the engagement letter, correct?
Yeah, correct.
Therefore, you'll agree that no success fee was payable upon issuance of facility letter by ENBD to the claimant because no debt facility drawdown was capable at that time, correct?
I disagree.
After the defendant signed the facility letter, you were liaising with ENBD on behalf of the defendant, correct?
Yes, because the client was telling us to get the information forwarded to the bank, like the valuation report. And the valuation report, the issue came that it was not addressed to the bank, and it was addressed in the name of the client, Mr. Ajay Sethi, and hence we were liaising to ensure that the corrected version whereby the valuation report would be addressed to bank happens, and which eventually did.
Okay. Your Excellency, I just have 15 more minutes of questions, so just to give you some signposting there. So you on behalf of the claimant, you were assisting Mr. Sethi in fulfilling all the condition precedents by way of communication with the bank, correct?
Yeah, whatever he was involving us.
And you, Mr. Khan, were doing this so that there would be a drawdown at the end of this process, correct?
Yeah, but just purely on relationship basis because we had fulfilled our given scope.
Okay. The claimant's scope of work under the engagement letter did not stop at the point of bank providing an offer letter, correct?
Yeah, so we were doing that. We were involved in that.
You should listen to this carefully again. I think you should not agree to this without hearing this properly. The claimant's scope of works under the engagement letter did not stop at the point when the bank provided the offer letter, correct?
Agreed.
Okay. So that means that you were supposed to go beyond the offer letter vis-a-vis the scope of works, correct?
Yes, and we did.
So scope of works, which we have already seen, includes negotiating and concluding the mandate with the bank as such, correct? Yeah.
Right.
So mandate did not conclude until the debt facility was capable of being drawn down, correct?
Correct. But the information has to be provided by the client.
Okay.
We were not supposed to provide any information which was not provided by the client.
Okay.
And we
Thank
cannot.
So can I take you now to section E?
If you can please share
Yeah,
the page number.
section E number 10.
Which page number, please?
Yes, 448.
Yes.
So this is an email from you to Emirates NBD, copying the defendant, in which you say, "Dear so-and-so, Mr. Sushil, reference our last week discussion on drawdown of approved term loan for captioned client. Please note that Mr. Sethi has got all the 49 NOCs and has received the latest liability letter from DIB. Hence has requested to the drawdown of 46 million dirhams on Wednesday, 8th of June 2022. Confirm the drawdown would happen on, kindly confirm the drawdown on 8th June 2022. As Mr. Sethi is expecting the seller specifically traveling to Dubai tonight to complete the transfer of title deeds." So based on this email, you were convinced that drawdown should happen by 8th of June, correct?
Correct. But then at this point of time, Mr. Ajay Sethi was supposed to share some more information, which he was sending, because a couple of information he was sending is directly from his own office through his secretary.
Okay. So if I ask you to, if you can go up the chain of the emails, then they further write to you in June and say, please provide the following ASAP. Some further documents, which basically.
Which page is it, sir?
Sorry, page 447, 448, towards the end of 447. It's the chain, the email chain.
Right.
And then you basically reply to him and say, well, what will be provided shortly, and you basically remind them of things that you had told them in April, and then you basically take care of their queries like that. Right. And then Mr. Marker of ENBD again writes you an email and says he needs 1 to 10 for the drawdown. And this time,
which page is it?
446.
446. Right.
So this time, for example, they come up with quite new, requirements. Number 6.
These are exactly the same thing which is stated in the offer letter.
Not really, because this time they even ask you at paragraph 7, please provide AECB report of Unique Parts Trading LLC, which is the sister company of Mr. Sethi's Channel 2.
Right.
It had nothing to do with Channel 2. You agree with that, right?
Right.
Which was previously
except the common ownership.
Yeah, but so they had no reason to basically provide. It was a completely new thing to be provided to them. Previously, it was not part of the schedule 1 of the facility letter, and here we go. We have a completely new requirement there, and also please submit the bank statements in which rentals of for W43, I think it's the Emirates Hills house, are deposited. So so essentially we were in a situation where conditions present were very fluid as to what was going on, and you yourself had noticed that we I mean the defendant had actually met all the conditions that they were provided the defendant in the facility offer letter, correct? But they were ever changing the goalposts, saying further documents, correct?
I disagree, because the information, what was asked and what was submitted was completely disconnected, and hence all these extra things were coming. The condition was to submit the clear evidence of the rental income of Mr. Ajay Sethi's villa in Emirates Hills. Now, as per the normal norm, the mode of payment and the timing of payment is mentioned in the rental agreement. But what was there and what the evidences were provided were completely disconnected. Hence, the bank asked for bank statement. So this is exactly, Mr. Salah, what we have mentioned earlier. If the conditions are not in line the way bank expects, the bank has the right to ask for more. General situation and a normal situation would be that if the client has rented a property, he gets certain checks and the frequency of the checks are mentioned in the rental agreement. But if the evidence says that those rental checks are never in cash and the mode of payment was something else, then it raises certain questions to provide and satisfy, to show that yes, actually the rental payment is coming. And
so
hence,
essentially, as you said,
but Mr. Salah, I would complete and then I will listen to your next question, because these conditions evolved when asked. There were certain more conditions, but the essence of the main conditions remains the same. That bank wanted to establish that yes, Mr. Ajay Sethi is receiving rental income regularly of the properties he owns. And they were asking the evidence. The evidence that was provided and the actual scenario was completely different. Hence, the bank asked for a couple more questions. And as a result of this, eventually, our client failed to furnish and satisfy the conditions.
So essentially, his credit worthiness was still being evaluated, correct?
Not at all. There was, again, I reiterate, there was nothing to do with credit assessment. It was the fulfillment of drawdown conditions.
But it's the same thing, whether his collateral
failed to furnish to the satisfaction of the bank.
But essentially the point is the same, whether the collateral he was going to give.
No, it is not the same, because it was never ever a conditional approval. The facility of a letter categorically says without any condition that facilities are approved. You have to furnish the following documents to do the drawdown. But if information are in the right manner, then bank has the right to ask for something extra to satisfy.
So can I take you down to section E, number 12, please? If you can go to number 12.
And if you can please take me to the page number.
Yes, certainly. If you can go to page number 459, please. Now, this is an email from Mr. Sethi, is a company colleague, and she's writing to ENBD, expressing her frustration that that they had provided all the information. If you want to familiarize yourself with the email, and drawdown had not happened, and they were at the verge of losing 49 flats deal, which was one of the most important reasons for getting the debt facility. Okay, and it says that that more documents had been asked for, and when they had completed all the procedures with the bank to get the drawdown. So essentially, it shows the frustration, isn't it, that they had fulfilled everything, and the bank still wanted further information. Correct?
No, it's not correct, because in the whole scope of things, you mentioned about unique spare parts. So the bank asked for a good conduct of account from the existing banks, and the loan given by Bank of Baroda, which Mr. Ajay Sethi again had a litigation and it went to the level of execution. Okay, was given in the name of unique spare parts. So the bank wanted to have a good conduct of account from all his existing banks, which included Bank of Baroda. And Bank of Baroda had not given it to Ajay Sethi, had given it to unique spare part. So they just wanted to have a good conduct of account. That's
but you would agree that this was not something they had asked previously, either in the facility
or they did very categorically. They did that. Mr. Ajay Sethi has to provide good conduct of account from all existing banks. So existing bank included Bank of Baroda, who had given loan to unique spare part and not to Ajay Sethi. Unique spare part again is owned by Mr. Ajay Sethi.
Only 39% of it.
Yeah, but he is the active owner. He has got the power of attorney. He is running the show.
Well, I mean, all I would say is that this was not mentioned.
So these are facts.
We have seen it's a sister company of Mr. Sethi.
Yeah, but he is the de facto owner.
So he runs a very extensive business group. So if a facility is going to be an endless amount of documentation for every company or every interest he has from India to United States, that will take years and definitely not be capable of fulfilling in 90 days, correct?
Mr. Salah, I disagree, because this is a very normal thing where a bank says that please give us a good conduct of account from your existing banks. And Bank of Baroda is one of his existing bank.
So you were aware of the fact that, Mr. Sethi's financial situation is bad. His capacity to get an approved loan is capable of being drawn down is very difficult, and that means success fee. It would be reasonable for Mr. Sethi to think that success fee would be payable only if he gets a drawdown, if he gets the funds, if he gets the debt facility. Otherwise, what purpose would he have for a piece of paper which is subject to contract, essentially?
Sorry, I didn't get your question.
There would be no purpose for Mr. Sethi to have a offer letter which is not subject to being drawn down for the purposes of buying and restructuring his debt. So essentially, what I'm saying to you, or I'm putting to you, is that any other interpretation would make no sense for Mr. Sethi. Mr. Sethi would not enter into any contract which will not be capable of drawdown in the end for success fee purposes, correct?
I don't agree to this, because Mr. Sethi has agreed and signed the offer letter with, I presume, and anybody would presume, that because he has knowingly accepted the conditions meant for drawdown that he will fulfill, he has signed that. If he is unable to fulfill that, it is beyond my scope.
Well, he fulfilled what they asked him, but they kept on asking for further. Isn't that right?
No, I disagree. He has not fulfilled those.
Well, you've said it yourself, Mr. Khan, but we have to move on. Can I take you to 468, please? Which is, I think, number 13. Sorry, next.
Yeah, I am at 468.
So here, Mr. Sethi is writing to Mr. Mr. Sethi's colleague is writing to the bank again and saying, I think this is the same email that we saw, that we have fulfilled everything, and then they say we request you to. Wait 1 second. I have lost my. So 468 and 469. They asked him to provide further information about unique parts, report litigation case on that. I mean, again, this was not already an overdue payment. I think that is due. So essentially, a leasing management contract between the broker and Mr. Sethi instead of Mr. Channel 2 Group with warehouses or PDC. This is again a new requirement. This was not previously in this conditions precedent on 24th of June. So this seemed to be evolving number of conditions precedent. And that's why on the 28th of June, the defendant wrote an email saying that we have fulfilled everything. And in fact, they have provided stuff multiple times. And so there was a lot of frustration. So you would agree that whatever the defendant was capable of doing in 90 days, they did that in 90 days to get a drawdown, correct?
I disagree to this because there were certain conditions he has not fulfilled. And this email itself establishes that he had a past due, which he is confirming that he has cleared it now.
Okay. Now,
as a result of that, he was unable to get a satisfactory conduct of account.
Well, we should move on now. We just have a few more questions, Your Excellency. Now, termination. ENBD terminated the facility letter on 30th of June 2022, correct?
Yes, I think so. But I think the document is there. I don't remember. Unless and until
let's just accept. I mean, unless my learned friend says I'm wrong.
Fine. I believe you. Otherwise, Mariam would say that.
I'm sure
you 5 minutes. Mr. Mato, 5 minutes.
Yes. Yeah, 5 minutes. Yes, Your Excellency. Thank you for your indulgence. I just have 5 more. 5 minutes should be more than enough. Defendant still had 3 months to fulfill the conditions, correct?
For which condition?
The conditions
there were two
with respect to the loan number 2.
Yeah.
But they just decided to terminate, correct?
Right.
So essentially, he could have still be whatever their conditions were or evolving conditions were, fulfilled them and been able to get a drawdown had they not terminated for whatever reason in 90 days for both loan terms, correct?
No, I disagree, but I would like to commend his urgency was loan number 1, which is 49 acquisition of 49 apartments.
I think that's loan number 2. That's loan number 2.
Loan number 2. So and then because he could not, and the easier one was loan number 1, which is for 18 million, and which is pretty straightforward. So perhaps, I mean, what I assumed was that because of a simpler thing, he failed to furnish the conditions stated for that term loan. I think the bank would have taken a call that, because things are not coming that straightforward and in a transmitted manner, they didn't want it to. And like after the expiry of term loan validity, they decided to cancel the limit. Because given the unending conditions precedent requests of ENBD after issuing the facility offer letter, you'll agree that when ENBD offered its facility offer letter, the facility was neither approved or sanctioned or capable of being drawn down, correct? Mr. Salah, with all due respect, if you believe that the facility was not approved, why did the bank cancel it then? There is no need for any cancellation.
It didn't cancel. Because it just withdraw its offer.
Approved. Because the facility was approved, bank issued a facility offer letter. Bank gave a validity time for availment, for disbursement. Client failed to furnish. Hence, the bank decided to cancel the limit. After,
you see, you just tell Mr. Khan to be a lawyer now, Mr. Mato.
Sorry, I just have 2 more questions, Your Excellency. The facility offer letter was signed by the defendant on 30th of March 2022, correct?
Right.
So the invoice for the success fee was not issued on 30th of March 2022, correct?
No. Yes, you're right. Because
the invoice,
the invoice was issued in tandem with the mandate.
It's just a direct question. That's all. The invoice you issued for success fee was dated 7th of May 2022, correct?
Correct.
That's all I have to ask, Your Honor. Your Excellency, I have no further questions. Mr. Khan, thank you so much for your patience. I'm very grateful for your indulgence. Thank you very much indeed.
Thank you so much.
Thank you. If you bear with Mr. Khan, your lawyer wants to clarify some issues with you.
Sure, sir.
Thank you, Mr. Khan. Can I just firstly address the issue of the approval and dispersal of conditions? I attempted to do this with Mr. Haider, but I'm going to ask you the same question, if I may. What is the difference between a dispersal conditions and approval conditions?
The approval conditions are purely based on the credit assessment. And once the credit department is convinced on the creditworthiness of the client, they give approval that the client is good enough for an X facility. However, subject to fulfillment of certain disbursement conditions. Just to elaborate on this point, if a borrower approaches a bank for a car loan, the bank will assess his bank statements, its creditworthiness. But then, subject to that, because that application is specific for a car loan, the bank will put a condition that the car has to be mortgaged and the insurance of that car has to, loss pay, the bank has to be made. Now, so I think these are the two clear, with this example, I can able to demonstrate the difference between a credit decision and a difference between a disbursement decision. Now, disbursement decision, if the obligor fails to provide that mortgage of that car or fails to provide the insurance in favor of the bank will not give that disbursement for car financing. So these are the two, in simple words, the difference between disbursement, fulfillment of disbursement condition and the credit conditions.
So am I correct in saying, Mr. Khan, that the approval conditions are only met once the bank has completed its credit checks?
Absolutely.
Thank you, Mr. Khan. Can I now take you to section E, page 444?
Actually, I've just come out of that email, so I have to go back to that email again.
Thank you, Mr. Khan.
But then, just bear with me.
Just let me know when you're at the page. It's okay. Take your time.
It's number 9, by the way. Number 9444. Yeah.
This,
I think he
I
got
think, Mr. Khan, I
disconnected.
think we've lost Mr. Khan. Just trying
Miss
to
Mariam?
establish, Your Excellency, where Mr. Khan is.
Sorry, Excellency, but Ms. Mariam and Mr. Farouk, if you can contact him.
Yes, we're attempting to do so now.
Thank you.
We are trying to make contact. Apologies, Your Excellency.
Don't worry.
I've been advised, Your Excellency, that his signal has dropped and he's trying to reconnect.
I think it's here.
hello, sorry,
Thank you, Mr. Khan.
got disconnected. Yeah.
No problem. I think we were at page 444 of section E.
Yeah, just bear with me. So,
That's no problem.
page
Have you
4.
located it, Mr. Khan? Page
Yeah,
444.
Yes, I'm there.
You're there. Can you see the email dated the 11th of March from Sushil Mehta from Emirates NBD?
Sorry, I can't hear you properly.
It stipulates the conditions, Mr. Khan, in the email from Sushil Mehta dated the email dated 11th of March.
That's correct.
Can I ask you to go through the stipulations from A to N and confirm for me which of those conditions as such you were able to assist Mrs. Sethi on?
Well, see, these are all these conditions where Mr. Sethi has to provide, and we were just a conduit to provide those information to the bank from as provided by Mr. Ajay Sethi, like Mr. Ajay Sethi's audited net worth statement. So he has to get it audited from his accountants and then submit it to the bank through us. Second is, the DSR at all times. So we are based on the information we have provided the financial model, and we provided that to the bank. This is perhaps part of the credit approval where the bank was completely satisfied. The fourth one is like fresh valuation. Okay, so Mr. Ajay Sethi has to provide the latest valuation of the properties that were subject to be offered as collateral. So these are primarily, most of these conditions were subject to be fulfilled by Mr. Ajay Sethi, and then some of the information he directly provided to the bank through his office, and some of the information he routed through us.
And can I ask you, did you volunteer that, Mr. Khan, or did Mr. Sethi ask you to forward this on to the bank?
Some of the information where our client, we being his financial advisor, wherever he approached us to seek our assistance, we were always available for him.
And am I fair in saying that when you carried on liaising with Emirates NBD, that was done entirely in good faith, Mr. Khan?
Absolutely.
And it was due to the existing relationship that you had created with Mr. Sethi from, is it November 2020 and up until January 2022?
That's correct.
Thank you. Can I now take you to section A, page 174, please, Mr. Khan?
Sure.
What section is that?
Section A.
What section? Sorry, what number? Sorry.
Number 1.
Ah.
Page 174.
That can't be right.
Yes.
Section A, number 1 is
Apologies. Section A, number 8.
Which page number?
174.
17. Yeah.
Do you have that in front of you, Mr. Khan?
Yes, I have.
Okay, there was some discussion with my learned friend in relation to condition 9 in relation to the insurance policy, Mr. Khan.
Yes.
The clause clearly states that it's in relation to properties not mortgaged to the bank. So I'm presuming Emirates NBD.
Right.
Can I then refer you to clause 11, please, Mr. Khan?
Yes.
Can you confirm whether clause 9 is making reference to those specific properties, namely unit numbers 1705, 1709, 1710 and 1711?
Absolutely.
Thank you, Mr. Khan.
these are the properties which Mr. Ajay Sethi already owns in his name.
Yes. Thank you for the clarification, Mr. Khan. In relation to clause 13, I think you clarified this point, Mr. Khan. You've already confirmed that Mr. Sethi had already provided the rental agreements. Is that right?
That's correct.
Can you just confirm to me how that was furnished?
It was furnished through a document which he got it from the seller.
And the bank were happy with that, were they?
Right.
Did they confirm that, Mr. Khan?
Not exactly. They on the face value of these documents, they accepted it.
Thank you, Mr. Khan. Can I also now take you to, just bear with me, Section A, page 96.
Page 96.
96.
What number is that?
Number 6. So Section A, number 6, page 96.
Right.
Just bear with me. I'm just slightly lagging, Mr. Khan.
Sure.
As you can see, Mr. Khan, this is making reference to your email to Emirates NBD.
Yeah.
Email.
Yeah.
Can you confirm, Mr. Khan, that again you are acting in good faith?
That's correct.
And you were simply asking the bank to confirm whether the 8th of June 2022 was an acceptable drawdown date.
Absolutely.
By no means were you telling the bank that you were in a position whereby the defendant was in a position to draw down. You were simply asking for a date. That's right, Mr. Khan.
That's correct.
Thank you. With regards to Section E, Mr. Khan, page 446. For my learned friends' information, it's number 9.
Yeah. Yes.
Number 10, I think.
Apologies, number 10.
Right.
There's a reference, you made reference at clause 7. There's a reference to an AECB report. Can you expand on that for me, Mr. Khan? What is that required for?
See, AECB report is Al-Ittihad Risk Bureau report, where the entire conduct, which reflects the conduct of account with banks, the number of occasions where a check has been bounced, any legal cases, any other labor issues. It's a very exhaustive credit history of the respective party. And then against that, there is a score, and each the score has got a matrix to say whether this is an acceptable score or this is a score below which no credit facilities would be given.
And is this normal to be requested as a matter of course in conditions precedent?
Absolutely.
And is this usually done after the approval conditions are met?
Absolutely.
Thank you. Can I now take you to section F, Mr. Khan? Page 721.
Page 721.
Yes.
What number is that?
721 F, section F, 3, number 3.
Number 3. Thank you.
Yes.
There's been much talk by my learned friend, Mr. Khan, of the problems that Mr. Sethi was encountering during COVID.
Right.
Can I confirm that that's correct with you?
Sorry, your voice was breaking. I could
Can I
not hear it.
confirm that that's my correct interpretation, Mr. Khan?
That's correct. That's Mr. Ajay Sethi's net worth statement.
Do you consider that to be the figure contained within the net worth statement of somebody that is considered to be struggling? And can you just confirm the date of the net worth statement as well for me, please?
This document is prepared by a qualified chartered accountant. So we have no, area to or reason to disbelieve this. But by any standards, this is a high net worth statement.
Can I just assist you, maybe, Mr. Khan? Isn't it dated June 2020?
That's
straight
correct.
after COVID.
That's correct.
Okay, thank you. Also, Mr. Khan, if I can take you to section E, page 468.
Yes, ma'am.
It refers to some conditions and the defendant's general frustration in this matter. I noted a comment that you made, Mr. Khan, that he was unable to get a satisfactory letter of good conduct. Did you find that throughout your dealings with Mr. Sethi?
Again, Mariam, I'm sorry, I can't, I didn't hear you
Apologies,
properly.
Mr. Khan. Can you hear me now?
I can.
Yes. So what I'm asking you is I can see the defendant's frustrations in this email, but I noted a comment that you made, Mr. Khan, that, you know, the defendant couldn't fulfill any of these conditions, and it was a repetitive job, if I may say, on the behalf of Emirates NBD to repeatedly ask for this information. And I note that you mentioned that as a result, he was unable to get a satisfactory letter of good conduct from the banks.
That's true.
Can you elaborate on this for me, Mr. Khan? What were the problems that were being encountered by Mr. Sethi?
See, when we were approaching ENBD, we ensured, because we were having some background that he had some similar problems. But at that point of time, he categorically provided us evidences that everything has been sorted out. The banks are fully paid and there are no past dues. But in due course, while the bank was doing, and we were not checking his conduct of account on a daily basis, but eventually when one of the disbursement condition was that he has to provide the latest good conduct of account where he was struggling, and which he himself is saying that there was a past due as a result of which is just got cleared on 28th of June as per this email. And then as a result of that, the banks were not giving him a satisfactory conduct of account, and that was one of his biggest challenge.
Thank you, Mr. Khan. Can I now refer you to section A, page 43?
Are you going too long, Mr. Razak?
Just a couple of questions, Your Excellency.
So what section is that?
What's in your reference?
Section A, number?
6.
You can set page 43.
46.
46. Okay.
Apologies, yes. Apologies, Mr. Khan. I said 43. Apologies.
No worries, no. I'm there.
Right. This is obviously your engagement letter, Mr. Khan. If we turn over the page at paragraph 4.
Yeah.
you can see quite clearly what your terms and conditions are in relation to information validity and reliance.
Right?
Can you explain that clause for me, please?
We have, in a couple of other occasions in this mandate, we categorically mentioned that the reliance and the source of information is from the client. We assume and we take on the face value that the information provided by the client is accurate and realistic in nature. Hence, we are not auditors to cross-examine the information provided by the client. We act in the space of advisor. So whatever information comes, we take it on the face value. Based on that, we make a submission. We make a proposal. We discuss it with the client, take their confidence, and submit it to the respective lender.
So at that stage, when you initially engage the client and prior to signature of each engagement letter as such, did Mr. Ajay Sethi disclose any of his blocked accounts, court cases, anything like that, Mr. Khan?
Not at all. It just came as a surprise also for us that each time with different banks that we approached, and then at each and every occasion there was a new problem arising, which were not told to us initially. And as and when we went back, because the bank has got much wider access, and then they highlighted those kind of problems to us, and we went back to Mr. Ajay Sethi, and then Ajay Sethi took the corrective actions and then provided documentary evidence that that's been fixed.
Thank you. And just one final question. If I can take you to section A, 6, page 49, again.
Yes. I'm there, Maria.
Apologies, I think I've just lost the page number. Just bear with me 1 second.
Sure.
Yes, apologies, it is 49. So can I refer you to paragraph 1 of that document, please, Mr. Khan?
Yeah.
So you can see manual amendments, can you not, by Mr. Ajay Sethi on the letter of engagement?
Correct.
So am I correct in saying, Mr. Khan, that if Mr. Sethi appeared to be not in agreement or unhappy with the way that a letter of engagement was drafted, he would definitely bring it to your attention, and more importantly, he would make the changes himself?
Absolutely.
So I don't think I've got any more questions to ask, unless you've got any for me, Your Excellency, or Mr. Khan.
Thank you.
Thank you. Thank you very much, Mr. Razak. Thank you very much, Mr. Khan.
Thank you, sir.
So Matu, I think it's time for break.
Yes, Your Excellency, very much so. All of us deserve a little bit of a comfort break and some coffee.
Yeah.
Yes, right. I'm not intended to take a longer break. I think what we have remaining is that your witness, Mr. Mato.
Yes, and maybe, Your Excellency, should we come back in 15, maybe by 12:05? Which is, I think, Dubai time, 3:10, maybe 3:10 Dubai time.
No, because I got, this is a prayer time too in here.
Okay.
I need to
Yes,
do
of
the
course.
Dhuhr prayer as well, and yeah, so we'll come back Dubai time 3:30, 12:30 your time. Okay.
Very well, Your Excellency.
Okay, Your
I'll
Excellency.
see you then.
Thank you.
Good afternoon.
Good
Mr.
afternoon.
Razak, good afternoon. Mr. Maru.
Excellency. Good afternoon.
Good afternoon, Your Excellency.
I'm Sethi. I'm Sethi. Mr. Matu, you still in the break?
Oh no, I took I took cups of coffee instead of one.
No worry.
Your
Yes, as
Excellency, may I
agreed.
swear
as
in
agreed.
the... I'm sorry to interrupt.
Yes, it's the time to introduce the defendant as a witness.
Sure. Could you please state your full name and occupation, please?
My name is Ajay Sethi, His Excellency, and I'm a businessman based in Dubai in Emirates Sales.
Thank you. Will you be affirming or swearing?
Affirming.
Great. So please repeat after me.
Yeah.
I solemnly declare
I solemnly declare
and affirm
and affirm
that evidence I shall give
the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
nothing but the truth.
Thank you. Thank you, Your Excellency.
Thank you, sir. Thank you, Excellency.
Thank you. Mr. Mato?
Yes, Your Excellency. Mrs. Sethi, can I take you to section E, number 4?
I'm using my PA to assist me. Yeah, it's fine. That's okay. On the computer, yeah. This section 4. Please repeat, please.
Section, so it's section E, number 4.
Yeah. Yes, please. Page number.
So, it should be the first witness statement, your first witness statement.
Yes, please.
Sorry, page number, sorry, I should give you 401.
401. Yes, I'm there.
Okay. Can you please repeat? Can you please look at the witness statement and say, is this your witness statement? Can you give your full name and your occupation and where you work?
Yes, Ajay Sethi, Channel 2 Group Corporation. I'm the chairman and I work in Dubai in the UAE.
Can I take you to the last page of this witness statement, which is page 409?
Yeah.
Do you see that?
Yes, please.
And is that your signature?
Yes, please.
And is your statement? Do you accept that it is true? The contents of the witness statements are true and accurate to the best of your knowledge.
Yes, please.
Can I take you now to your second witness statement, which is at section E, number 6?
Yes, please. It's 412, page number.
Yes, that's right.
Yeah.
Is this your second witness statement, Mr. Sethi?
Yes, please.
And can I take you to your last page of this witness statement, which is 420?
Yes, please.
Is this your signature?
That's true. It's my signature.
And are the contents of this witness statement true and true from your recollection and based on your knowledge and accurate representation of the facts as set out there?
Yes, please.
Okay. Can I take you to the third witness statement, which is at number 18?
Right. $490.
Yeah. So is this your third witness statement, Mr. Sethi?
Yes, please.
Can I take you to the last page of this, which is at 493?
Yes, please.
Is that your signature?
That's true.
Are the contents of this witness statement true based on your recollection, Mr. Sethi?
Yes, please.
Are all the facts contained in this based on your understanding and based on the truth as you understand it, Mr. Sethi?
Yes, please.
No further questions from us.
Thank you, Mr. Mato. Mr. Sethi, now you would be taken through with Ms. Razak for cross-examination. She would ask you about certain information in your evidence.
Sure. Thank you, sir.
Ms. Razak, please.
Excellency.
Good afternoon, Mr. Sethi.
Good afternoon, ma'am.
How are you?
I'm fine, thanks. And how about you?
Good, thank you. Just to let you know, Mr. Sethi, I'm going to be taking you through some evidence. If I'm going too fast or there's a point that you want me to repeat, please feel free to ask me to do so.
Yeah, I'll do that.
Okay. So Mr. Sethi, you're the chairman of Channel 2 Group Corporation, correct?
Yes,
You're a businessman who's been based in Dubai for the last 30 years. Is that correct?
yes, correct.
I'm correct in saying that you have various other business interests as well. Is that right?
Yes.
Can you confirm for me what these business interests are?
I have a business in media. I have a real estate business. I have a business in Algeria with the steel plant. I have a business in India for the real estate land holdings. And I also a spare part business, automobile, which is my oldest business of 40 years. And I moved to Dubai from Kenya. So I lived 9 years in Kenya before I moved to Dubai. So I was in the same business of parts business I'm still doing.
Okay, thank you, Mr. Sethi. So it's also apparent that you own and regularly acquire land and buildings as you've built up a reputable portfolio, correct?
Yes, since the 2001 with the Dubai property boom, I took this opportunity.
I assume then you're familiar with lending facilities, banks and their lending requirements and understand how banking system works, don't you, Mr. Sethi?
Yes, I'm a commercial person, a businessman. I do it uh, regularly, and there's always ups and downs in business, but I'm fully aware and conversant of the business.
Going back to Channel 2 Group Corporation, Mr. Sethi, can you tell me about the services offered by Channel 2?
Sorry, can you repeat that? I think.
Yeah, just Channel 2 Group Corporation. Can you tell me what the services are that are offered by Channel 2?
Channel 2 Group Corporation, we have launched this company in 2006, and we are dealing in sports rights, including ICC World Cups, IPL, Asia Cup, a lot of cricket on the audio business. And we also have FM interest in the live broadcasting of commentaries. And we also have various interests in sporting events, mainly sporting business.
Yes, I've noted that you work with a lot of large, reputable organizations. Can you name a few of the organizations that you've worked with, Mr. Sethi?
I work with ICC, BBC, SABC, ABC, Australian Broadcast Corporation. I work with all the broadcast because we have a global rights. So we work with the national broadcasters, and also I work with Ajman TV, where we have a long-time relationship with Mr. Abdullah Murad of Ajman TV. We work with them since 2003. And we also have a relationship in Pakistan with the Ham FM and South Africa in America. So when you have global rights, you have, and cricket is playing being in 11 countries. So at least there's 11 broadcaster I have a relationship.
Okay. So who reviews the contracts you enter with these organizations?
For example, when we buy the rights, we do through the bid, we deal with ICC, BCCI, all the sporting federations, and we syndicate and do revenue share with contract. We have a 5 years contract with BBC in UK for the ICC rights, and BCCI is India. Prasar Bharati is All India Radio. And rest of contracts are, we have a digital one in Bombay, also have a Fun Asia in Dubai where we have a contract.
I think you misunderstood me, Mr. Sethi. Who reviews those contracts prior to you entering into the contracts? Who reviews them for you and who negotiates them?
Generally, I give it to my lawyer if it's a large contracts. I use my law firms India or UK. They review, but I also understand generally deals are done by me and my team because this is a negotiation. The contracts we read only on the legal part of and sometimes this is generally done by the lawyers. And so, and if it's smaller contracts, then I don't use lawyers because any businessman reads few. As a layman, you can understand those terms and conditions because businessman makes the decision in the end. Lawyers are only there to then come in the picture, but you take advice.
Did you take advice on the engagement letter detailed at section A, page 43, Mr. Sethi? Can I direct you to that?
No, because what happened, I have been dealing with Mr. Moise Sorry.
Can I ask you just to go to the relevant section, Mr. Sethi?
Yeah, I will.
It's section A, page 46.
46, yeah. 46. 1 second, please. Yeah. 46, yes. Yeah, I'm there. Number 6, termination.
Yes. So if we go back up, my apologies, Mr. Sethi, it was basically, I think it starts at 43.
43.
My apologies.
No, fine, it's fine. 43. Yes.
Can you confirm that signature at the end of this document is yours, Mr. Sethi?
Yes.
And
As the
I think
chairman of Channel 2 Group. Yeah.
yes. And I asked you, did you personally review this contract yourself?
Yes, because I have seen the same format of contracts. They're copy and paste for last 3 years from them. So it was nothing new, very similar copy and paste contracts. But sometimes they've been adding clauses of fixed fee and term sheet fee and all. But otherwise, generally, they have a standard format. Looks like with all the contracts since 2020 I had with them.
Okay. So can I take
I
you
did
to
not use I'm sorry, I didn't use any lawyer
Okay.
for this.
Yeah.
Because I've been dealing with them for 3 years. So I took it as a fee contract or success fee contract.
Okay. That's absolutely fine. Can I take you to paragraph 3 of that contract, please, Mr. Sethi?
Yeah. Paragraph 3.
Yeah.
3. Paragraph.
It's titled exclusivity.
Yeah.
Have you got that, Mr. Sethi?
Yes, in front of me.
Okay, that's good. So exclusivity, and I'm sure you're a successful businessman, you know that the contract was exclusive to Fursa. But if we go 6 lines down, I think it's 6 lines down, 4, 5, 6. Yes. So I'm going to read this to you, Mr. Sethi. So if you wouldn't mind following it for me.
Yes.
So notwithstanding the exclusivity granted to the advisor, nothing contained herein shall be interpreted to prevent the client from retaining legal counsels or such other advisors as may be required for taxation, accounts, or legal purposes.
Yeah.
So do you agree, Mr. Sethi, that it was your prerogative to seek independent legal advice if you are unsure about the interpretation of such an agreement?
Yes, the clause said that, but this was a fee contract of success, and I have not hired a lawyer to spend more money on this contract rather than I'm going through with Mr. Moyes. We have 4 contracts like this. So of a particular contract, I didn't want to change a new lawyer and have a new advice.
But isn't it apparent that there is a dispute regarding contract interpretation on this, and that you weren't sure from the outset what the implications of this contract meant?
No, we discussed this matter with Moise that time, and he said, we will have 30 days to get the drawdown done. That's why I put 30 days. He said, generally, in my experience, ex-banker, within 30 days, the bank drawdown happen. And I took that as and also there has to be some mutual trust. And I believe that if there is a drawdown and 30 days is giving, it will happen in his experience. And I know that if you have all the documents, which is required for a loan disbursement, it happens in 30 days. I have experience with other banks too.
So you've experienced the drawdown occurring within 30 days?
Like Bank of Baroda, we didn't have that long stay, but approval takes time. But the drawdown happens if you have all the documents, because most of the documents bank ask are very simple. I will tell you my experience with banking. Once you have a full credit approval, means credit committee is a risk committee is a key committee of the approval. If they approve the loan, Generally, they ask you the mortgage documents. The most important document, if it's a takeover, is a liability letter from the other bank, the NOC from the developer, service charge paid, and mortgage documents, legal document, and they create a facility and mortgage contract. Those are the only 4 or 5 documents I've ever seen, but I've never seen a documents of 15, 14 precedent conditions, whereas they're asking me conduct of other banks, AECB, net worth statement. This is all done before the credit committee even touched the subject. Even AECB, the first document of a credit of a person is studied by the credit committee before they go further. They have employees to pay the salary. They don't want to waste their time on a contract or a loan which have so much bad history. So if the first document is required from the bank and it's in public domain, is the AECB report, Etihad Credit Bureau report, and then any bank conduct. If you have no good conduct with the banks, ma'am, how the credit committee they will not ask after approval. So then this list was so exhausted, and I discussed with Moise that what this look like a term sheet to me.
Right, but we're now on the issue of you signing this letter of engagement or agreement as such, aren't we, Mr. Sethi? So if it was so easy and you were advised that, you know, the drawdown would occur within 30 days, why were the documents not provided within 30 days? Am I right in saying that, you know, you alleged to know that you were signing, but you actually just used that as a simple way to get out of the contract at a later stage?
No, ma'am. Let me explain. I meant 30 days. I gave you also the list of documents which generally banks needed. And Mr. Moise, as a ex-banker, he knows bank does not ask 20 or 10, 12 list of documents. If 10, 12 list of document, nobody can complete in 30 days, not even 1 year, because of some of the condition. For example, I'll tell you one condition was there, which is very important for you, for His Excellency to also to please listen to me on this.
Yeah.
They had asked us, give us a clean title, the title deed for 4 apartments, which was kept with the way Islamic Bank as additional security. And those security they will only release once they clear the first payment of 18 million. And in the condition they asked me to provide this clean title deed as a part of the deal. And I say, I cannot do this. You take over the loan and bank can give you an email that they will deliver the 4 title once you pay the 18 million check. So this was impossible to meet that condition anyway. But 30 days I meant for the normal standard documents, like there's a mortgage paper, there's NOC and liability letter. The rest of things, everything is done before the bank issue the credit facility. In my view, this was simply a term sheet, written in a structured manner, and then it was not a final approval, which I think I've seen since morning. I'm listening to all the witnesses and our lawyer and His Excellency is listening. We know exactly what happened. And I want to say something. If I'm a desperate for money, and I really need the funds, I will make sure and I will leave no stone unturned to get this loan approved, which I did. But I could not meet the requirement all the time, which bank has been.
What
Okay.
we're addressing firstly, Mr. Sethi, and I'll come on to that, is
Okay,
the
fine.
issue. Yes, it's just the issue of the signature. So it was the offer that was made to you and the acceptance, but I'm taking this as a reasonable, commercially minded businessman. If you were in any doubt about it, would you not consider speaking to Moise and Mr. Khan, or would you not seek the advice of an independent lawyer? Because the way this has emanated now, it's seemingly and increasingly becoming apparent that this is a clear case of contract interpretation, whereby you weren't sure of what you were signing anyway. But why did you go ahead and sign it? I'm correct in saying that you signed a document that you weren't aware of what it was saying. That's right,
No,
isn't it?
No. I said I've signed the document knowing I have a discussion. I didn't sign on an email. I signed in person in their office, and we discussed this matter. And he said, Mr. Sethi, I'm going to be with you until the loan is disbursed. Drawdown is done. And it will happen in generally 30 days, but we have 90. But that time, there was no term sheet for the bank. It was only a contract. So he put 30 days. He said, my experience in 30 days will get the money drawn on. And I'm a commercial businessman. Why would I want to pay somebody presenting me with the bank, which I have known all the banks. I have facility with other banks, Bank of Baroda, the Islamic Bank, Habib Bank. I have the facilities. I know how it works and operates. I said, fine, within 30 days, if there only few documents, we'll immediately close and we get the disbursement to pay them. And that's how he put the wording like that. And I took as a business, a layman business, it was not a deal which I'm doing $20-30 million, which I have to, I mean, to go through a lawyer for this because we have been meeting for the last 3 years with him and he did not able to get the loans in the past.
Okay, so moving
so
on.
I did speak to my lawyer later on when this problem started, when he started sending me termination. Then I spoke to Mr. Salah.
Okay. Moving on, Mr. Sethi, you refer to the claimant's CEO, namely Mr. Moez Khan, visiting your offices on many occasions. Is that correct?
No, he is. I visited most of the time in his office. He has maybe only once, I don't remember, once I think he came to my office, if I'm not mistaken. But most of my meeting, I live in Emirates Sales and he lives in Fursa. So most of my meeting was to be in Shakespeare in Springs. And 6 to 7 times he came to my house with Adnan. Adnan was most of the time out of UAE during this my facility. He was in Canada. It's Mr. Moez who was interacting with me most.
I think what
And
I'm
he's been to
trying
my
to
house
get,
a few times.
yes, what I'm trying to get at is that throughout this time, throughout this period, you built up a good working relationship, didn't you?
Yes. That's why I didn't go to any other bank. I have working with him only. I don't have applied any facility. I given him specific name of those banks where he wants to. And if you look at in good faith, I had no contract with him on NBD. It was expired. But being a gentleman, I kept my word. If without a contract, if it's Islam, because I wanted Islamic loan because the way Islamic bank, I wanted Ijara loan to Ijara bank. But somehow he couldn't get it and he said he wanted NBD. I didn't extend the contract. I didn't sign the new contract. But as a gentleman, as a businessman, I kept my word. I never denying it till today. So my
But as
intention,
a
relationship was
businessman,
there.
as a businessman, wouldn't you think it prudent to have an agreement?
Not necessarily. When you known somebody 3 years and you have a contract and he says he's not getting the loan, but and I thought he will never get a loan. I was in the impression that he's trying his hard because he was trying, let's say you make a tender. I make 20 tenders. I do paperwork. I go to everything I do. I spend a little money. I don't get each tender, but that is my business. I continue doing other tenders in business. So he's the same story when he was trying to get me the loan for 4 times. He didn't succeed. And I thought it's waste of time, but I was polite to him and I thought you never know. He'll get a
But as a
loan and then
commercially astute businessman, Mr. Sethi, do you have
yes.
time to waste your time by just thinking, well, someone can get me a loan, especially given your financial situation?
So, madam, what's your question? That I did not sign the contract or extend the contract because I'm not denying that I didn't. I have a gentleman contract expired, but I'm accepting it. If the loan was disbursed and drawdown done, I had a deal for 2%. I'm happy to pay as a commercial businessman. There's a benefit for me and benefit for them. But
Okay,
I
so
did not extend the contract and say that, when somebody meet every day in 3 times a week with you, sit and have coffee, we have a contract. And I was I had a very little chance that he has not been, if you think I have a bad history with the credit, I have all. So I was also thinking, and I'll go back later on in those, I'll clarify my other issues with the banks, which we'll talk later.
I just find it a little bizarre, Mr. Sethi, just to think that a businessman who is suffering extremely financially, particularly after COVID, would waste so much time on something that he knew he wasn't going to attain.
No, as mentioned to you, he was doing for last 3 years. Why would I sign 4th contract on 7th of January? Because I knew he's being an ex-banker. He told me he has got a relationship with so many bank managers and everything because they're colleagues in the past. So it's not just a guy who's come from India or some other country and started a business. All these people are experienced and he's lived a long time in this country. And he mentioned that he has a very good relationship and he will only use the banks which he has a relationship he doesn't write all banks. So he knew, and in business, there are about more than 100 financial brokerage company in Dubai. We know them. I don't know all of them, but I think that's how business work. And most of my business colleagues, my friends have given the money on the drawdown. Nobody has ever, it's like if I make money, I get money, I will give his right. But if I'm not getting my drawdown, I mean, I cannot just give million dirham to somebody for giving some papers and sign some document,
I think
which
we'll
is
come back
vague.
to that, Mr. Sethi, if that's okay. So if we go back, the way you've dealt with this kind of business working relationship is that suggests that you were comfortable and happy with the services provided by Mr. Khan and Mr. Heather and their company, weren't you?
As I previously said, that last 3 years, they have been trying. If somebody's trying to get me the money, he also needs the business. Why would he, if he was so busy with other 50 clients, he will not want to bother to follow my failed business again and again and get me the new loan, waste his time with me. If he is not sure about that he will get me the loan, it's like any business. I said, I do tenders. I don't succeed, but I still follow business. So it was not like, but I didn't go to any because I was thinking until this issue with, my credit 40, my ratings never changed from 21 to 22. So rating was always 540 points in the Etihad Bureau. And my loan always had been against the properties. Even in 2021, I never had a loan on the balance sheet. That's my 20 years experience with the banks. I never borrowed money on balance sheet, only against my solid assets.
I acknowledge what you're saying, Mr. Sethi, but the onus is going on to Fursa in this instance. But again, a commercially astute businessman, who doesn't think that these people are going to get anywhere, puts all his faith into them and signs numerous engagement letters with them. So it's correct, isn't it, that you had some element of faith in these people?
That's why I was dealing with them. Yes. Why would I deal with somebody and give me all my information to them for 3 years? And I just want to clarify. He was saying that Mr. Moise said that he didn't know about certain cases. Somebody's working with you 3 years. Your advisor is your doctor. He knew everything about why would I go to a doctor and hide my disease? He knew exactly what my problem is.
Yeah, Mr. Sethi, because Mr. Sethi, if you allow me, because for a lot of business people, it's not about faith, it's about opportunity. Like they deal with anyone bring them opportunity, but others who believe in faith, they give certain people opportunity. So the question is whether you have given them a faith or just you look at them as one of the opportunities in your table.
I think I wanted the loan and they have been trying to get me the loan. So it was my opportunity also. I don't know them for a long time. They were not my friends. So it is basically, I think rightly, this is my opportunity I got. They may get me a loan. If they're trying, they may succeed.
And if they not succeed, you lose nothing. That's the deal in your mind?
No, if I draw down, I get the money. I was paying them 2%. I never denied. Imagine if I've taken the money, I would have paid it.
And if they get you nothing?
I mean, because we had the understanding that, because drawdown must be done. And it was, I think my council has also, explained all the positions on that. But if I don't like 3 years, we couldn't get anything. The loan was not approved, so we were pushing, going along with it. But if my term sheet, this is like a term sheet, if my drawdown was not done, how would I pay the fee, 2%?
Mr. Razak?
I'm going to move on from this point, Mr. Sethi, but it's just bizarre that a businessman who is in an extremely desperate, if I may say so, situation financially is willing to give so much time and look for opportunities when he has so many opportunities and other financial brokers available whereby they could have got him the facility faster. But if we just move on.
Mr. Razak, I think maybe that's unnecessary. I mean, I'm taking Mr. Mato's role, but I think that was unnecessary. If you have any question, to the witness on regard of evidence. Let's move on.
Okay, thank you. Can I then take you back again to the engagement letter, Mr. Sethi?
Page 44.
Page 44, sorry, apologies. Is
Page
that in front of
43,
you, Mrs. Sethi?
Yeah, page 43, I think, Your Excellency.
43 or 44?
Apologies, 43.
Yeah.
Have you got it in front of you, Mr. Sethi?
Yeah, I have.
I'm looking at clause 1, transactions. Now, I'm not going to read the whole clause out, but the purpose of the agreement was to get a facility to pay off your debt of 18 million to DIB and the remaining 28 million to fund a project for acquisition of 49 apartments. Is that correct?
Yes.
Can I then refer you to clause 2.2, which is on
Also,
page
the
44?
15 million was channeled to working capital.
15 million of the. Can you just
Working capital
clarify
for
that for
channel
me?
2. Yeah.
Okay. Okay, can I then refer you to page 44, Mr. Sethi?
Yeah.
Clause 2.2. So clause 2.2 refers to a success fee of 2% of the total project facility approved by the lender to be payable to the claimants. And it goes on to say the client agrees to pay first a success fee in the case of a successful transaction. Maximum within 30 days from the date of signing of the facility offer letter. So based on that, you agree, don't you, Mr. Sethi, that you received an approved facility offer?
No, it was not a final approved facility offer. Successful fee means I do a drawdown and a final facility offer with all the, after they present all conditions which the precedent condition are given, then the final facility letter will come, and that's why I say within 30 days we'll get this drawdown done. Not immediately on the
Oh,
first.
no. Don't be a lawyer. Try to just answer. She said.
Thank
Do
you.
you remember that she said, "Have you got a facility offer letter signed?" And then
I signed the letter which has provided to me, but I was given a impression that I asked them to 15 conditions is there, 12, 15 conditions, but this is the normal procedure. They will be, we'll get this sorted out, and this is the final letter will
Mr.
still come.
Sethi, that comes at a later stage. We're
Okay,
still
fine.
on
Your question is,
issue.
let me reply in short. Yeah.
Yeah, the issue is, we've got to take this as literal, and I addressed the issue of contract interpretation and whether you were sure of what you were signing. Now, if we take this literally, it is actually meaning that a successful transaction is the signing of the facility offer letter. That's correct, isn't it?
But this was a conditional precedent letter. According to me, when I met them, it was not for me. It was not a final letter.
I think we're missing the point. What I'm trying to say to you is looking at this as literally as a commercial businessman without any legal knowledge. If you look at that, what would you take that as the literal meaning of that, Mr. Sethi? It's saying quite clearly, for the purposes of this engagement letter, a successful transaction means acceptance and signing of the facility offer letter. Now, that would mean to me that you accepted that a successful transaction had occurred, correct?
No, but I think my counsel has also have confirmed that the same legal point of view. But I am again, when this letter was brought to me on 30th, 22nd of March was issued, I signed after 8 days. And I was discussing with Moise that, he said, don't worry, we are there till the last and we'll make sure that we get the drawdown done. That's why they did not ask on the 1st of April to give me the money. They waited till the.
If you were discussing, Mr. Sethi, so there must have been some doubt in your mind. Now, would you go to the perpetrator to clarify something for you, or would you go to someone that can actually assist you with this interpretation? I'm just asking you the question.
I think my question, I signed that letter, and in my view, success was a drawdown, not a facility letter. Which facility? This was not a final facility letter. Doesn't have 15 clauses of code of conduct and all those. So my question is, I've signed that letter, but in my view, in my mind and discussion, that this was not a final facility offer letter.
Okay, thank you. I think we'll agree to disagree on that then, Mr. Sethi. Can I now refer you to section A, page 118 of the bundle?
119,
118.
18, yeah, 118. 118 section.
Just bear with me. Sorry, I think I've got that just wrong. Just bear with me a second. Of defense. Sorry, section A, 7.
Section A.
7, page 118.
Page 118.
That's not right. It can't be section 7. It cannot be number 7.
118 maybe.
Maybe it's number 6, I think.
Yeah, number 7 is a legal translation.
Yeah, I think it's number 6, Your Excellency.
I'm actually getting it at section A, 7. Is it 125?
What page?
Apologies.
117 is the legal translation. Is that what you're?
No. I'm looking at the statement of defense. I think I've
That's
got
number
two
7.
different paginations.
125, yes.
125.
Apologies.
125, yeah, defense, yeah.
Yeah. Can you confirm that you've read and agreed to the contents of this document, Mr. Sethi?
Yes.
Okay, can you go, I think I've got my page numbering wrong now in accordance with this. Can you turn to page 139 of that document?
Yes.
Can you confirm that that's your signature, Mr. Sethi?
Yes, it's my signature.
Thank you. Apologies, can I ask you just to go back to page 127 of that document?
127.
Yeah.
Yeah.
Thank you.
7. What you're doing? 127.
Yeah, so if we go to page 127, Mrs. Sethi, at
127 has many part.
paragraph 13, I was just about to direct you.
Yeah.
So paragraph 13 refers to the 1st of November 2020. That confirms the beginning of your business relationship with Fursa Consulting, correct?
Yeah.
It further goes on to state that the first offer letter was signed on the 1st of November 2020. Is that correct?
Yeah.
The terms agreed in the engagement letter were for 65 million dirhams.
Yes.
An assignment,
Yes.
and that's correct, isn't it, Mr. Sethi?
Yes, please.
An assignment fee was also charged upon receipt of an indicative term sheet, correct?
Yes.
Now, if I ask you to turn to page 128, paragraph 18. Do you have that, Mrs. Sethi?
Yeah.
So it's confirmed that you signed a second engagement letter with the claimant on 23rd of June, didn't you?
Yeah.
The amount of the facility at this paragraph isn't specified, Mrs. Sethi, but paragraph 19 confirms that you agreed to pay 75,000 dirhams upon receipt of an indicative term sheet. That's correct, isn't it?
Yes, it was signed that time.
If I ask you now to go to page 129 of the same document, Mr. Sethi.
129.
So up page 129, Mr. Sethi, do you have that?
Yeah.
Okay. So a further engagement letter was signed on 7th January in relation to DIB Bank, wasn't it, Mr. Sethi?
Yeah.
This was again subject to an assignment fee of 50,000 dirhams upon signing of satisfactory term sheet, correct?
That's right.
Okay. I put it to you, Mr. Sethi, that you were fully aware of the difference between an indicative term sheet and a facility offer letter, correct?
Yes.
Okay, so can you explain that to me?
Because see, Dubai Islamic Bank, we had an existing loan. So they told me they will get my equity release and increase because valuation has changed. They'll get me because I paid the loan for last 10 years and my LTV has come down. So they will increase the facility in Dubai Islamic Bank. And if they bring the term sheet from them, that was good enough for me, particularly Dubai Islamic Bank, because I'm already existing client of the bank and I have all the documentation, legal, mortgages, everything done with them. So I didn't have an issue paying them 50,000 if they bring me term sheet from the Dubai Islamic Bank, because Dubai Islamic Bank, I don't need to do anything. Term sheet was more than enough for me to increase the amount. They will not ask me any further documents for the
Okay.
mortgages for, yeah.
Mrs.
But
Sethi,
I did not pay anything till today to them in any other banks.
I think you're missing my point. So, and what I asked you was, are you
Yeah.
aware of the difference between an indicative term sheet and a facility offer letter?
I think every bank has a different, as per the Mr. Moyes, every bank has a different practice and different formats. But I know what is because all that binding this term sheets and facility offer letter or final facility offer letter, it is different version of the different banks. So
But
I
have
know
you not just
I tell you, there's a non-binding term sheet, there's a binding term sheet, there is a facility letter, there's a final facility letter, there is a facility and mortgage contracts.
But you've just said to me that for them just to get you an indicative term sheet was good enough. And then you've just said to me that there is a final facility offer letter. What I'm asking you is, do you know what the difference is?
As I said, even indicated term sheet, if I don't sign and agree, I mean, why would I have not paid till today in all the banks any money? Because no term sheet was accepted, or it was like, non-binding term sheets. And when this facility letter offer came from the NBD, I still question whether it's looking to me like a term sheet, because in the past they brought me from Fab Bank and they asked me 50,000 dirham for that term sheet. I said, this is a non-binding, has no meaning. It has same clauses like what I saw in this facility. But they said every bank, he said, be behind you. We will make sure drawdown will be done and all these conditions will meet. This is the format of the bank. Every bank is different. And I agree with them. Bank do have a different procedure with different banks. That's my experience too.
So you agree that an indicative term sheet is non-binding?
Depends. Sometimes you're binding term sheet also. I have seen binding term sheet. Some banks don't even issue term sheet. They give you a direct final offer for drawdown after do the full due diligence for drawdown. They don't give you any paper. Like I give you example of NBQ. In my experience, they give you, once they approve a loan, they send you the final offer letter with the binding offer. There's no condition. Condition has to be meet all before credit sign of the stamp and the signature. And you will not get anything in before. No term sheet also. Some bank issue binding term sheet, some issue non-binding term sheet. So every bank has different internal practice.
But
and this is public domain. Yeah.
I understand that every bank has a different kind of practice, but it's normal practice, and especially in the banking world, to use this kind of language that's understood by, banks all over the world. So, I wouldn't expect a bank to be using an indicative term sheet and then changing that and another bank changing that. So the language that is used has got to be global. It's got to be used worldwide. And, people who use the facility, I've got to be au fait with the language. Am I correct?
Wait, you got the answer of the witness recorded now.
Thank you. Thank you, Your Excellency.
Sir,
Okay.
Excellency, do you want me to reply that, this question?
I think we can move on.
Okay.
So can I take you back again to paragraph 16? That's at page 128 of the statement of defense.
128 statement of defense. Para
Paragraph 16.
16.
Yeah.
Yeah.
That's just to confirm your point, Mrs. Sethi. You've approved a document where it says the defendant's point of view was that an indicative term sheet from the lender did not provide any contractual certainty. Correct?
Yeah, because this was like, when I saw the term sheet and I saw the 15 conditions, because I don't have a problem with few conditions, because those are standard worldwide, as you said, worldwide practice. But no credit will issue a term sheet and a loan to a client without knowing his conduct of the banks and knowing the ACB beforehand. They don't ask you later on. So that was very strange. And asked, this is something not right. But he said to me that please, we have 90 days and we will deal with it. And we will clarify and submit everything. And then after that, there will be, the final approval will come with a mortgage and funding letter, what they call, some format is there. So that was I don't have an issue with other conditions, but even the 4 title deeds, which is I don't own, how can I provide the condition? I told them, but they said they'll manage. They're behind us. We will make sure disbursement happen, drawdown happen, and they work till the 15th of June. I'll come later on to that point. Why they
Yes, we
work
will
with me.
come later on to that point, Mrs. Sethi. But I put it to you that you entered into multiple engagement letters with the claimant for the sole purpose of obtaining a facility offer letter from the bank, didn't you?
Yes.
And I therefore put it to you, Mrs. Sethi, that your previous dealings with the claimant reflect your understanding of when a success fee becomes payable, because you've worked with them so often. Correct?
Yes, as per whatever we have a relationship and conduct. But then when there was a question of this precedent conditions, I have made it very clear to them. But they said, please leave it to me. Even they told me, Mohit, you don't even have a contract, still I'm continuing. Please, I'll make sure drawdown happens and we'll meet all this condition.
Thank you, Mrs. Sethi.
Yes, thank you.
Can I take you now to section A, page 55 of the bundle?
Sorry, what number is that?
Number 6. Do you have it in front of you, Mrs. Sethi?
Yeah, I'm looking at number 6, page number.
Page number 55.
Yes, we have.
So this is the facility offer letter that was granted to you by Emirates MBD.
Yeah.
Can you confirm that you're familiar with the contents of this document, Mr. Sethi?
Yes, I'm familiar.
And can you confirm that it's your signature at the end of the document?
Yes, I confirm.
Okay. So if we go to the first line of this letter, where it starts, further to our recent discussions, we are pleased to advise that Emirates NBD has agreed to make available the facilities listed in the clause title, facilities below. Can you see that, Mr. Sethi?
Sorry, this is which one page number? Sorry, in the first page, which para?
Yes. Paragraph, the first paragraph under Dear Sir.
Yeah, okay, fine. Yeah, NBD has agreed to make available the facilities listed from the clause. Yes.
That's constituted as an offer to you then, Mr. Sethi, correct?
Yeah, condition with condition precedent.
But again, it's an offer. You agree with that, correct?
Even term sheet also an offer. So it's in a generally. But it is an offer with a precedent condition. Yeah.
Okay, that's fine. So if I can take you to page 64 of the same document, Mr. Sethi.
Yes, please. Give me 1 second. 64.
Yes, of course. Yes.
Yeah.
So Under paragraph headed conditions precedent, can you see that, Mr. Sethi?
Which paragraph?
I think it's number 66. I think my little friend got the page number wrong. It's
66.
Apologies, 66.
Yeah. Yes.
Okay.
Condition precedent.
Yes. So there is somewhere on the document, I apologize for the mix up. I think I've got the page number wrong, but there is a paragraph that refers to utilization of the facilities shall be subject to the bank having received all of the documents and other evidence listed in the conditions precedent. I'm just trying to find that for you, Mr. Sethi. Yes, so my apologies. It's page number 63, paragraph 5.
I have in front of me.
You have it in front of you, paragraph 5. 63, paragraph 5.
63, paragraph 5. 5 is down.
Yeah.
Yes.
5, yes, condition precedent.
Yes. So that starts off by saying utilization of the facilities shall be subject to the bank having received all the documents and other evidence listed in the conditions precedent. So a reasonable businessman, and apologies, Mr. Sethi, for going back to this, but we have to judge it by what a reasonable, astute businessman would do. So a reasonable person who is aware of the circumstances of your, in this instance, the circumstances that you've been placed in, would give these two clauses their literal meaning again, in that a facility has been approved, and to use the facility, which if we use the word utilization, that is the meaning that we give to the word utilization. To use the facility, certain documents had to be provided, wouldn't they?
Yes,
Your Excellency, I just wanted to interject, if I may. The standard of reasonable person is standard that the court has to determine. I don't think the witness should be deciding what a reasonable businessman would do.
I think it's just a simple
asking,
question.
I think she's asking what he personally would think about it.
Essentially, but that could be his position. Yeah.
I think when we discussed this matter and I gave those conditions, I was very clear with them. They have asked certain conditions which should be asked before the credit, but they say they are with me till the drawdown and they will manage it, and they are there with them. That's why you see they have stayed till 15th of June dealing with my case.
I think
This
what
was
I'm
understanding
trying to
with them. Yeah.
What I'm trying to get at, Mr. Sethi, is the word use of the word utilization of the offer of the facility. Apologies.
Yeah.
So doesn't that mean that an offer has been granted, and in order to use the offer, there are certain conditions by you that have to be met?
And there's more condition after that, which they keep adding. It's not only these conditions which they've given us 14 conditions. But anyway, I think I read that when I sign, I've read it, no? But that is what I explained to Mr. Moise, that this is something, conditions are like term sheet to me, and it's not a final offer. But he said we are pleased.
Mrs. Sethi, you think this is an unusual transaction, like for loan acquisition that you have done through your business before?
Yes, for me it's unusual. No, it's unusual for me. I've never signed such term sheet in the past. They're very specific to the loan, which is generally liability letter, NOC, and mortgages. Any code of conduct, any credit will not approve your facility without they check your code of conduct and your conduct with other banks. They're carrying a big risk, this credit team, if they use my offer and if they found I'm not a credit worthy and I have a bad reputation with the banks. It's a big risk for their jobs. From the risk committee.
Am I not right in saying, Mrs. Sethi, that you entered into 3 previous agreements similar to this prior to entering into this one?
They were very similar, but not 100%, but very similar.
But you were aware
we did not get any. But we didn't get a term sheet. We got a term sheet from them, which was non-binding, and they asked, that was a FAB bank they brought, which was never signed and agreed.
Is it correct, Mrs. Sethi, that in your whole career, when you have funded your business by way of a refinance deal, it's always stopped at an indicative term sheet correct?
No. Term sheet, it always go to the final facility offer letter with the mortgage and they call it financing and mortgage contracts.
So you've
Because
just used the
always
term,
my loan
Mr.
has been.
Sethi. You've just used the term facility offer letter. It goes to facility offer letter. Was that not what this was? Am I correct in saying that?
No, I'm saying not this kind of precedent conditions. There's a conditions I told you generally I've dealt always my loan has been on properties and never borrowed money on trade. So my experience was when any bank gives the offer letter, generally some banks ask the personal guarantees, but in my case we have a properties. The personal guarantees I refuse from the day one. I'll not give personal guarantees. Generally they ask security check. We have also agreed no security check because of those are things will come maybe they say that security check will be taken and personal guarantee will be taken in the final offer letter. I'm very clear. Remember that those will come in the contract when the legal contract is drafted. They all generally come with those terms.
Isn't that what happened, Mr. Sethi?
No,
that
this was
happened?
is
Isn't
no.
that what
This was an
happened?
indicate for me. It's a
The
precedent.
final security checks occurred when the facility offer letter was issued.
No, security check means they generally take a guarantee check. In most of the banks in Dubai, take a guarantee check for the properties. So those comes in the final contracts. And this letter was for me like an indicator term sheet. I did tell many times to Mr. Moyes, please. That's why it took 8 days to agree with him. I would have, if I was so happy and lucky to get this loan, I would have signed next morning. If he say, please trust me, we will deal with it. We are there with you. We'll make a drawdown, make sure it happens. I asked him why they asking me ACB now, why they asking me after 15th June, they start asking unique part trading. He asking me many other things which are no relevance. Who will ask any? Sorry. So what's the question? I reply you.
It's okay, no problem.
Yeah.
As I put it to you, Mr. Sethi, that you are aware and you've just confirmed that the final security checks, which the conditions precedent were, happen at the final stage. And I put it to you again that you received an approved facility and that meant that the success fee was payable, wasn't it?
Sorry, you please, ma'am, you're not understanding. Let me interpret better. Security check is not check. I'm talking about the bank needs security check.
A physical check.
And physical check and personal guarantees. This is the normal I've done with Bank of Baroda, Habib Bank, and DIB. I have DDS with them. So they will not give you a facility bank on just on the property tomorrow. They look at also your, they take those comes in the later stage. And Mr. Mo is aware of that. And he said they will take a security check. I said, no problem. When the final letter comes, we'll see. But in my experience, sir, and His Excellency, I never seen any credit committee, risk committee giving a final offer letter or part of the facility letter without doing your credit check and banks conducts. That's very, very important point for me.
So in this transaction, you have not reached the stage where they ask you for the check?
No, it will come in the next stage when they know the total amount and everything.
From that basis, you think it's not final. That's what you're saying.
Yes, one of the no. We have a condition precedent, and one of I think there are other things. Let's say, sir, liability letter from the bank of DIB was not asked. They didn't ask NOC from Nakhil or Imar. They didn't ask service charge. This come part of the NOC. Those are documents required for any bank to give a disburse. They need a liability letter from Dubai Islamic Bank. It's not mentioned anywhere. They come in the next stage. When they do all these checks confirm, then they offer the financial and mortgage contract, legal contract. And that's the thing. This is my experience with other banks. And I've been telling Mr. Moyes all the time this matter. That this is
Thank you. Thank you, Mr.
Thank you, Mr. Sethi. So if I can now refer you, do you want to take a minute, Mr. Sethi?
I'm fine. That's fine. I'll just take a little water. Thank you. I'm fine.
Problem. Can I take you now to section E?
Section,
number 11. Section E.
Section
number 11, page 454.
454, yes.
Yes. So as you can see, Mrs. Sethi, this is an email dated 7th of June. 7th of June.
Yeah, yeah.
I'm sorry, 453. If you go up a minute, 453. An email from Sushi Maka at NBD dated the 7th of June.
Yes.
Can you see that?
Yes, please.
Can you confirm that you've seen this email before, Mr. Sethi?
Yes, I have seen.
Okay, if we turn to paragraph 1 of that email,
Yes.
it refers to a requirement of evidence of satisfactory account conduct and borrowing conduct of you as an individual, doesn't it?
Yes.
So if I read it out to you, it's saying, as per CBRB of Ajay Sethi, there are 3 lenders. It was reported DIB, BOB, and Habib Bank AG Zurich. The satisfactory account conduct
One second.
certificate.
No, 1 second. I'm not. Which the page number? I'm not.
Yeah,
Something
I think we are on the same page, I think.
454.
You said 4.453, I think.
I think there's a page number difference.
454.
Okay.
Go to 454.
Is this the email at 10:50?
Yes.
Okay.
Yes, I see this. CRB. As per CRB, Ajay Sethi, there are 3 lenders.
Okay.
Yes, go on, Ms.
See
Raja.
that? Yes. So basically, so what it's saying is, as per CBRB of Ajay Sethi, there are 3 lenders. It was reported DIB, BOB, and Habib Bank AG Zurich. The satisfactory account conduct certificate from Habib Bank AG Zurich is not provided. Please arrange to provide the same as well. DIB needs to confirm the borrowing conduct of the customer, whether borrowings are satisfactory or not.
Yes, so you want me to answer this?
Yeah, I'm just reading
Okay.
that out to you. So
Right.
that suggests to me, Mrs. Sethi, that a lot of these things they were waiting on you for, weren't they?
It was part of the precedent condition. These 3 items. And then what happened? As I want to repeat, sorry, His Excellency, I'm repeating because no bank, in my experience, will ask such reports after issuing the credit facility letter. They'll ask all beforehand to know your conduct with other banks, and ACV speaks your Bible. However, since me and Moise was working together in the last 2 months, 3 months to finish this during this 90 days period, I arranged a letter from Bank of Baroda. I had a loan from Ajay Sethi name, 15 million. They gave me a good conduct letter and it was presented to the bank. Before this June, not only 8th June, it was done in May, sorry. I've given this letters in May. I have the evidence in bundles is there, the date. Unless Salah can show which date we give the letter. Then Habib Bank and DIB, I approached them during May, in April, but immediately after I saw these conditions. And I was in touch with Mr. Moise day-to-day basis. 3 to 4 times a day we used to talk. I conducted the bank, I wrote them a letter. They gave me a letter confirming my account number and blah, blah. And they said to me, they don't have such after ACB system in Dubai in 2015, they have stopped issuing such good conduct letters. That's as a bank policy. So I explained that to Moise and Sushil of the bank, that bank is not giving, but they say they confirm this on email. And bank confirmed. DIB said we don't issue such new letters, but I said you can see my bank statement. And also Habib Bank also wrote we don't issue such letters. They issued a letter showing my account number, and bank statement shows my status. However, I have been telling you this should be done before the final. Why they asking these questions now? But however, since we were moving toward to get the disbursement drawdown, I provided these 3 documents in May. Also, if you see my letters to the bank, they have been repeatedly asked same document which I submitted in April and May, and I have a proof stamp from the bank because my office was opposite to the bank. I'm in Amal Mashraf Tower and bank was in next to the Creek Tower. So my guy used to go to the bank because we have original forms We couldn't send them by email because Mr. Moise has told me he will only deal with the banks directly. Don't get involved in day-to-day negotiation. Submission of document, your man can do. I had my accountant Vijay. He used to go and submit document to Sushil, get a stamp on the paper. So he got all the documents, and I provided all the documents to the bank, all the 14. But what happened on the 8th of June, when Mr. Moise sent us a letter to Sushil that bring the seller, he came from Moscow to Dubai. I called him based on the.
I think
Sorry.
what we'll do,
Okay, fine. My
we'll do, Mr. Sethi, if you don't mind, we'll get on to that issue.
Sorry. Apologies.
No problem. Can I then refer you to section E, number 13, page 469?
469. Yeah.
Yes. Have you got that in front of you, Mr. Sethi?
Yes.
So it's an email from Sushil Mehta at Emirates MBD dated the 24th of June 2022, dated 2:42 p.m.
Yes.
Can you confirm you've had sight of this email?
Yes.
So this email refers to an AECB report with a nil overdue amount. There's also reference to one overdue account and a litigation report in respect of unique port trading. Can you see that, Mr. Sethi?
Yes.
I put it to you, Mr. Sethi, that the bank was continuously requesting you documents from you that they had previously requested, and there was continuously new information coming to light regarding your credit position, whereby that they had no choice but to continuously chase you for documents. Is that correct?
Not correct. I've been chasing them for my drawdown and my facilities. They've been asking. I have a proof and evidence in the bundles. If Al-Salah can show them, I've been submitted all the many documents which they declined. They say they denied. Then I have to show them the stamp signed paper of the bank officer that please you receive this document. But again, in good faith, we gave them again. But this document which is showing me now is the first time on the 8th of June when the seller came from Moscow to sign the transfer, because of Mr. Moise had confirmed to the bank, we are ready for drawdown, call the seller. He was dealing with the bank, not me. Please, Sushil Makar he knows that he was told, I will deal with the bank and you just submission can be done by us, the documents original. He was dealing with them. Then he got this seller came to Dubai and he went to the trustee's office. Sorry, let me explain, madam.
Okay.
Next morning, let me explain, please. I want to explain this point.
Okay.
Next morning, I got a mail. Even Moise got shocked when he see the mail. 10 more points out of 10. There 3 or 4 were the old point which we have already submitted, and I have evidence. And then they asked unique part trading, ACB, which is totally new thing. We never ever discussed for Channel 2 AC. I have other partners. I own 39%, but I am the manager in the company. I had given a personal property security for unique part trading. So we had one litigation in 2019, which was settled in 2019 20 September with Bank of Baroda. We don't have any case there. ACB was clear. There was no case on that. Case was closed and finished because it was all under full security. There was no loan on a balance sheet.
Mrs. Sethi, your lawyer can do the rest of the justification. We have to finish this hearing before 5 because I have another commitment actually, and Mr. Razak is running out of time.
Yes.
If you try to give her question, answers.
Yes.
Short
Okay,
answer.
I'll do the short answer. So what happened on the 8th of morning when they got the mail, Mr. Moi's strategy changed towards the loan. He sent me a termination. He knew that loan is not going to get approved because looks like there's a problem. He changed his strategy on 15th of August. June. He sent the letter for termination to, and I went to the bank to Mr. Sushil to meet him.
I think, Mrs. Sethi, with all due respect, we're going to get onto that point. But if you let me continue with what I'm asking
So
you.
I responded you already on the unique part trading. It was something very new. It was not part of our even precedent condition.
Mr. Razak, he wants to give you the full story without your asking.
Thank you, sir. I'm sorry.
Go
This is
ahead.
how, you know,
No,
something
no,
in the
it's
flow
fine,
you
Mr.
speak, yeah.
Sethi. If you let me
Because it's come from the
continue, and
heart.
we'll get on to the point. Yes. So
I think you're
What-
not used to cross-examination, Mr. Sethi. Yeah.
No, I not that. No, it's maybe the first time.
The first time, yeah, okay.
Okay, Mr. Sethi. So this email that we have in front of us, it would suggest to me that there was new things coming out. So it appears that the bank have reviewed this AECB report. They've reviewed the documents, and now they're asking you for details of the case. So they're asking you for further information that's coming to light. So it's new information. Is that correct?
Of course, when they asked me ACB, I provided the ACB. So they must, I would have replied. When they asked 24th, I was ready. I met them. In fact, I met to see.
But then what I'm saying to you, Mr. Sethi, is correct,
Yes.
isn't it? The bank was continuously requesting documents from you that they weren't aware of because new information was coming to light. That's correct, isn't it?
But why would they ask me unique part trading on 8th of June?
No,
Why
no,
not
no. The
31st
question, no,
March?
no, no. No, the question is they keep asking you because there are a new information comes to the bank. New information pop up. So that's why they keep asking you new things. That's the question. Is that right or no?
I think they
Oh.
asked me the new thing, yes, but same time, you know, when anybody in the UAE law, sir, sorry, in the His Excellency, when you take a my Emirates ID, every information on given immediately from the day one of my companies, my everything, it doesn't come in
That's
the
not the
surprise in the
question,
3
Mr.
months.
Sethi. The question is basically when you're providing this information,
Yes.
when they're reviewing that, there's new information coming to light. And because you failed to provide material information, and forgive me for saying this, Mrs. Sethi, due to lack of transparency with the claimant, this is the situation that's arising, isn't it?
No, because he was aware of unique part trading issue with the, there was no issue. It was closed in 2020, September. But he was aware, Mr. Boyce, and they were aware of unique part trading was nowhere in the picture during before the 31st of March and not in the precedent conditions. But if something
all
new
due
come,
respect, Mr.
even something
Sethi,
new come, we were ready to comply and reply. There was no issue for me. And I did. Yes, I
think
did,
we're
and I
going
went to
to
see the
have to.
bank. Yeah,
I
I
think
went to
we're going
see
to have
him.
to agree to disagree on this point as well, Mr. Sethi.
If that's your call.
Mr. Razak, I would remind you also the email of your client who said he have complied with the 49 requirement of the bank as well.
Yes, Your Excellency.
You remember that?
Yes.
Yes,
Go
I
on.
do. I do. Can I now refer you, Mrs. Sethi, to section A,
Yeah.
number 8181.
It can't be 181. It starts from 426.
Apologies for this.
Yeah, she always got different system.
Sorry, my apologies.
Sorry, is it number 8 again? Let me just double
It's
check.
number 8. Yes, I've got the right one. It's the letter of
Sorry, yeah.
termination.
Okay, sorry. This is
My learned friend was wrong in this instance.
I'm guilty
Yeah,
as charged. I'm guilty as charged.
Okay, good. Fair enough.
Okay.
Section?
I think section 8, section A, page 181, Mr. Sethi.
181.
Yes.
Mr. Razak, do you think you can finish within next 15 minutes?
I don't think I will be able to, Your Excellency. Do you think that this will carry on into the morning?
Well, I don't want to carry like 15 to 20 minutes to the next morning and give you full day business, but because let me text I got another hearing actually. I'll see if they can starts 5 o'clock. I will email them to give. I will email. I'm texting them to give us another 15 minutes. Would that be fine?
I
I'm
will
expecting you to finish. I'm going to give you 25 minutes from now. Okay.
Thank you, Your Excellency. I will do the best that I can in that time.
Appreciate it. Thank you.
Thank you. Mrs. Sethi.
Yeah.
This is a letter of termination from Fursa dated the 15th of June. Can you confirm that you've had prior sight of this document?
I have.
You have. So at the beginning of the second paragraph, Mrs. Sethi, have you gone to the beginning of the second paragraph?
Further, there are several instructions from your part with the constitution. I have read it, I remembered now, but I don't agree with it.
You don't agree with it?
I don't agree with, because this is something he was aware of
All I'm
everything.
going to ask you, and I'm aware that His Excellency has given me 25 minutes to conclude this, Mr. Sethi, but I'm going to put it to you that this just reinforces my previous point, you know, that the bank was coming into new information from the document that you'd already submitted, and it became virtually impossible for the claimant to salvage this for you, correct?
My simple answer to this, I've never seen any bank, not in UAE, not in the world, a credit committee, a risk committee approves a loan without going through all this in the first tense, not after giving a facility offer. That is something very strange and very unusual practice in banking.
This letter from the client, not from the bank, yeah, Mr. Razak? From the claimant.
That's from the claimant, Your Excellency.
Yeah, I see.
I'm not going to take you again back to the letter of engagement because I recall taking you to that clause earlier on. It was the validity and reliance clause, Mr. Sethi. Would you want me to take you to it?
I think engagement matter is all legal. I think that Salah has dealt with it already. And let's go to the point which is more relevant for you.
I'm not going to skip my points with all due respect, Mr. Sethi. So if we go to page 44.
You didn't like that at all.
Can we go to paragraph 4, please?
Mrs. Sethi, she's in control now. You're her witness now.
I'm fine. I'm in front of the justice, and I'll meet the justice.
Unless you feel interrogated, then you need to be subject to her question.
I have no problem, so I will reply everything possible. And I good thing I remember everything. I don't.
Thank you, Mr. Sethi. Thank you. So if we go to paragraph 4, it reiterates again that you had to provide all financial. Paragraph 4, page 44.
Page 44. Go back.
Section A, page
Section
44.
A, go. Section A, 44, quickly.
Sorry, what number is that?
Sorry, it's number 6.
The agreement.
44, number 6, go number 6. 6, number 6. No, 44 44 page.
Page 44, paragraph 4.
Yes, information validity reliance, yeah.
Yes, so what this clause is effectively saying, Mr. Sethi, is that you are to provide your advisor with all financial and other information requested for the purpose of the transaction. The advisor shall be entitled to rely upon and assume without independent verification the accuracy and completeness of all of the information that's publicly available. But I put it to you, Mrs. Sethi, that you weren't transparent and this information wasn't provided to the claimants readily and it wasn't made available to them readily, correct?
Not correct. If somebody is working with you 3 years, he knows exactly what client has his issues. And he cannot just come in the last minute if it's last letter, but I don't agree with you. Next. And why would I hide from doctor my problem? I've never done this.
Next, Mr. Razak.
Okay, so section A, 103, page 103, number 6.
Number 6, 103. 103, number 6, yeah?
Yeah.
Termination.
Termination.
Yes.
Same contract termination.
If I can take you to paragraph 6.
Which page is that? Sorry.
46.
Page 46. Let's go to 46.
No, apologies. It's section A, number 6, page 103. 103. Yes.
Page 103 straight.
Do you have that in front of you, Mrs. Sethi?
Yeah, just to, we're getting it. 1 second, please.
Yeah.
103, go for it.
Your Excellency, given that I've got 20 minutes now, would it be feasible for us to carry on for an hour in the morning?
Show me this.
An hour.
Yes, Your Excellency, if that's okay with you. I won't need the full hour. It just saves us from rushing this now.
22nd July 2022, the letter.
That's right.
Well, I think you carry on now until 5:10. I will see what we
Okay,
can do.
thank you, Your Excellency.
This letter, channel 2 letter 22nd of July.
That's right. So
Yeah.
if you go to paragraph 6 of this letter, Mrs. Sethi, can you just read that for me?
1 second. We have submitted all the documents to the bank till 13th May 22. Bank had requested 2 documents which we had provided to Fursa, who mentioned everything is done. There was no communication between 13 May to 6 June. Fursa mentioned that they manage everything and bank is ready to disburse as there is no pending queries. So Fursa had sent the mail dated 6 June 2022. Fine quoted here below.
Yes, thank you, Mrs. Sethi. But if we go beyond the scope of the email from Mr. Moez Khan, it's saying based on this mail, we'd informed the seller who came down for issuing the NOC. And basically, the seller was infuriated by the delay in disbursement or in wrong communication. But if we refer to that email of Mr. Moez Khan, it's correct, isn't it, Mr. Sethi, that he has not once said that drawdown will be on the 8th of June 2022. It's correct to say, Mr. Sethi, that it wasn't the fault of the claimants that your sale transaction didn't go ahead, but the fact that you failed to provide pertinent information to the bank. That's correct, isn't it?
No, I have written in the letter that because Mr. Moez was dealing with the bank, not me. I was been told by Moez, let me one person deal with the bank. He knows Faranaz and Sushil. He's dealing with the bank and only we will submit. We were not dealing directly with the bank, but we are not getting any communication from Fursa for last three weeks. I was chasing him. He said, call the seller. We are ready. I called the seller on.
Isn't that contradictory, Mr. Sethi? Because I've seen numerous emails from yourself to the bank.
Please explain
one that you just referred to yourself.
What is the contradictory? Just please explain me. That I didn't, the 2 documents, because we said we have already submitted this document. They're asking again, same document. We have the proof stamp of the bank receiving the documents. And we have complied everything.
I'm correct, Mr.
Because the Moez was dealing with the bank, not me. I went to bank once or twice in 3 months.
I'm correct, Mr. Sethi, in saying that you chose to deflect the blame from yourself onto the claim yet again, didn't you?
But why would he call my seller? I based on his email as my advisor. I called the seller based on his mail because he was dealing with the bank. We were only a messenger.
Dealt with that issue, haven't we, Mr. Sethi, that you couldn't rely upon that email because it doesn't confirm that drawdown would definitely occur on the 8th of June.
No, until the 8th of June myself. Why would I call a seller? I'm a businessman. Other guy's also a businessman. I call him to Dubai to make a fool of myself in front of him. If I was not believe Mr. Moez, but I feel Moez had lack of communication with the bank. And he was dealing with the bank himself. He told my team and us don't deal with the bank, only make submission and get stamps because we want to keep a one-party communication. Why would I take an action on his email and call the seller? Please tell me. I will not do that.
But if you were getting so frustrated with Mr. Khan, just seems very contradictory given the fact that you signed a subsequent engagement letter, Mr. Sethi, on the 28th of April 2022.
I got only frustrated with him when the seller came to Dubai. Before that, there was no frustration. We were working. He was working for me as an advisor till the last 15th of June. Why would he work 2.5 months later on my same facility when he is not part of? It's not a good faith. It was he knew that he wanted to draw down and take his money. But when he know on the 15th or the 8th of June, when he saw the new list of 10 items, unique part trading, all this, he saw, my God, this loan is not happening. Let me grab my 900,000, 2% and focus on that and terminate it. And interestingly, the bank managers are very important for His Excellency to know. I tried to contact the same lady Farhanaz and Sushil Makar of bank senior officers who was introduced Moise to me. Moise took me to the bank first time. They refused to take my calls and meetings. I have 6 emails, please. I'm a client. I'm giving you 46 million business. I want to meet you. They did not respond. They till today did not activate my account. And I had 6 months.
It appears to me, Mr. Sethi, that this transaction was all over the place, because one minute you're saying that you had no correspondence with the bank. Now you've just admitted to me that you were emailing the bank. You didn't know what was happening, did you, Mr. Sethi?
Let me clarify again. I start dealing with the bank when he resigned. He terminated my contract. I went to the bank straight away. I met the manager and his body language was very clear. He told me that, oh, what happened? Fursa terminated your contract. Okay, yes, because, you know, he called my seller from Moscow and without giving a confirmation that, and we took a NOC, we paid the service charges. We took the NOC for the property. And this guy, Moise, has put me in a big trouble. And then now he disappeared. He wanted his 900,000. I told this manager he wanted his 2%. And maybe if it's mandate from you, I don't know. I want to continue with the bank and I have 6 months. He did not after that give me, after that, he was not giving appointment. I have mails, the bundle. If you have a time, I can show this communication. Why bank manager will not
you dealt with the bank after the termination?
Yes, I went to the bank myself because I need to get it done. But bank did not entertain me. I have a proof, six emails. And they say, what happened?
Go on,
Sorry.
Yes.
Razak, next question.
Yes, so can I now direct you, Mr. Sethi, to section A, number 6, page 73.
Page 73. Sorry, sir, my little bit, His Excellency. I get a little excited, but that's normal. That's how I'm sorry for this.
No.
But I'm responding, you know, when you're responding, sometimes you, it's some different characters like that.
No, but if you see, as Ms. Razak wanted break and she wanted to have you for more time.
I don't mind.
Look at your list. I mean, what is your evaluation of the remaining question, Ms. Razak? I mean, for now.
I think it's to do, Your Excellency, just with in relation to the payment of the invoice and termination of the contract.
Okay, you can do 3-4 questions. Go on.
Thank you, Your Excellency. So, can you confirm, Mr. Sethi, that you've had sight of this document, which is the invoice?
Yes, 7th May.
Yes, so the invoice was sent to you, wasn't it? That's correct.
Yes.
It's also received by you. That's correct too, isn't
By
it?
email, it comes by email. This email in my email is received. But why this invoice not come on the 1st of April?
The 1st of April.
Yes, that's why they're saying that this was the facility was done and I should be paid them on the 1st of April.
But I think
Why 2 months?
I think if we refer to the clause, Mr. Sethi, it's either upon drawdown or within 30 days of signing off of the facility letter. That's correct.
30 days or
the drawdown. Drawdown didn't occur.
That's
correct, isn't it?
Fine, yeah. But I got on the 7th of May.
Yeah, you accept, don't you, that the 30 days expired on the 30th of April.
We received on 7th May. And Mr. Moise worked with me till the 8th of June or 9th June. After that, he quit.
So I don't have anything further, just a final point on the invoice. So to date, it's correct, isn't it, Mr. Sethi, that this invoice hasn't been paid and is still outstanding?
Yeah, because it's not due. It was no success fee was given. My facility was not, drawdown was not done. It was not, a transaction was not successful. And this, a facility letter was vague. It's not the final facility letter. And I've given you all my background and proofs.
Thank you, Mr. Sethi. Your Excellency, I now intend to move on to termination, but this will take a little longer. So I'll be guided by you as to what you suggest.
You still got 15 minutes, isn't it?
Thank
you. Can
you.
Utilize it.
Can we go to section A, please, Mr. Sethi? Number 6, page 96.
Section A, page
96.
directly. 1 second, I'll be there. 96, yeah, 90.
It's the email from Mr. Khan to Sushil Makar.
Yeah. Yeah.
Is
So,
that
Mr.
correct?
Sethi, yes, that's right. Correct. Have you got it in front of you, Mr. Sethi?
Yes, yes, I have.
It's your assertion, isn't it? It's your
Mhm.
assertion, isn't it, Mr. Sethi, that if the contract had terminated by the claimant on 15th of June, why the claimant was still corresponding with the bank? That's correct, isn't it?
Sorry, no. But 8th of June, when the seller came, please, problem started when the seller came. And Mr. Moyes met me 3 times. He started threatening me. I want my money, otherwise I will move. I will not help you. You'll see what the bank will do. You try and get the loan from the bank directly. Then I overreacted and started because I'm a client in the end. If I get the drawdown, I would have paid him. I continued talking to the bank. I have to take a decision to go directly and find out the truth because he lied to me that there is a drawdown ready and called the seller. So I lost my trust on the 7th of June. That's why I had the right to go to the bank as a client and businessman. I don't have
agree
to wait
with
for
that, Mr.
no, I don't
Sethi.
have
I'm
to
not
wait for
disputing
15th
that.
of Madam. I don't have to wait for 15th of June when I have a SOS problem in ICU. When guy is sitting here and shouting at us why he called him and his lawyer threatening me to sue me for this and I lose 20
If
million
you
in
let me
profit.
finish, Mr. Sethi, and
Yes,
then we can
yes,
move
yes,
on. Is that okay?
yes, yes, madam, yes.
So it's further asserted by you, isn't it, Mr. Sethi, that the reason for this was because the claimant believed, and you've just said it previously, the claimant was still getting involved even prior to the 15th of June because you believe that he wanted to facilitate the success fee to meet the conditions of the facility offer. That's right, isn't it? That's your perception. That's correct.
Because our problem started with Mr. Moyes. He sent me the mail, the drawdown is ready, disbursement is ready. And I called the seller in Dubai. We had a huge embarrassment and there is maybe a case against us. They will file. I had to intervene with
Mr.
the
Sethi, I don't think you're answering my question.
But he met me till the 15th. Even Adnan had come by time. They met me in the Shakespeare Cafe.
Yeah, but why he kept meeting you and assessing you? Why is that? Why he did that?
Because he said we will try and close this matter. Because I said you've done this, when how we can resolve this matter? He said, let me talk to
Mr. Sethi, your assertion is that he did it because he wanted to facilitate the success fee and meet the conditions of the facility offer letter. But I put it to you that Mr. Khan did this out of good faith and out of the goodness of his heart because of the previous working relationship he had with you, correct?
No, he asked me, pay me 200,000. And on the 9th of, he met me in the Shakespeare Cafe on 9th or 10th June. He said, forget 9, pay me half, pay me 300, pay me 200. I say, I cannot pay anything. But he kept meeting me till the last termination notice came.
So, Mrs. Sethi, so Mr. Khan was helping you to close the deal, or he has already closed the deal and he's going extra mile with you as just customer?
No, after 15th, he stopped.
No, but why he was doing, no, after 8, he tried to help you to close the deal, or the deal is closed by the signing of the first documents and he's only helping you?
No, he was trying to
as a good faith.
He's trying to be, he knew that he has to finish till the end. Why would he wait for all this June and do all the work and get letter from seller to invite him, all that, if he was not involved? He was involved.
Clear answer.
Thank you. So if I now refer you, Mrs. Sethi, to section A, page 43 again, which is the engagement letter.
Section 43?
Section A, page 43.
What number is that?
It's number 6.
43.
If I can take you to paragraph 6, which is page 46.
46.
Yes.
Always roll like that.
Yeah, we were here 5 minutes ago, Mr. Razak.
I'm sorry, it's whole day, sir, for you. Whole day you've been a long hearing.
No, the problem is I'm having another hearing, that's why.
Page 46, yeah.
46.
Yes, 46.
Termination or a public announcement?
No, termination. Paragraph
Okay.
6. Yes, so you've relied on the first 3 lines of this clause, haven't you, Mr. Sethi?
Yes, I'm reading it in front of me.
Can you tell me in your words what your interpretation of that clause is?
It's a bit more technical to me, but anyway, I think it's about
So what
cure
is,
and.
would you
it's
like me to
talking about
help you, Mr. Sethi?
So I want if Salah can help me in this.
No,
It's
no.
talking
This
about-
is
No,
Razak.
sorry,
No, he can't.
I'm sorry.
Not today. Not today.
Sorry, I'm sorry. Let me see this. It's talking about the cure and remedies and those kind of thing after the notice.
What I'm trying to get at, Mrs. Sethi, is that it's saying basically that unless both parties agreed to renew the agreement, the agreement would automatically terminate upon the occurrence of the following events. So I think in this instance, what we're saying is that it's the claimant's case that the financial close of the transaction, because what they're saying is that this is done, it's completed. What you're saying is it's not completed. It won't be completed until drawdown. But then, is it not correct that you're contradicting yourself, Mr. Sethi? Because then you're saying that the engagement letter terminated on the 7th of April 2002 in any event. That's correct, isn't it?
7th of April. We're talking about termination. Termination happened, as you mentioned, the termination was happened in case there is facility drawdown didn't happen. In my view, the credit facility was not completed to me. And 6 months I had and bank closed my deal in 90 days, in the last day, 11 o'clock.
But
didn't
that's
wait for
your
1 day.
assertion, isn't it, in your evidence, Mr. Sethi, that the agreement terminated in any event on the 7th of April. But it just appears to be very contradictory to me that you would expect.
Then why you continue working with me till 15th of June?
Well, that's what I'm asking you, Mr. Sethi, and you expected the transaction to go on until the drawdown. That's correct, isn't it?
That was the whole idea for having this facility. I get this. I've told you again in a condition precedent. This was not a final facility offer letter. I explained several times.
I don't think the question is being answered, Mr. Sethi. What I'm saying is that you're contradicting yourself. First, you're saying
contradicting in what manner?
Can you let me finish, Mr. Sethi?
Yeah.
Yes, I will. First of all, you're saying that, you know, the claimant was involved and should have been involved upon drawdown. Then it's alleged in your evidence yourself that the contract terminated on the 7th of April. Isn't that contradictory in itself?
No,
That's correct, isn't it?
I said invoice not issued on the 1st of April, not the contract terminated. I never said this. I said invoice should have been issued on 1st of.
If I'm mistaken, I think you have said that,
April.
Mrs. Sethi. I put
No,
it to you that you have said that in
because
your
my
evidence.
first termination happened in 15th June. There has been no termination in the past.
It's in your
I
witness
didn't
statement,
contradict.
Mrs.
I did not
Sethi,
contradict this.
It's recorded. It's recorded. Don't quarrel with the witness, Ms. Razak.
Okay.
I did not
That's
say this
fine.
that the contract terminated in the 7th.
That's fine, not a problem, Mr.
No.
Sethi. So if we go on to the last paragraph, it's just, I wanted to alert your attention to that. So if we read that, it says, upon termination of advisor's services under this letter of engagement. So the letter of engagement shall have no further force or effect except that
Can you
number one.
just refer to me that other where I'm contradicting so I can remember? Because I may be not remembering.
I will do.
said-
If you let me finish the point, Mr. Sethi, and then I
Okay.
will go back to that point if that's okay.
Yes.
So it's saying in the last paragraph, if you look at the last paragraph, in subsection 6.
Upon termination
of advisors' services under this letter of engagement, this letter of engagement shall have no further force or effect except that any fees that are to be paid to the advisor in accordance with the terms of the LOM.
Yes.
That's correct, isn't it?
No, I mean this one was, see, 1 minute. One was the I want to know where I'm contradicting first. Please, I don't want to reply wrong. I want to know where I'm contradicting. It is in the statement of facts, because did I write something in my statement and which I'm contradicting? Please, I just want to be, I want to write question right.
Yeah, you're asking him for legal opinion, Ms. Razak.
Apologies. I will move on. What I'm actually saying to you is that it's your assertion that the contract terminated on the 7th of April. But what this clause is effectively saying, Mr. Sethi, is that it hadn't terminated and the claimant was perfectly entitled to carry on this agreement just for the purposes of payment, which they're saying is still outstanding. That's correct, isn't it?
No, first of all, did you say the contract terminated the 7th of April, Ms. Sethi? Have you said that?
I need to, I have to go. Can you refer to which clause, please, in the statement of facts? Maybe I will not remember whole defense, but can I look at that? Can you refer to me that where I said this? Then maybe
yes,
I will recall.
I'm just trying to look for it. Just bear with me. I think it was referred to in one of your witness statements. Just bear with me.
Just give me the clause number. Then I will remember, I have a more, I can get a clear picture. I don't say wrong, something which is, I'm not 100% sure.
I'll refer you to the relevant section. Just bear with me.
If it's taking too long time, I mean, you may skip this and then you just take the
Yes,
next
I'll come back to it. And yes,
you have
if that's okay.
3 minutes to go, so that
Yes,
when you
if
have 3
that's okay.
questions.
But I can vaguely remember that His Excellency, that once on 30th first drawdown was not done, the contract was, the financial close was not closed. So it is, look at, it's automatically terminated if you're not able to draw down the money. The financial close was not done. That
Yeah,
was
so
something I remember.
The question,
Mr.
Mr.
Sethi,
Razak, yeah.
I found the relevant section. So
Yes,
if you go to section E,
Yeah.
number 6, page 419.
419.
Yeah, paragraph 33. It's in your witness statement dated the 17th of February 2022.
Which page is that?
419.
419. Yeah. Which clause?
Paragraph 33.
Based on my understanding, the agreement could be argued that the agreement ultimately terminated on the period. This is because of the clause 6 of the agreement stated there. Yeah, because as he said that since the financial closure didn't happen, and that is when we make the statement. I remember we said the final closure didn't happen, so it'll get automatically the contract got terminated in legal way.
I think moving on, due to the lack of time, what my point here is, Mr. Sethi, is that it's a clear contradiction, and I've just pointed you out to the section where it says that for the terms of payment, the contract is still very much considered as live, and it would appear, therefore, that you're still contractually liable to pay the amount of 966,000 AED.
That's for another time, Mr. Razak. Now
Okay.
the question, you got 2 minutes, 1 minute actually, not 2. You got to have last question.
Okay. Okay, turning now to the point of termination of the facility offer by Emirates MBD, can I refer you to section A, Mrs. Sethi, page 95, which is the bank's termination letter.
Section 5. Sorry, section.
Section
sorry.
A. Section A. Number 6, page 95.
Yeah, I have it here.
Okay.
And the last question is?
Yes, the bank clearly sets out in this letter at the second paragraph, Mr. Sethi, that as per their offer terms, the bank should have received all the requirements that's set out in Schedule 1 of the conditions precedent. So if we go to page 55 of section A, which is the facility offer letter, Mr. Sethi, can you go to that for me, please?
Yeah.
And if you go on to the next page, please, for me, 56.
56 page, yeah.
Yep. So if we go to the clause 3.16.
Yeah.
Availability period. Can you see that, Mr. Sethi?
Yes, subject to a clause titled availability, amendments
Yes.
and the termination of the general terms 90 days from the date of acceptance to the facility letter.
Yes. So the bank cancelled the facility 92 days after the facility letter was signed. That's correct, isn't it?
No, it was also 180 days. They are contradicted. There was 180 days in the page. You can go, I'll show you the page. Salah, we can show go down page here.
I put it to you, Mr. Sethi, that's incorrect. It was cancelled on the 30th of June, 2022.
Yes, they cancelled this terminate, but they had up to 180 days, 6 months for the combined facility.
That's the combined facility. But what I'm saying to you, that's correct, isn't it, Mr. Sethi? Yes or no?
Yes, but they wrongly terminated or cancelled because this conditions was not separate to separate loan. This conditions was precedent condition was all combined. They never said this condition for this loan, this condition for this loan. So they wrongly terminated my facility. I would have provided all. I would have provided all the documents.
Your understanding was it is combined and you will use the longest period. Isn't it?
And
it's
would have continued
90.
complying I would have continued complying all the requirements they wanted. Even they were, since
So
they had more conditions, I would have continued providing them.
So, Mr. Sethi, you're saying that you are of the understanding that it was valid for 6 months. Is that correct?
Yes.
Okay, can I now turn you to section E, number 6, paragraph 417, page 417.
Page 417, para 417 here.
Yeah, so that's paragraph 22.
So, paragraph 20.
22 of your witness statement, dated the 17th of February.
Yeah, yes.
So that's correct, isn't it? In paragraph 22, you say in your witness statement that the facility offer letter was only valid for 30 days. Please. That's correct, isn't it, Mr. Sethi? So we've had 3 interpretations of this.
I think please let me clarify. You're misinterpreting it. It was valid 30 days for me to sign. I signed on the 30th March from 22nd was issued. It was valid till 22nd of April. It was 30 days, not for the facility, 30 days for offer letter to sign for me to sign.
I think that's just clearly contradicted what we've just discussed, Mr. Sethi.
No, not contradicted. It is part of the contract of it's part of the offer letter. Which mentioned 30 days I must sign to yes or no.
I think that's another point. I think that's another point where we'll agree to disagree. So in reality, you agree, don't you, Mr. Sethi, that you had plenty of time to meet the conditions precedent and it was a result of your delay and you failing to disclose everything to the bank as in a timely manner that led to this. That's correct, isn't it?
Repeat again, please. I was not.
So, what I'm saying to you, Mrs. Sethi, is in reality, you had plenty of time to meet the conditions precedent, didn't you? From what I've just shown you. And I put it to you, Mr. Sethi, that it was due to the lack of diligence on your part that resulted in you being unable to meet the conditions precedent within the 3-month period and with your own admission, the 6-month period, which consequently resulted in termination by Fursa and Emirates NBD. That's correct, isn't it?
No, don't agree with you. all the condition precedent we had submitted, we have fulfilled. They added new conditions, which are never ending. They can add another, after I do this, they would add another 10. Maybe I'd never get the loan. So I do not agree with you.
Thank you, Sethi. Thank you, Mr.
Mr.
Razak.
I
Sethi.
just
No
have,
further
uh,
questions.
Conclude.
There
I'll
is
revert
absolutely
to
Your
no
Honor, I
Mr.
just have
Mato.
less than 1 minute of rebuttal. Just less than 1 minute of rebuttal.
Okay.
On the same, can I take you to the same facility letter? Can you go to clause number 8, please? Page number 435. Mr. Sethi,
Yeah.
can you go to
435.
section E, number 8, 435.
435. Page 435.
Number 8, section E, number 8, 435.
435, yes. Section.
This is the facility letter.
Yeah. I'm looking at which clause, which page?
Clause number 8. Clause number 8, it says validity and availability. Let me read this to you.
Yeah. The letter
This
of
letter,
validity,
i.e. the
yes.
facility letter, is valid for 30 days from the date hereof and shall
Yes.
expire immediately upon the lapse of such period, provided to the bank. So is it in your understanding the issue of 30 days comes from this point of the facility letter?
No. This 30 days for true validity of the, I have to sign it.
Yes.
Within 30 days. If I don't
Yes.
sign it, it is null and void.
Okay.
It's not then they give 1 month, 90 days and 180 days in the main letter.
Can I
And they keep,
can I take you to number 12, please, quickly?
yes,
And same
please.
section E, number 12,
Yeah,
page 462.
462.
Can you confirm to His Excellency, to the court, that the issue of unique parts trading was never part of the conditions precedent in the facility letter? Isn't that right?
Yes, it's right. It was never ever discussed, never ever brought in any way. And I've told again and again, everything is generally done before the risk and credit committee approve any loan. Nothing can be done after that of all this conduct and everything. I don't
Your
repeat.
Excellency, I have no further questions. Thank you very much for your assistance today, and thank you very much for your patience and for your understanding.
Yes, Your
Thank you,
Excellency.
Mr.
Thank you very
Razak.
much.
Thank you, Mr.
Thank
And
you,
it's always a learning
Razak.
experience to be
No,
with
I
an experienced
thank her
judge. So
before
thank you.
she asked me for another rebuttal.
Thank you.
One
Thank you
last
so much.
point of
First of
housekeeping.
all, we thank you, Sethi, for your time,
Thank
for
you,
your
Mr. Sethi.
patience with Ms. Razak.
Thank you, Mr. Sethi.
No, she's doing a
One
job,
point of
doing job.
housekeeping, Your Excellency, regarding the post-closing, now that the trial has come to an end, would you be giving us directions as to when you would require post-closing submissions from us?
Yeah, well, I'm not in a hurry. You tell me how much time you want to prepare,
Okay.
and I'm not expecting any lengthy. I'm thinking maximum of 15 pages each.
15 pages. Yeah.
Simultaneous delivery.
Exchange. Yeah. Would you want
And
our perhaps the submissions on
You
costs
need
could be
30
after
days.
the order?
You need 30 days.
30 days should be more than generous, Your Excellency.
Yes, thank you, Your Excellency. So can we agree a date, Your Excellency?
So should we have it have the exchange and deliver you the post-closing by 23rd of June, Your Excellency?
23rd of June.
Just before the Eid holidays.
Yeah, that's a Friday.
Yes.
Friday usually would be day off, maybe. So
Maybe 21st June on Wednesday.
Yeah, that's the best.
Perfect. So 21st June,
Yeah,
Wednesday.
and I have free calendar that day as well. So
Okay. Your Excellency, in the meantime, I want to basically thank you for the conduct today, and on behalf of my learned friend, I want to basically again extend our gratitude for your patience and for your indulgence. And,
oh, not at all.
Excellent.
This is our work. I mean, we will deal with cost toward the end, isn't it? I mean,
towards the end, yes, that's our
maybe
understanding as well.
after the delivery of the judgment, I will invite you for short submission for
Okay.
cost.
Yes,
Thank
that's
you,
fine,
ma'am.
Your Excellency. Thank you very much for your time today.
Thank you very
Thank
much.
you
for
very
your
much.
presence. Thank
All
you.
the
Thank
best.
you.